The Lord is my shepherd, I shall not want. He makes me lie down in green pastures. He leads me beside quiet waters. He restores my soul. He guides me in the paths of righteousness for the sake of His name. Even though I walk through the valley of the shadow of death, I will fear no evil, for You are with me. Your rod and Your staff, they comfort me. You prepare a table before me in the presence of my enemies. You anoint my head with oil, my cup overflows. Surely goodness and mercy will follow me all the days of my life, and I will dwell in the house of the Lord forever. The Lord is my shepherd. The Lord is my shepherd, I don't want for more. He lays me in green fields by the still shore. He brings my soul home when my path runs dry. He leads me, even if I lose my way. He knows my name. Even if the dark gets close, He stays the same. The Lord is my shepherd, I will not fear. He walks right beside me. He keeps me here. The Lord is my shepherd, my cup runs over. My cup runs over. Mercy in every step, grace on my shoulders. He leads me straight on the right road, line for His own good name. He makes it shine when I walk through the valley of death's deep shade. I won't break down, I won't be afraid. You're with me, You're with me. Your rod, Your staff, they steady my heart. When the night feels long, You light the dark. The Lord is my shepherd, I will not fear. He walks right beside me. He keeps me here. The Lord is my shepherd, my cup runs over. My cup runs over. Mercy in every step, grace on my shoulders. You set a table right in front of my foes. You anoint my head and You overflow. Goodness and mercy will follow me home all the days I breathe. I'm never alone, never beside me. He keeps me here. The Lord is my shepherd, my cup runs over. My cup runs over. Mercy in every step, grace on my shoulders.
Grace and peace, everybody. We back up in this building. We back up in here. Hopefully, you all had a wonderful last night. And hold on. All right. Hopefully, you had a wonderful night last night. We got another day of Tyler Robinson preliminary trial. Andrea is already on. She's already given the lay of the land. I'm going to pray. We're going to jump over to Andrea, see what she's got going on. The trial is going to be starting. They already got their cameras on, and it'll be starting in about 15 minutes. So, God, I thank you today that we have an opportunity to gather. I thank you for everybody who's in the best live chat on the internet, in the most electrifying comment section. I pray that we'll get better understanding of what's going on with the Tyler Robinson case. We pray for justice for Charlie Kirk and Erica Kirk. We thank you, God, that you've protected Erica and her in-laws. I pray that you'll continue to do so. And I pray that, God, Tyler Robinson will just confess and that this will be over quickly. In Jesus' name, we thank you and pray. Amen. Everybody, we're going to get ready to pop on. Let's bring Andrea up in here. Shout out to Andrea Burkhart. I will drop the link to her channel in the description as well.
I haven't heard that before. Was the holster the holster that they found for
yeah, I don't know what that holster was about.
They described it as a concealed carry holster for a pistol that they just found like lying on the grass in the upper part of the amphitheater where the shooting took place. Not near where they arrested George Zinn, not near where they are, claiming Tyler was on the roof of the Losi Center, somewhere just totally different. And we don't have a lot of information about it.
I don't think there's anything going to happen about that, truthfully.
So did that get taken into evidence and stuff? Don't know, but I, for one, was not aware that UVU was an open carry campus. Doesn't shock me to learn that, but I just I didn't know that, and so given that, it would not surprise me if there are other firearms present during the event. But for the most part, I would have to say my takeaway of day one is kind of a slow start. It's kind of a slow start. This is going to be a little bit of a different pace, I think, than
I agree.
We may want or even be accustomed to. And I was thinking about this because we know the state has 4 witnesses they plan to call. They've been given 5 days for their preliminary hearing. Now, granted, we know the defense is going to call some as well, but if we're getting through 1 witness a day by the state,
hopefully
we're
not going to
kind of on schedule. It seems like this was sort of anticipated, and structurally, it fits with the way that they are presenting their case for probable cause, because they're really doing it primarily through the lead investigators. That's what I'm expecting. The most of it is coming through the witness currently on the stand, Agent Hull, and then the other lead investigator, Agent Davis, who's on the witness list, but hasn't testified yet. They're going to be the ones testifying about the vast bulk of what was brought to their attention by other law enforcement over the course of the investigation. And so it's really not going to be the kind of hearing where we're going to, blow through a lot of witnesses and a lot of evidence real fast. It is going to take some time. But I think that the pace is likely to pick up a little bit. Now that we have gotten through some of the preliminaries, some of the background, we don't have to spend another 40 minutes looking at aerial photos of the campus,
which was crazy.
Now to all of that.
We're gonna get some objections though.
Is kind of already in place. What the prosecution seems to be doing is presenting their case for probable cause through the eyes and the story of the investigation they conducted. They're doing it chronologically. They're on the day. Here's what we discovered immediately. And then as we moved into our investigation to find the suspect, here's what we found. We've already got a little bit of the preview of call to the Washington County Sheriff's Office indicating somebody wanted to surrender. That person was Tyler Robinson. So we can anticipate that's the direction that they're moving in. We're going to continue to work through this investigation that they were doing primarily, I think, on the surveillance cameras to help them identify from the scene who's our suspect there. And then we'll transition to Tyler Robinson coming to their attention, and then the evidence that they got from him, from Lance, and the ways that they corroborated that.
Okay.
So today, could be a little bit bigger, because I think we could be moving more towards the surrender. And the surrender, of course, again, it's not really news. We have the state's account in the probable cause documents, their descriptions of the case. But you know how the internet commentary is. There's a lot of questions and
Internet
accusations
commentary.
and speculations and things like that surrounding all of it. Did his parents turn him in? Did he confess to his parents? Those types of things. So we can expect to be moving in that direction today. That's where I think we're going to be going. For me,
Tell us
the
about it.
thing that happened yesterday that I'm like, yes, totally under the radar, very subtle, kind of slipped in there, not a big to do about it, because I can already tell it's not going to be the focus of this preliminary hearing, but it is so going to be an issue at trial. Was that little subtle reference by Agent Hull that the surveillance video together with the cell phone data helped place Tyler in certain locations. The cell phone location data, it has made its first appearance. Guys, it's going to be huge in this case. We already kind of knew this was going to be huge in this case. At least I did, because we can go back on pretty much day one of getting any kind of information. When we got this probable cause statement from, I think this was the FBI agent that wrote this one. No,
Oh, I know what
Davis.
she's talking about.
This was SBI. SBI. This was Davis, right? So he has yet to testify, but he will be testifying. The reason why it was really obvious from the very, very beginning that cell phone data was going to be big in this case is this part of the PC right here. UVU surveillance camera at 11:50 captured suspect walking across a grassy area north of Campus Drive, 800 West, turned south through the parking lot, approached the pedestrian tunnel. Before entering the tunnel, suspect paused at the top of the stairs and pulled out what appeared to be a cell phone from his right pocket using his right hand at approximately 11:53, and eventually put what appeared to be the cell phone back in his right pants pocket using his right hand, and then making his way towards the Losi Center. This is exactly how they are going to piece together the parts of this case, because they've already told us explicitly. The surveillance video from the morning is very clear. It's obviously Tyler. You're going to be able to see that it's him. But the video from the time of the shooting is not as clear. It's more obscured, more obstructed. He's got the hat on, the glasses, changed the clothes, etc. This is their story. So how are they going to show this is the same person? The location data. The location data. They have his phone. They have surveillance camera that's going to tell us he's in this area doing this thing at this time. And when they find that on his phone, we're done. When they don't find that on his phone, defense is pointing out your suspect did this. Tyler's location, according to his phone, is somewhere else. We're done. It's such important data, evidence in this case, because it will, once we know that it's there, it will either be incriminating or exonerating. This was like the big difference, I think, between this case and the Kohberger case. Also expected in the Kohberger case, if they got location data, it's going to be big one way or the other. But the problem was they didn't have it. And that's why it couldn't definitively establish. Did he go to King Road that night? They don't know. His phone was off. Tyler seems to be using his phone. That's not the only instance either. the text chain with Lance. The text chain with Lance. It is reported in the PC affidavit. What we're anticipating seeing in this this probable cause hearing is the photographs that the investigators took of Lance's phone as he showed them these things. The initial step that they take to preserve this type of evidence before they are able to get the device, extract it, and obtain the original digital record. That's what we're expecting to see is the photographs of it. But they are going to analyze all of that and compare it to Tyler's phone. Maybe the messages aren't on his phone. Maybe he would delete the messages. It doesn't matter. There's going to be a record of the phone activity. There's going to be that record on his phone. There's going to be that record on the provider side. Provider is going to have records of texts received and sent and the time and to whom and from whom. All of this is available to corroborate the state's case. And if it doesn't, it's exonerating. And we'll hear about it from the defense. So the casual, oh yeah, the cell phone data, just dropping that in. That to me was big, just because, yeah, I mean, I knew this because I'm familiar with criminal cases. And in this day and age, the cell phone data is massive. It's massive. It's such a big part of so many cases. It's like one of the first thing they always want to do. Like, I don't even care what you're charged with. They're going to try to get your phone and look at whether your phone incriminates you. Does your phone put you in the right place? If it does, you're going to have some explaining to do about how it's just a coincidence that you were there while you are ostensibly on video somewhere you're not supposed to be, doing things you're not supposed to be doing. So my only regret is that it does seem to be a bit of a shame to me that doesn't look like they're going to get into any of that in this hearing. I understand why. I understand why they're not. It wasn't part of their original arrest decision. It's the part of the post-arrest investigation where a lot of the good stuff comes out. Now that you know who your suspect is, you've identified him, you can start to look at his digital footprint. But absolutely zero question. That's the hint from Agent Hull.
Okay, while Andrea is getting warmed up, let's just jump over real quick and see that the state seal is in place. They are getting ready for trial today. If you don't mind, please go ahead and hit that like button already. Go ahead and hit it. What is this? Read the latest. Let's see what they got over here. What's their latest news that they want me to read? What they got? Oh, okay. It's an update. Okay, this is dope. What to expect today? Okay. Tyler Robinson preliminary hearing trial day 2. Let me drop that in there for y'all. All right, during a break or whatever like that, if you want to check this out, it looks pretty straightforward. It doesn't look like super long at all. Okay, I appreciate that. Thank y'all so much for giving us that. Okay, make sure you hit that like button. Jump up into the best live chat on the internet. I appreciate Edie's up in here. Hey, Heather, how are you? How's it going there? I see you over there, Katie. Grace and peace to you. Good morning to all you good people. All right, the camera's moving. I think something's about to get popping and locking. They got some music over here that I don't want to get copywritten. I don't know if it's copywritten, but it's a sound, some kind of sound. All right. That camera is moving. It's almost go time. It's almost go time. What's going on, Reform Chick? How are you? I see you. I appreciate y'all stopping by this morning. I had a great conversation with attorney Dennis Sperling. Oh, we're back. Let's go.
403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
I'm up in here.
Jack Remander, Ryan McBride, David Sturgill, Lauren Hunt for the state, Jeff Gray, the county attorney, as well as Chris Miller are also present.
Good morning.
Good morning, Judge.
Good morning, Your Honor. Good morning, Your Honor. Good morning, Your Honor.
All right.
Kathy Nestor, Michael Burt, Richard Novak, Stacy Visser here for Mr. Robinson, who's seated to my right.
Good morning, counsel. Good morning, Mr. Robinson. And for the record, the court also recognizes the presence of victim representative, Ms. Erica Kirk. Good morning.
Okay, so
First,
now
with
we know Erica's in the
respect
house
to courtroom
again.
Protocol to maintain security and decorum. Any individual who exits the courtroom during proceedings will not be permitted to re-enter until recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices. All right, is it the audio working?
Mhm.
All right, well, let's just take a brief moment.
That sounds like an old school dial.
It appears to be working.
All right, so they're having a little bit of technical difficulty this early in the morning. Shout out to them. Nobody's above it. Nobody's above it.
While we're waiting, if you have any water bottles or such, feel free to drink them. It is a little bit warm in here today, so I will be drinking from my water, so don't hesitate to use that if you need to.
All right, so if you're just jumping in, we're just getting started. They have not started court as of yet. So we are waiting for them to really, he was actually giving instructions and they needed to do a little bit of audio check. Absolutely. What's going on? Shout out to the almost 100 people that are watching on YouTube. 26 are watching on X. Shout out to it. Shout out to you. I don't think X can actually comment. Put X in the chat if you can comment. For some reason or other, they won't allow me to comment to X. Interesting. Okay. Good morning to you, Rhonda. How are you? All the way from Sweden? Come on.
Is it working?
Yeah, I haven't. I need to go pop in. I'm gonna go pop in on X real quick, see what they're doing
Can you
over
send
there.
them a link to the,
Check them out.
where this is being streamed so they have something to look at. I see. All right. All right, let's go ahead and continue. And let me repeat it just because the audio may have cut out. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and still photographer, and I will invite you to come forward. Today's, the purpose of this is to ensure clarity regarding the expectations governing today's proceedings. Could you both state your name for the record?
Yes, Trent Nelson with the Salt Lake Tribune as the pool still photographer.
John Wilson from KSL Television, video photographer.
Good morning to you both. Have you reviewed the court's standing decorum order?
Yes, Your Honor.
Yes.
Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
Do you anticipate any difficulty complying with the order or today or with the court's instructions?
No.
All right. Well, thank you. I appreciate your
Thank you.
cooperation today. As we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly during all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during today's hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or opposing to any person connected with this case, or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Turning now to counsel. Before we begin, I wish to acknowledge the professionalism, civility, and competence demonstrated by counsel for both the defense and prosecution during yesterday's proceedings. It is evident to the court that each of you approach this matter with seriousness, preparation, and a deep commitment to your respective responsibilities. The court appreciates the care which you have taken in advocating for your positions and the respectful manner in which you have done so. Thank you. Do either party require the benefit of the record before we proceed?
The state does, Your Honor. Mr. McBride will address the court.
All right, and just as a reminder, the microphones at council table are turned off to prevent the inadvertent capture of any communication. So if you would like to come forward, thank you. And turning to Mr. McBride.
Thank you, Your Honor. Before this hearing, the defense moved to find Article 1, Section 12 of the Utah Constitution, Rule 7B, and Rule 1102 unconstitutional as it relates to the admissibility of hearsay and reliable hearsay at this hearing. The issue was extensively briefed and argued. The court denied the defense motion to exclude the use of reliable hearsay at the preliminary hearing. That ruling is at docket number 631. In addition, defense counsel filed a standing objection on July 3rd. That's docket 678. The standing objection reasserted the arguments made in defendant's previous motion. Defendant continues to make these same objections throughout the testimony of each witness. I believe both the state and the court and everyone present knows that the defense objects to the use of hearsay or reliable hearsay at this hearing. On the point of preserving the objection, that has been done. Defense counsel has filed their motion, they filed their standing objection. Throughout the proceeding, they have continued to make objections. At this point, further objection is unnecessary to preserve the record and causes undue and unnecessary delay. This is needless delay, and we'd ask the court to acknowledge and the record to reflect the standing objection. And we also ask the court to give an instruction that continuing objections on this ground are unnecessary. Of course, if it relates to some other ground or is some item that's particular to a particular statement, that objection may be appropriate. But at this point, we feel that the repeated objections that have been made and already been ruled upon are unnecessary and cause undue delay.
Thank you, Mr. McBride. To defense.
Good morning, Your Honor. Michael Burt for
Good
Mr.
morning.
Robinson. We have no objection to that procedure as long as the court makes a ruling that the objections are preserved. We do think it would expedite matters if we didn't have to repeat the standing objection. There may be particular objections that are not covered by the standing objection we've made, and so we ask permission to be allowed to make those objections as needed.
Thank you, Mr. Burt. Thank you to both sides. I appreciate the presentation and your argument about this. The court takes no position in regards to whether the objection is made again and again or not. I leave that to the parties. I recognize the need to expedite this, and if both sides stipulate, I will adopt the request that the standing objection as it relates to 1102, Article 1, Section 12 of the Utah Constitution, and all relevant authorities that have been cited have been noted, and the standing objection by defense is in place. However, if defense feels the need to do that in order to protect the constitutional rights of Mr. Robinson, the court will not prevent that, nor stand in its way. This court is not is acting in the role of a magistrate and will allow the parties to move forward as necessary. But as noted, I will make that note that the standing objection has been noted for all of the yesterday's proceedings and will be in place throughout the rest of the preliminary hearing. Anything further or any need for the record given the court's statement?
Not from the state.
No, Your Honor.
All right, thank you. All right, the court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. And again, I will leave it to the parties to monitor the courtroom to ensure that if a witness has come in and they shouldn't be, that they are redirected. I invite Agent Hull to return to the stand to resume direct examination. And Agent Hull, you are still under oath. Mr. Sturgill?
Thank you, Judge.
And before we begin, is there a way to dim these lights just a tad like we did yesterday? Perfect. Thank you. All right. As of yesterday, there is also a water bottle to your left. And if you wouldn't mind just making sure that microphone is directly in front of you, we want to make sure that the record picks up your testimony today. Mr. Sturgill, your witness.
Thank you, Judge. Agent Hull, we're going to return to what has been marked State's Exhibit 12.1. There was reference to it yesterday. And I'd like to ask you again, have you reviewed that exhibit?
Yes.
And if you wouldn't mind, just briefly remind us what that exhibit consists of.
The exhibit is a compilation or running of a summary of videos from UVU campus security footage.
Okay.
Your Honor, excuse me, we can't hear the witness.
That's what I hear. So let's go ahead and
Yeah.
stop. I'm not hearing it. So I'm going to have you repeat. Let's test it. Go ahead.
Check.
All right. I believe that.
Thank you.
Mr. Sturgill, if you wouldn't mind restarting.
I
so
can do that, Judge.
Thank you.
Maybe bring a mic from the base a little bit closer to you. I don't know if that'll help. All right, let's go ahead and go back to what's been marked as State's Exhibit 12.1. I'd asked you a moment ago if you'd reviewed that exhibit.
Yes, I have.
Okay. And would you just remind us what that exhibit consists of?
It's a compilation of videos that were part of the overall footage that was obtained from the Utah Valley University as part of the investigation.
And does that compilation video, from your point of view, capture Mr. Robinson arriving to and visiting the UVU campus
It does, yes.
on September 10th through the 11th, 2025?
Correct.
Okay. And again, I asked you this question yesterday, but did you prepare that video compilation?
I did not.
Okay. Do you know who did?
The Utah County Attorney's Office.
Does that video, and I'm referring to 12.1 exhibit, State's Exhibit 12.1, does it include all of the footage collected by the SBI from UVU?
It does not, no.
Does that video, again, 12.1, include all of the footage you collected from UVU that captures who you believe is Mr. Robinson walking around campus?
Not all of the footage, no.
You reviewed this compilation with Mr. Olson, correct?
Correct.
And in its entirety.
Yes.
And he actually, and then you collected an 1102 statement from him.
I did, yes.
And I believe that has actually been admitted into evidence as State's Exhibit 12.3. Did Mr. Olson refer to that exhibit 12.1 in his statement?
He did, yes.
Okay. 12.3. I'm going to put on your monitor State's Exhibit 12.3. And I asked that if you scroll down towards the very bottom. And I would ask that you read from the statement specifically what Mr. Olson said about State's Exhibit 12.1. And I want to narrow your focus. So I'm going to draw your attention about 3/4 down the page. There's a sentence that begins on the left margin, "I have reviewed." Do you see that?
I do, yes.
Okay. Would you please read that sentence?
I have reviewed State's Exhibit 12.1, and the recordings are true and accurate, including timestamps, dates, and camera labels. The only changes are some zooms and red highlights, which were not part of the original recording.
Yeah.
Would
Have
like me to-
you, I'm sorry.
Sorry, I didn't know if you wanted me to continue. or-
No, that's good enough. Have you had a chance? Well, you review the raw footage yourself. Is that correct?
Correct.
And does that comport with your viewpoint of that exhibit?
It does, yes.
Have you had a chance to review what's been marked as State's Exhibit 12.4?
Yes,
Okay, and when did you review that exhibit?
this morning
And who did you review that exhibit with?
with Kimberly Durfler.
Okay, was there any conversation about that exhibit?
No, I was just shown the video.
Okay. Nobody asked you questions or suggested anything to you?
They did not know.
Did you prepare that exhibit?
I did not.
Do you know who did?
The Utah County Attorney's Office.
All right. And I'm referring specifically to what's been marked State's Exhibit 12.4. What is depicted in that video?
That video is, again, a compilation of videos from the overall footage that was obtained from Utah Valley University for September 11th and September 12th.
And how does it compare to what's been marked as State's Exhibit 12.1?
It appears to be the same footage. However, on this particular version, there were no circles or blurs that had been made to the video.
How about zooming in and zooming out?
No, there was no zooming or zooming out.
Does it appear to be identical to the raw footage that you've seen that portrays this particular part of the UVU surveillance video?
It does, yes.
Judge, the state would move to admit what's been marked State's Exhibit 12.4.
And
Your Honor, we just object to the publication of this for all the reasons we argued yesterday. We think this video is going to play a big role in the trial, and to allow the public to see it now would seriously impact our ability to get a fair trial, and we're asking the court not to publish it.
thank you. And Mr. Sturgill, and to all counsel, as it will apply to all counsel, when you are moving a piece of evidence, it's the three parts, whether admissibility into the record,
Right.
to be published in the courtroom, and captured by the media. So Mr. Sturgill, as it's your request, what are you requesting?
Judge, first of all, clearly I'd move to admit the exhibit. I'd ask, and Judge, the presumption is that this is a public record and should be published. And so the state's position is that it should be published here in the courtroom, and it should be published in such a way that the media can capture it on video.
All right.
Your Honor, can I be heard on that very briefly?
You may, if you would approach the lectern, please, and state your name.
I'm David Ryman. I represent the news media. I didn't make an appearance because the news media technically aren't parties, but as you know, they do have the right to be heard on issues like this, and I've tried to keep that to a minimum. But since this is the first one coming up today, I thought it might be helpful to just address it again. There is a presumption not just that it be published in the courtroom, as we talked about yesterday, because the participants or the spectators in the courtroom have a right to know what the court is viewing so that they can understand how you're making your decision. This seems like a very important piece of evidence. It doesn't seem like there is a basis in the courtroom today from understanding why it's being introduced. It is not like the videos yesterday, and my understanding at least is, and you can correct me if I'm wrong, but we didn't object to the videos that weren't published yesterday that were graphic. We didn't object to the non-publication of the autopsy report. The argument here that Ms. Nestor just made is this seems really relevant, and that is precisely why it needs to be public. With the last thing I'll address is just EMC. There is a presumption, it's a rule presumption, not a constitutional one, that EMC is allowed. And I think that for all of the reasons that we've briefed this for your honor several different ways, there needs to be a really good reason why. If it's being published in a public proceeding in the courtroom, it should not also be it should not also be allowed to be published to the media. So
Thank you.
thank you.
Mr. Sturgill, did you wish to respond or perhaps give a little bit more detail on what this video purports to show?
Well, do you want me to proffer that, Judge, or have the witness?
I'll defer to you.
Okay. Well, first of all, if I could take one step back, let me ask you, I may have misheard, but let's just be clear about this video, the compilation video. It includes video surveillance from UVU campus from what dates?
September 10th, 2025 into the morning of the 11th, 2025.
And if you wouldn't mind just describing in a bit more detail what this compilation includes.
The compilation shows the movements of the individual believed to be Mr. Robinson on Utah Valley University campus, arriving and leaving in a vehicle, arriving and leaving on foot, and then returning and leaving, and then attempting to gain access again in a vehicle. And his movements throughout the day are included in the videos also.
Is there any footage of the alleged shooting?
There is not, Judge.
Okay, I just want to clarify that. Ms. Nestor, given that additional information and anything further from defense?
Mr. Burt's he's the one who's been litigating all of the First Amendment issues. If he could address Mr. Ryman's argument.
Yes, Mr. Burt, if you wouldn't mind coming forward.
Judge, I wanted to clarify one argument that was made by counsel for the media yesterday, and that was the rules, the rule 4-202.02 does not apply to the situation we're in right now, and that is wrong. The rule says that this rule applies to the judicial branch, and 4-202.02J says the judge may regulate or deny access to exhibits to ensure a fair trial. So I think that rule does apply to our situation, and the Supreme Court in the Algier, ALLGIER case, 258 Pacific 3rd, 589, applied the rule in the context of an evidentiary exhibit. And I know the court has not mentioned, since counsel made that argument, this particular rule, but I think it does apply here. And also applicable is the Supreme Court's decision in the Kearns case, which we talked about when we argued the motion for denying access to the cameras. And that case, Kearns versus Tribune Corporation, 685 Pacific 2nd, 515, says that the standard the court ought to apply in determining whether an exhibit at a preliminary hearing should be sealed is one of a, quote, realistic likelihood of prejudice. And we rely on the evidentiary showing we've made in connection with our motion to exclude cameras, that there is a realistic likelihood of prejudice in this way. The court knows and has access to the media coverage up to the time when we litigated the motion concerning closing this hearing to the cameras. And the court knows that one feature of the media coverage has been a very pro-prosecution bias of every story that has been published on this account. The court also knows from that coverage that information is being widely disseminated, and you have found in connection with the shackling issue that the publicity in this case is likely to reach jurors who will be part of our jury pool. And we've also submitted to the court a public opinion survey, which shows that the prejudicial publicity that the media has already generated in this case has affected the jury pool. And so those are all factors the court can point to and rely on and conclude that publication of this particular exhibit should not be allowed because there is a realistic likelihood of prejudice to Mr. Robinson's right to a fair trial. So under that standard and under the rule, the court ought to deny publication.
Thank you, Mr. Burt.
Thank you.
Any final argument from the parties before the court issues its ruling?
Your Honor, can I be heard on that briefly?
Yes, you may.
Thank you, Your Honor. David Ryman. I just wanted to clarify. I don't know that Mr. Burt and I necessarily disagree about what he said about the rule. What we were talking about yesterday was something different. That is the portion of the rule that classifies records that are in the court file. You know, it's not the same as what happens in a public hearing. And Mr. Burt referenced the portion of the rule that essentially just tracks the constitutional standard, which of course, you know, controls here as to whether in this public proceeding, it can be closed in any way, and non-publication of exhibits as a form of closure. So I don't necessarily disagree. I would just underscore a lot of what Mr. Burt just said has been briefed ad nauseum at this point. Their position that publicity is incompatible with a fair trial. The Allgaier case he mentioned, you know, I know that case. I litigated that case. It involved a confession that the court found public because you have so many other tools to seat a fair and impartial jury. And we have cited that case repeatedly, and so has Your Honor, I think, recognized it in your ruling, saying pretrial publicity can coexist with the defendant's right to a fair trial. So the last thing I'll say is just that the constitutional standard that I think we're all agreeing applies here is weighty and difficult to overcome. And it is never satisfied, as we've explained, by just generalized assertions that there's a lot of publicity out there. It's got to be something really specific, and they just haven't made that showing. And I certainly don't think that a video that apparently just shows the defendant walking around the UVU campus qualifies.
Thank you. Anything further?
From the state, no, but I think I'd like to be crystal clear. You asked if there's any portion of this video that captures, and I believe you asked of the actual shooting. There's no video of that. There is video, however, and you've heard testimony related to this, where the shooter goes to the top of the Low-C building, goes out to the edge of the building, low crawls, and then leaves after what we assume is the shot being fired. That's as close as it gets. I don't know if that makes a difference, Judge. I just wanted to make the record clear, and I want to be crystal clear with Your Honor.
Thank you. I appreciate that clarification as it is guiding for this court and making its ruling. I turn to Utah. Well, let me pull this up.
Thank you so much for the
4-202.
brand new memberships. Thank you very
102.
much. Patrine,
I go down
thank you
to-
so very much. Mindy,
Well,
thank you all.
First, it says statement of the rule. 1, presumption of public court records. Court records are public unless otherwise classified by this rule. 2, public court records. Public court records include but are not limited to, and I'm going to go down to 2J, exhibits. But the judge may regulate or deny access to ensure the integrity of the exhibit, a fair trial, or interests favoring closure. And the court recognizes the importance of the constitutional rights of Mr. Robinson being upheld and protected. At the same time, the court also recognizes the importance of transparency and a proper balance to ensure that the constitutional rights of all parties are upheld. As it relates to this exhibit, I believe it's 12.4.
12.4, yes.
Based off the representation of what is in that, the court differentiates this exhibit from the exhibits from yesterday, namely Exhibit 7, Exhibit 8, and Exhibit 9, as those are different in nature. And those go to issues relating to Utah Constitution, Article 1, Section 28, as it relates to the Declaration of the Rights of Crime Victims.
It's just long.
And the court also recognizes Utah Rule of Evidence 1102, as that is the foundation that's being laid for the admission of this exhibit. Having taken in consideration all factors, the court rules that Exhibit 12.4 is admitted into evidence and shall be played in the courtroom and may be broadcast by the media. We can proceed.
Thank you, Judge. Agent Hall, before we actually watch State's Exhibit 12.4, I have just a few questions. Yesterday, you testified at the very beginning of your investigation that you focused on the video that captured the shooter on the top of the Low-C building. Is that correct?
Yes.
I believe you also testified that you began by working your way, and this is what I remember you saying, so correct me if I'm wrong, but you in essence testified that you began with that video and you started working your way backward and forward with the UVU surveillance video in an effort to trace the shooter's steps on campus. Is that right?
Correct.
Okay. Would you mind explaining just in a little bit more detail what you meant by that, tracking forward and backward on that video?
Yeah, we had a known when the shooting occurred, and as the officer testified, there was a video of an individual on the roof at the time of the shooting. And so the philosophy that we applied was to take what we knew and then work that forward through the timeline and backwards through the timeline to try and establish where the individual had gone from the rooftop or how the individual had come to be on the rooftop.
And did that, for lack of a better term, did that bear fruit?
It did,
you
yes.
actually see from, at least in part, where he came from and where that shooter went?
Yes, more so where he came from. It was very limited after the fact.
Okay. You testified yesterday that in reference, I believe, to what's marked State's Exhibit 21, that you believe Mr. Robinson visited campus at least 4 times on the 10th and the 11th.
Correct.
And I think you reaffirmed that today. Did you do the same attempt, that is, to track Mr. Robinson through UVU surveillance video during each of those 4 visits?
Yes.
Or those other 3 visits, I guess.
Yes, on each occasion, we attempted to follow the movements of the individual throughout campus.
And did you in fact see Mr. Robinson on campus in surveillance video that is not included in State's Exhibit 12.4?
Yes, there is additional footage of him on campus, yes.
Okay. I'm going to have displayed on your monitor. What you're going to see is a paused or a still image. And I'm going to ask if you recognize what you see that now, Agent Hall?
I do, yes.
Okay. Do you recognize what's displayed on your monitor?
Yes, it's footage from the university that was provided to us, particularly of the parking structure.
Okay. Does it appear to be State's Exhibit 12.4?
It does, yes.
So I'm going to go ahead and I'm going to have this video run. And if you don't mind, as it's running, I'm probably going to be asking you some questions. And so this video has no audio, is that right?
No, there's no audio on the cameras.
Okay. Let's go ahead and start the video.
Your Honor, it's just not up on the screen yet.
Let's go ahead and put it on all screens. No, I appreciate it. Is so it is admitted and may be published to the screens. And just want to make sure it's on your screen, Agent. All right. All right. Mr. Sturgill, you may proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe this particular vehicle belongs to Mr. Robinson?
Information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red T-shirt and the shorts and the shoes.
And do you believe you recognize who that person is?
Yes,
Who is that?
I believe that's Tyler Robinson.
All right, and where does he go from there?
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area,
Sorry,
But do you know if they're body doubles?
the amphitheater is what I previously referred it to.
all right. So he goes up on campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
But is it a body double? He never said foot, though. We never saw his foot. Technically, we never saw his foot on the
And where's his
campus.
parking?
Candace said that he never set foot. We've never seen his feet on the campus. You gotta remember that, people.
Structure located on campus.
It's just off of Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving.
Oh,
the
he got a
vehicle.
Charger. He got a Hellcat.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video. And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored T-shirt with
Uh-oh.
gray or olive colored shorts and then Converse shoes.
Oh man.
And
Oh
what time did he
man.
return to campus.
Just after 10 a.m.
And does he leave the parking structure eventually?
He does, yes.
And during this visit, do you know where he goes after he leaves the?
Just gonna fess up, my
Yes,
dude.
we were able to track his movements on campus. He went to Chick-fil-A
Not Chick-fil-A.
in the Sorensen building
Mhm.
and purchased some food, sat and ate the food. Then,
And
I'm sorry,
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Koch was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus we noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building. And
goes where?
then, I'm sorry,
And then goes where?
then goes across to the railing that gives access to the roof of the Losi building.
From there?
From there, he comes back down the stairs and walks off campus from that point.
And about what time was that he left campus that second time? Do you know?
I believe it was approximately 11 a.m. or just after, if I recall. I could verify from my notes if you need an exact time.
Yeah, if you don't mind. That'll help you remember, refer to it. Don't read it out loud. Just let me know when you've had a chance to look at that, would you?
This is bad. But technically, we already knew Candace was lying. We never were under any suspicion that she was not lying. It's just now her audience is going to see in 4K. This is pretty good imagery, by the way. They're going to see that she's been lying to them. So I want to see what they end up saying. But let's keep dancing. Let's go.
Were you able to refresh your memory as far as the time?
I was, yes.
And what time was it?
It was just prior to 11 a.m. when he walked off campus.
And before we go any further, the parking structure that he left initially, where is that parking structure in relation to the LDS Institute building?
I'm sorry, in relation to?
The LDS Institute building on campus?
I think it would be just to the north of the LDS Institute building, if I recall.
Do you recall whether it was adjacent to the LDS Institute?
Yes, it is.
Okay. All right. What do we see displayed here now? Go ahead.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
And this takes just a moment. And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have are from my viewing and seeing Mr. Robinson on the video, it's the same person.
He's noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Okay. Now what do we see?
So it's Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
Dang. Bruh, just go ahead and fess up,
Again, we're
bruh.
able to track. So we're able to track Mr. Robinson when he leaves this parking structure.
Yes, we were able to.
So when he leaves the parking structure, where does he go?
He comes up around Campus Drive. As you can see on the video here, there is a cut through there north of the Losi building, and that's Mr. Robinson coming up the sidewalk. He has the noticeable gait or limp in his walk. And then he moves south across the front of the Losi building.
On the sidewalk?
Yes, correct.
Okay.
He would be the rear of the two individuals in this particular video.
So right now, if you were to break this picture into quadrants, where would he be?
I would be in the top left quadrant, walking to the left of the image.
Now what do we see?
This is an image looking across the parking lot to the Losi building, and Mr. Robinson is appearing on the exterior staircase, which gives access to the Losi building roof and the area where the railing was.
And again, let's break that image into quadrants. Where would he be
Wow,
located
they
if you
got
broke it
him
into
all the way
quadrants?
up
It's in
there.
the top right, and the individual can be seen moving under the notations that are on the video.
And what time is this?
It's just afternoon, about 12:15
On what day?
on September 10th, 2025.
What just happened, or what did we just see happen?
The individual actually kind of rolls over the railing onto the roof of the Losi building.
All right. Go ahead,
Um,
sir.
And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building
Wow.
to what would be the southwest corner of the building, crouching down and then crawling to the corner of the building.
And this is at what time?
Around 12:23. I think the timestamp on the video is 12:22
On the 10th.
on September 10th, yes,
So we're
2025.
clear, this is the roof of the Losi building.
Correct.
Can you still see that individual?
Yes, you can, laying prone.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. Individual then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. They move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Do you see Mr. Robinson now?
I do, yes. He's just arriving at the corner of the building, almost the top center of the image.
What are we seeing now?
And Mr. Robinson lowering and jumping off of the roof of the Losi building onto the grass area, and then moving away towards Campus
Wow.
Drive. And he appears to be carrying some kind of an object in his hand at this time.
So he's approaching,
Campus Drive,
and again, broken into quadrants. Where is he currently?
be in the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
What do we see now?
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive. That's the vehicle that's driven by Mr. Robinson.
And on the screen, where is that vehicle that you're referring to located? If you broke it into quadrants.
It's on the left side, on the upper side, the upper quadrant.
Now, what do we see?
That vehicle's now pulling away and heading east on 800 South.
Man, they ain't playing.
And why do you believe that that vehicle is Mr. Robinson's vehicle?
When that vehicle was stopped, it actually made contact with an officer who was doing security detail,
And do you know who that officer is? or
Officer
was?
Goforth,
Okay. And do you know which department he works for?
Spanish Fort Police.
And did you have a conversation with Mr. Goforth regarding this interaction at that intersection?
I did, yes.
Okay, and what time was that interaction? I'm sorry. Did I ask you that?
It was approximately 12:30 a.m.
On the 11th?
on September 11th, 2025.
So you talked to Officer Goforth about that contact on the corner on that, or during, I guess during the early morning hours of the 11th.
Correct.
And what did Officer Goforth tell you about that interaction?
It was an interaction that I guess cop intuition, but there was something about the interaction that made him make a note of the license plate of the vehicle. And then subsequently, when information
being
was
profiled.
available that vehicle or a vehicle matching the description of that was involved in the incident, he ran the information that he had obtained from the stop and was able to identify that it was registered to Mr. Robinson, and he had in fact had contact with Mr. Robinson on the morning of September 11th, 2025.
The information that he ran, do you know what information when you say that, he ran information,
Yes, he ran a partial plate,
a license plate?
correct.
And based on that partial license plate, he was able to identify the owner of that vehicle?
Yes,
And did he tell you who the owner of that vehicle was?
he did, yes.
Okay, and who did he tell you that belonged to?
Said there were two registered owners of the vehicle, Tyler Robinson and an Amber Robinson.
So it was his
say anything about
mama.
the person that he actually interacted with?
Yes, it was a male that he believed to be Tyler Robinson.
So you're saying it could have been his mama? No, I'm just kidding.
Let's
That's
return
crazy.
again to what's been marked State's Exhibit 12.1. Again, you've reviewed that video.
Yes,
And the difference between 12.1, or what's been marked as State's Exhibit 12.1 and 12.4 are, if I understand you correctly, are these enhancements that we've been talking about.
yes.
And specifically, be specific about the enhancements, and let's go one at a time.
Okay,
I think there's a reference to either red circles or red highlights. I think
Correct.
That's how Mr. Olson described it, red highlights.
yes.
Do you know what he's, or what is he referencing by the red highlights, or what do you believe he's referencing?
I believe he's referring to red ovals or circles that were placed over the image to identify specific individuals of note.
And these red circles, are they permanent red circles? Are they temporary?
I'm
Different.
I would assume they are temporary. I'm not very technological, but I believe they would be overlaid over the image.
That is a bad question. What I mean by that is do they appear and disappear quickly, or do they linger or last for a period of time?
They're there for a notable period, but I believe they come off the video. But
All right. And other than, well, and you said that the circles, what do the circles do?
they identify an area or a person of interest within the video.
And other than do that, do the circles or the highlights, do they do anything with regards to the video itself as far as its accuracy?
Not to my knowledge, no.
I think the next enhancement that has been mentioned that we've talked about is there's some blurring.
Yes.
Do you know what that? Tell us what that is. What blurring do you see in what's been marked as State's Exhibit 12.1 that you now don't see in 12.4?
If I recall, there were some individuals in the parking garage footage, and their faces were blurred.
Is anything other than faces being blurred?
Not that I recall, no.
And how often do you see the blurring throughout the video?
I believe it's just in the original sequence in the parking garage.
The other than the blurring, does the blurring, other than obviously blur out part of the image, does it change or impact the accuracy in your mind of that part of the compilation video?
Not to my knowledge, no.
And then the last thing is, I believe, is there's some zooming in and zooming out that's in 12.1 that has been removed
Yes.
from 12.4. What can you tell us about the zooming in and the zooming out?
Predominantly, it's in the area that was referred to as viewing the Losi building rooftop. I believe it focuses on the area where Mr. Robinson comes up the stairs and onto the rooftop. Those portions of that particular footage were zoomed in for clarity.
Other than zooming in and zooming out, does at least that enhancement to the video, does it change the content of the video,
No,
the accuracy of the video in your mind?
no.
Okay. Are the enhancements in State's Exhibit, well, it's been marked as State's Exhibit 12.1, are they helpful in any way, or what do they add or take away from that video?
I think for people who are not familiar with the area and what's trying to be shown, they allow an opportunity for people to look at an individual who we believe to be Tyler Robinson, and also specific movements with more clarity than the original focal point gives.
So let's talk about the zooming in and the zooming out. It sounds like it's specific to the Losi rooftop, if I understand you correctly.
Yes,
Okay. And I think we've all watched that exhibit.
correct.
Before. And although you can see Mr. Robinson and his movements, is it fair to say that it's difficult to really see what's going on?
That would be fair, yes.
And the version that's in 12.1, does it facilitate at least that part of the video, seeing Mr. Robinson and tracking, I guess, his steps?
I believe so, yes.
Judge, at this point, I think in combination with yesterday, the foundation that was laid yesterday, including the written statement from Mr. Olson, which has been admitted into evidence and is, well, it's already been admitted to evidence. We believe there's enough foundation that at this point, we'd also ask the court to admit what's been marked State's Exhibit 12.1. We think it would be well, beneficial for Your Honor to view it.
Ms. Nestor.
Thank you, Your Honor. We renew our authenticity objection, and we also object to for admission purposes. And then we also object to the publication for the same reasons, the fair trial issues that we raised with the unaltered version that was just submitted.
So what you're saying is that it's a day that ends in Y. That's what you're saying, Ms. Nestor.
The presumption is that this is a public record, that it should be not only admitted, but it should be published here in the courtroom, and it should be published in such a way that the media can have access to it.
All right, real quick, shout out to Mike. Thank you so much, man. Blessing 10 people with memberships. Mike is over here filling up the chat. Y'all tell Mike thank you. If you got a membership from Mike, please make sure you put his name on it. If you got a membership, put his name on it and say thank you very much. I appreciate you, Mike. Thank you so much for that, brother. Okay, let's get back to this. Oh man, how are they going to square this peg, y'all? Oh, by the way, Mike, you are the stream sponsor. Let me go ahead and make you the stream sponsor.
All right. I do have a question, and just directing your attention to the Utah Rule of Evidence 403, to the last phrase, the last 4 words in that. Do you wish to address that?
Judge, I'm going to have to look at 403 specifically for those last 4
Well,
words.
I
unless
can
you want to share
read.
that
I
with
can
me.
read that. Or
Okay, go ahead and
needlessly
read that.
presenting cumulative evidence. So the court may. Let me just read the whole rule for completeness. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. I'm not looking at anything else other than that last portion. I recognize there is no jury. I am the magistrate. I am the fact finder, but just addressing that last point of Rule 403.
Right. Judge, well, I don't believe that the evidence is cumulative. I think that each of the 2 videos, although they portray basically the same footage, there's characteristics of the one that has been enhanced that I think makes it easier for Your Honor to truly see what's going on, and for the public to see what's going on. I mean, we've displayed 12.4 on the video, and unless you have very, very, very good vision or you've zoomed in on that monitor, you really can't see what Agent Hull has just described. The character of 12.1 is it simply it enhances that at least important parts of that exhibit, and it just makes it easier to see, not only by Your Honor, but also by the public. And specifically as it relates to the zooming in and the zooming out.
Okay. Anything further from the parties as it relates to 12.1? All right, well, I will admit 12.1 into evidence, but as it relates to playing it in the courtroom or on television, well, for the media, I find that it is, well, as the fact finder, I will look at the evidence and weigh it as a magistrate is required to do, but I do not find it is I don't find it's necessary to replay this video, given the representation that's the exact same video, the difference being enhancements made. If it was different in any way, or if it added to or subtracted from, that would be one factor. But because it's simply the same video, simply zooming in with circles or notations, the court does not find that the interest of justice requires it being played again. But it is received into evidence and will be reviewed by myself in determining a probable cause determination.
And I appreciate that, Judge. And just so we're clear, State's Exhibit 12.1 has been admitted.
It is received into evidence, yes.
And your intent is to review it in its entirety, but not here in the courtroom.
Yes.
Can I make one suggestion, Judge? Or maybe
Sure.
one run request? I believe the most important part of the most helpful part of this video is the zooming in and the zooming out. And that is a portion that if you want, we could isolate that and only play that portion of the video if you'd be willing to publish that portion of the video. And that's really the thrust of why we are trying to introduce that exhibit, because we believe that it's helpful to see it up close. And unfortunately, because of the way it's formatted and the way it's been recorded, there's no way any of us can zoom in and zoom out on this video to get a better look at what's going on. And that's the reason why we did what we did, but we had to memorialize it and save it, and then present it in that way rather than just present it in its raw form and then have the ability to zoom in and out, if that helps Your Honor understand why we're doing what we're doing.
All right, Ms. Nestor, to the second request of not playing the whole video in its entirety, but simply the portion with the zooming in. How long is that, Mr. Sturgill?
I think it's a couple of minutes.
All right, Ms. Nestor.
We object to the prejudice of that, Your Honor, and ask the court to stand by your previous ruling on that.
All right, thank you. I appreciate both parties. What I will do is review this video in court, and it will be displayed to the monitors, counsel table, and to the court's monitor on any portion that you wish to play for me to look at, so all parties can see clearly that the court is reviewing it in court. But I do not find that it is necessary for its publication, because this is the exact same video. I recognize it's zooming, but in balancing constitutional rights, there is nothing on this video from what's been represented that the public.
So I'm confused, and I need, if you all, and I'm real quick, if you tapped in, if Andrea talked about this or somebody else on LawTube talked about this, can you please help me? This is the preliminary trial. They're just showing the evidence, and the judge is going to determine if that evidence can stay or the evidence needs to go. And the argument is whether or not they are going to publish. Oh, okay. The argument is whether or not they're going to publish this evidence to be seen on the screen right now. Am I correct? Okay. I'm sorry, my mic is loud. I'm sorry about that. I've been working on this mic thing. I told y'all, man, I keep having problems with my microphone. Okay. So wouldn't it be problematic to publish the evidence now and you haven't even selected a jury yet? And wouldn't that be the problem? I'm lost. I'm so lost. I'm over here. I'm confused, y'all. Are you really an attorney? DJ W Music Production. If you are, I'm a serious question. Like, this is some very crisp. I mean, that's some very crisp evidence that we saw. The videos, that was very crisp. So isn't that problematic though? Isn't this evidence being shown? Like it's going out, people are going to see it, people are going to be parsing through it and making assessments and looking at it and zooming in and doing all that kind of stuff right now. I'm sure somebody's doing it as we speak. But isn't that going to mess with the jury? Okay. Thank you. Rebecca, you said it so much better than me. Why couldn't I just said that? Isn't the jury going to see this? They might call me to be a juror. They might say, Jay Witt, we need you to be a juror. Well, then I'm going to be problematic because I done seen all the evidence. I don't have time to think about it. It's an evidentiary preliminary hearing about what will be considered admissible during the trial. I got you, but we're seeing it. Like, I'm trying not to be difficult. I'm not trying to be hard-headed. But aren't we watching it though? I'm a juror. I'm gonna mess it up. Because I done seen it. I'm sitting there watching it. Oh, y'all, I'm like, I am not understanding this. Send me an email, DJW. Send me an email. Hold on. Here's my email, man. Hit me up with an email. I don't understand that because it seemed like it would be problematic. It would just seem like to me that jurors are going to see this. That's all I'm trying to figure out. And maybe I totally understand, the preliminary aspect of it, but it just seemed like this is going to put you in a pickle where somebody's going to have seen this. All right, let's get back to this. Let's go.
Public hasn't already seen. It's simply zooming in, and I don't find that is necessary or and so in balancing the constitutional rights of all parties, I'll view it on the monitor. Council's free to view it with me as I'm looking at it, but it will not be broadcast in the courtroom or by the video camera.
Great, I appreciate that, Judge. I respect that. I think there's a natural break where we can start. And what I'm going to ask is just we simply play you will have this entire exhibit in evidence, though.
Thank you.
Is that right?
Yes,
Okay.
I will. All right, whenever you're ready. Council, as it relates to your monitors, just as a caution, if you don't want it to be wished to be picked up, and I'm not saying it will, I know there are camera operators being diligent in ensuring they're complying by the rules, but in abundance of caution, this is just your moment to take care of your screens if you feel the need to do so.
So if I could just have one moment. Hold on, Kimberly. Not sure where the power button is on this. There we go.
All right, counsel for defense, are we prepared? And for the state?
Yes, Judge.
All right, thank you. Having heard from both counsel, I'll go ahead and review it on my screens. It is not being displayed in the monitor in the courtroom. And you may present 12.1, the portion you wish for me to view. And just for the benefit of the record, do you want to put on the record the timestamp of what you're playing, at what point you're starting and stopping, as we go, or when we finish is fine. I just want the record to be complete.
Just the difficulty in doing that is because we've zoomed in, it's removed the timestamp on it. And so
Well, you can just give me the
count
The
on the
count
video.
on the bottom. There's a timer at the bottom of the total length of the video. So that's fine. I'm just trying to create a record of what exactly I'm looking at.
Whenever we
pause on the court system.
Oh, I see. No, it's limitations of technology sometimes. Thank you for letting me know.
Time on the video was just before 6-minute mark, Judge.
All right.
And, just so the record's clear, this is State's Exhibit 12.1.
Thank you. I have it on my screen. It's so it looks like it's been paused at 6 minutes and 9 seconds.
Agent Hall, can you see it?
Yes.
Okay, well, let's just, I'm good with playing it.
Y'all, we know we know DJW is legitimate. He using the intense words. Utah Reform Criminal Paragraph 7B. All right, so I'm gonna check that out. We know he's serious now. Now we know he's real. All right. We're back on that so I can look for it. What are we doing? What are we doing? Okay, I'm not 100% certain what they're doing. It looks like he picks back up. Let me get him.
Looks like at 6 minutes and 23 seconds.
I'm sorry. Judge, at 8:23, we stopped the video.
Oh, at 8:23. Okay.
8:23.
See
That's
if
the
it's
count
on.
on the video itself.
Thank you.
Okay.
All right. Thank you, Mr. Sturgill.
Agent Hall, you were able to watch that zoomed in version. Is that
Yes, sir.
right? Okay. And was there anything that stood out watching that zoomed version?
For me, on the zoomed version, it's apparent that Mr. Robinson, the individual jumping off the roof, is carrying an item.
Okay. And you can see clear.
So let me real quick answer this question. There's two questions I want to answer them because I don't want to go too far. Okay, I have an important question. Can he do the same thing as Brian did in his case? See all of this and then decide to play guilty. I'm sorry, I guess it means plead guilty if the death penalty comes off the table. Actually, as far as I know, yeah. And any lawyers or legal experts can come in, Rebecca, and correct me if I'm wrong. I think he can as much as stand up right now and say, hey, y'all, I did it. This is what I did, and keep it moving, and everything will be. Yeah. So he could do that, as far as I know. Okay, and then there was another question right here. J-Way Podcast. Be honest. If you were asked to be a part of the jury, would you do it? Oh, I would. You know what? I was thinking before that I didn't want to be on a jury. If I was asked to be on a jury, I would do my civic duty. I would come. I'd answer the questions. I go through voir dire. If they selected me, I would go be a juror. I mean, I'd realize how important it is to have good jurors, because we can't sit there and be mad if criminals get off and we're not a part of the jury. So you can't be mad about it. So to answer your question, yeah, I would, if I was asked to be on a jury, I would do it. I mean, would I want to? No. Would I, would I be upset about it? Probably so. But it is what it is. I would do my civic duty.
The clothing that he's wearing. Strike that.
Mr. Sturgill, do you want to respond to the objection?
Judge, it is leading.
I'll go ahead and sustain the objection and that you may move forward.
Is it easier to see? Strike that, Judge. I'll let the video speak for itself. Judge, I have nothing further with Agent Hall.
All right. Ms. Nestor.
He sounded tired, man. He sounded like he was frustrated. Somebody asked, why is Tyler Robinson taking notes? To be honest with you, what else would you be doing? You can't get on your phone. You can't, surf Netflix. You got to be dialed in. So I guess maybe he's taking notes, writing down some things, maybe telling his attorney, hey, I was smuggling gerbils. That's why I was walking with a limp. I didn't have a weapon in my hand. I was in my pants. I was trying to sneak. I don't know. He might be writing notes. I don't know. But I would probably be doing the same thing. I'd probably be taking notes, writing stuff. I mean, because you can't go to sleep. You got to sit there and listen to these people, maybe draw. I'd become a pretty good artist, man. But these people are determining your future, your life or death, your freedom. I'm paying attention. So he's probably taking notes. That's what I would be doing.
And I was just going to suggest that. It seems like right now is a good time to take our morning break.
Oh, there we go.
At 10:15. Let's come back at 10:30, and we'll resume with cross-examination of Agent Hull. Court is now in recess.
He's doodling. Y'all are wild. All right, let's see. We're going to jump over to Andrea real quick and see what Andrea is talking about.
What the division of responsibility between them was. There is an issue. There's a lead investigator. It's a little bit like, having the captain of the ship. You need to be the one in charge of everything. And when you have two captains, it's just not always a good recipe for
oh no, that's a good question.
Mission. So I wonder how they divided their responsibilities between them. If it was just a total sharing of all authority and calls and everything like that, or if
I'm gonna come back to Andrea. I think this is a good question as well. Could they use facial recognition? This is, I think, part of I'm saying the word problem. I don't mean it's a problem, but part of the problem is we have so many ways to survey people now. So I'm sure that this comes into, kind of gets into the gray area. Is this surveillance? Is this, search, so on and so forth, and it's such like that, invading people's privacy, so on and so forth. So I don't know if they use facial recognition, or could use it, in a very robust way like that. I don't know. That's a great question though. And I saw something. Yeah, I think he's just taking notes, man. I don't know what he's doing, but I probably couldn't, by God's grace, you'll never see me in his position. I'm probably taking notes. I'm asking questions. I'm answering questions. I'm saying this is what I was doing. I don't own a Dodge Charger, whatever like that. So, and I do think it's going to be very interesting. Is his attorney going to get up there and say, how do you know that he owns a Dodge Charger? Because nobody's argued that he wasn't there. And we're going to see. I want to see, is she going to argue that he wasn't there at all? Because that would be the Candace argument. Come on, Jason. He wasn't smuggling no gerbils. Okay, giraffes, baby giraffes. He's writing out his will. See? his mom and dad did recognize him. That was a good point. See, that's what I'm saying. I think there's a lot to this that we don't fully get. But let's jump back over to Andrea. See how Andrea is doing. What you got going on,
Prosecution in
Andrea?
every story. No, man, come on. Come on. Don't piss on my leg and tell me it's raining.
Whoa.
We just had a whole hearing over that stupid Daily Mail article about the case is falling apart because of the tool mark ballistics, the tool mark analysis.
Oh, yeah.
No. No, even if you have like a technical kind of distinction in your mind between mainstream or conventional media sources and then the online commentary and the new media and so forth, even if you make that distinction, there's plenty of mainstream commentary like the Daily Mail that has not been pro-prosecution.
So real quick, that's a good question. Wouldn't facial recognition prove it's 100% Tyler Robinson? I would think so. But if you followed the Fonnie Willis case here in Atlanta, there was a big deal about her and her married boyfriend canoodling at her condo. And they used cell phone data to determine that because the boyfriend, the married boyfriend, doesn't live far from Whitaker Park. I've run into him at the grocery store. Funny story. But he lives up here by Whitaker Park. And where she was staying is down by the airport. And I thought it was a slam dunk. They used the cell phone data to pick when he was leaving from the house. He got a phone call. He left from the house. He drove 45 minutes down to the airport, and he was near Fonnie Willis's condo. I thought it was a slam dunk. It seemed pretty straightforward. Like, they got him. They caught him. Man, they tore that thing apart so quick. So where I'm going with that is, even though that looked like a slam dunk, they looked so right on the button that they got him. No, even in that, even something as simple as that, or what I thought would have been pretty straightforward, it still didn't go. So I don't know if even facial recognition, I still bet they would come with some way to argue about facial recognition and lighting and so forth and this, that, and the other, even in that. But it's funny, when they need cell phone data, when they need facial recognition to put somebody in jail, it depends on who it is. Sometimes it works very easy. But then when they don't want to put the person in jail, they want to cause some confusion, it's not very easy. It's not that simple again. Just something else. The defense must try and object to as much visual evidence as possible. Good play by them, but very little chance of succeeding. Shout out. Thank you so much. Music Productions. Thank you so much. DJW. All right. No, facial recognition is not 100% proven. There are a few high profile cases. Yep. Okay. Facial recognition, getting it wrong and ruining people's lives. There we go. Yeah. See, they said I was mean. It wasn't me. I said it was me. All right. Let's get this back. Let's bring Andrea back up in here because we don't have a lot of time.
But I mean, that is his job. That is his job. It's just I'm gonna notice. I'm gonna notice when you're like, no, and it's just like, no, that's too far. That's too far. Like, yeah, you could say you have a public opinion poll that shows that the opinion is being affected and that there's people that already think he's guilty and stuff like that. None of that is untrue. Like, why do you have to try to turn it up to 11 and just take it too far? It's not every single story. Oh, well. How are you guys at? I see we got some new members coming through. KPH 500, welcome. Allie B from Tennessee, welcome.
Allie B in Tennessee.
Lucy Fair, haven't seen you in a minute. Welcome back.
Shout out to Andrea. I got this ready just in case court starts. One lady wasn't even in the state when the crime was committed. She was still jailed and lost her entire life, her house, her job, everything. Wow. Yeah, that's crazy work right there. All right. The Yo-Yo Pro John says this. What happened recently and the guy was in another state, irresponsible police work? Okay, y'all still talking about the facial recognition. Okay, I agree with you. Without Tyler's parents, it could have stayed a mystery. Yeah, I can give you that. Well, I don't know, man. If they had kind of already zoomed in on they had kind of figured out who this person was and that there was this gray Charger involved with it. I don't know if they would have got away with it. They would still, if they were looking at the gray Charger without knowing it was Tyler Robinson, I think they would have still come to the same conclusion. What do you think? Have they said the parents are going to testify? That's a good question. I don't know. Electronic surveillance is a gray area within Fourth Amendment. Right, there we go, case law. The Supreme Court of the United States hasn't really weighed in on it and can be heavily scrutinized in cross-examination if the state uses expert witnesses. Yeah. Oh, is a challenger, not a charger? Okay. See, I said I'm already making mistakes, man. Jay Witt Law School is not doing well for me. Yes, Taylor, I believe he did confess after he was captured. Well, no, he did say that to his parents too. There's some good questions there. Ruben gonna make sure, look, don't be misrepresenting the Challenger and the Charger. Don't you be doing that. The 2-door coupe and the 4-door. Shout out. Court said Charger. I'm just using words, so I don't even know. Neither of them was a Hellcat. That's all I know. Or a TRX. So. All right. We are waiting for. The court has been pretty on time, so I'm feeling good about them. That's true. I like that. Facial recognition software seems akin to lie detector. To me, not reliable as evidence. Good point. He did confess to his furry. You're right. And there we go. DNA is 100% if collected and processed correctly. Now, we're going to talk about that. I'm hoping it'll be today, but I don't know. They're supposed to talk about the DNA, what do you call it, entanglement or something like that, where they had several DNA samples. They were kind of mixed together. So we're going to see. Yeah, Furry Friends is wild work. You think it's 1,000% legit? I'm with that. And that's what I'm saying. I'm hoping that if there's a sworn written confession, dude, just go and fess up and let's go. We got other things to do. Hey, what's going on, Key? How are you, Keisha? Thank you for stopping through today. But the parents said, I'm sorry, but his parents they identified him and not trust me. You know your kids, right? His parents did come through. So, I mean, there's a good problem there. A good problem. There's a big problem there. Yep, DNA is not 100% if chain of custody issues arise. Whew. And that's what I was thinking they were trying to do. DJW was trying to establish chain of custody and show like with the maps and stuff like that. But apparently it's a little bit more than that. But hopefully the chain of custody is in play because I think that would be a slam dunk. All right. What's going on? Kay Shay, how are you? Good to see you back. What'd you say here, Joe? Joe said this. The whole thing is surreal to me. I saw Charlie Kirk speak a few months before this all happened. He came to Faith Forward conference my church was hosting. My wife and I saw him record a podcast. Shout out Yo-Yo Pro John. Thank you so much. That's kind of cool. As Christy said right here. Never thought I'd hear such thing as a furry friends. The world is a crazy place. That's true. All right, it's 12. It's time. Where y'all at? Judge Graff, you gotta get back up. Here we go. The camera's moving. Audio is on. Green hearts in the chat when you can hear. Or maybe not. Audio is not on. Sorry about that. I think the maroon shirt is kind of wild. That is crazy work. I think this proves Candace was 100% correct. Interesting. Okay, hold on. Here we go.
Courtroom. And we're
Green hearts in
looking
chat
at
when
the
you can hear.
Cross-examination of Agent Hull. Ms. Nestor, your witness.
May it please the court, thank you. Good afternoon, Agent Hall.
Good
You and
morning.
I have met before, but just to remind you, my name's Kathy Nestor. I'm one of the attorneys representing Mr. Robinson. So when did you leave the SBI?
The State Bureau of Investigation?
Yes,
March of this year.
March of this year.
Yes.
So you were involved in this investigation from September to March, basically.
Yes.
And your new position at Post, what is your new position?
I'm an investigative sergeant.
So you investigate potential wrongdoing of police officers?
Correct.
Okay. So when you were first brought into this case in September, is it my understanding from your testimony that you were not engaged in any way with this event prior to getting a call after the shooting? Is that correct?
Correct.
Does the SBI on occasion assist other agencies with preparing for big events like this or not? Is that not typically something you do?
Not something that I've ever been involved with, no.
Okay. And what time did you arrive on campus that day?
I believe it was shortly after 1:30.
So approximately an hour after Mr. Kirk had already been removed from the.
Approximately, yes.
Okay. And were you involved in putting up any drones into the air? Were you part of that or were you not
It's
involved?
not, no.
So how quickly after you arrived on scene did you become aware that you were actually going to be in charge of the scene?
I believe it was approximately an hour after, so what would have been approximately 2:30.
So for the first 2 hours, you were not in charge.
For the first 2 hours, I didn't arrive till 1:30, so no.
Okay. And once you came from on high that you were basically going to be in charge of the scene, what was your first priority? What were you focused on?
We were focused on, through our major crimes team and our lieutenant, putting together an investigative team and developing initial assignments and a plan as to what we were going to do moving forward.
And part of that is protecting any potential forensic evidence that may be found on the scene. That's clearly important, right?
Correct.
Preserving the scene, right?
Correct.
But it sounds like that's not really your area. That was more maybe Agent Falmina's area.
Agent Falmina was assigned to process and document the crime scenes. It was my understanding that the known scenes at that time, amid the chaos, had been contained and had been secured by the on-campus officers who were already on scene.
And what's your understanding of what the known scenes were? In other words, the area where there might potentially be evidence that you needed to process.
I know that the amphitheater area was cordoned off and managed as best it could with the number of people that were there. I was also made aware that there was a rooftop area that had been secured and also an area off of the side of that building that had been secured by an officer.
And that building was the Losi building.
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th. Yes.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
It was not. My recollection is that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Okay, I thought you said it was an unfired bullet. And now you're saying it was a
That's correct.
cartridge?
When a weapon is cleared,
Uh-huh.
an officer would make his rifle ready, which would chamber around.
Oh, I got you.
My understanding was that that's how that was accounted for.
So an officer claimed that bullet belonged to him or her?
That's my recollection, is that was how it was accounted for.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
I don't.
Was it a 30-06? Do you remember?
I don't.
Do you know where that bullet is now?
I don't.
Okay. So you had the amphitheater area that had to be preserved. And how far out did that stretch? The entire amphitheater or just the area around the tent or what?
My understanding was the entire amphitheater area was cordoned off, and there were attempts to secure the campus itself with a perimeter of officers who were monitoring or preventing people coming and going.
When you arrived on the scene, were you aware that an individual had been taken into custody?
I had heard that, yes.
Did you ever have any interaction with that individual?
I did not.
And were you advised at any point that that person was no longer a person of interest?
Information was passed down that the individual was not considered to be a suspect in the shooting.
And when was that, time-wise?
I don't recall specifically, but I know I was on campus when I had heard.
So whoever arrested him as a potential suspect got that wrong. He wasn't the actual suspect, right?
Sorry, got what wrong?
That he was the shooter.
The person I believe to be the shooter was not the individual who was taken into custody, correct?
And then was there anybody else taken into custody as a person of interest?
There were several people who were detained for questioning and who were interviewed throughout the investigation.
And none of those people were they were all ultimately cleared by you or somebody connected with you.
Correct.
And were there any other guns confiscated on the scene that day?
There were other firearms that were located on the scene, yes.
How many guns were confiscated that day?
I don't know specifically confiscated, but I know that there was a firearm found in a backpack that was accounted for during the day.
What type of firearm was that?
It was a handgun,
Any other guns that were found on the scene?
not that I recall.
Do you recall an individual named Noah Gonzalez being interviewed?
I don't recall that name specifically.
Let me see if it refreshes your memory that he was an off-duty, I think maybe trooper that was on the scene that day and that was involved in recovering the holster. Does that refresh your memory?
I know that a trooper was interviewed having been on scene. I don't recall if it was Gonzalez. I don't recall the name, but I do know there was a trooper that was interviewed, yes.
Okay. And just a moment, Your Honor. And do you recall the trooper that was interviewed saying that there was actually a gun found in that holster?
I do not.
You do not?
No.
Okay. Can we pull up? Exhibit Hole 13 and just show it only to the witness for right now?
Not about the gun? Oh, man, come on.
All right, can we go to page 2 of that report? Do you recognize this report? Have you reviewed it as part of your investigation duties?
I do recognize the report now, yes.
Okay, and this is a report prepared by actually Mr. Davis, who's going to testify later in this matter. Is that right?
Correct.
Okay, and on page 2, this is the interview of Noah Gonzalez. Is that right?
That's what it stated on page 1, yes.
And he's an off-duty trooper who happened to be there that day?
Correct.
And do you see on the second paragraph, does that refresh your memory about whether Trooper Gonzalez believed there was a gun found in a holster in that area of the amphitheater?
Trooper Gonzalez included in his report that there was a gun, yes.
Okay.
What does it matter though?
Thank you.
What does it matter?
Okay. When did you first personally go up to the roof of the Losi building? Do you remember the time of that?
I don't recall. I know it was dark when I went up to the roof, so it would have been later that evening.
And at the time you went up there, there was already crime scene tape that had been placed around it.
There was an officer standing security.
Right. And to your knowledge, as the head of the investigation, did they ever find any bullets or casings anywhere on the Losi roof?
Not to my knowledge, no.
Did they ever find any bullets or casings anywhere around the Losi building?
When you say around the Losi building, do you mean how close? Like immediately around the Losi building?
Correct.
Not to my knowledge, no.
Okay. And then you've been talking a lot about a timeline here that seemed, you talked about it when you were watching the video, but you also talked about the fact that you developed a timeline. Is that right?
Correct.
And can you pull up hole 1, please? I'm pulling up on your screen your report that you prepared. Do you recognize that?
I do, yes.
And what's the date that you drafted that report?
That looks like September 14th. It says date created.
And that's the place where, if you could go to page 2, please. Do you see down at the bottom where you summarize Sergeant Bricker's report listing the timeline?
Yes.
Okay, and so it was actually Sergeant Bricker that prepared the timeline, is that right?
He prepared a timeline.
And you incorporated that into your report?
No, I created a timeline.
You created your own timeline?
Yes.
Separate from the one that's in this report?
Yes, using information obtained in the investigation.
And when did you create that timeline?
Over the course of the investigation, over a long period of time, after a lot of reviewing video and investigative time.
So as of September 14th, Tyler Robinson had already turned himself in to the authorities. Is that right?
Yes, I believe he turned himself in on September 11th.
So prior to the time that Tyler Robinson turned himself in, had you all prepared a timeline?
A documented written timeline?
Yes.
Not to my knowledge. I don't know when Sergeant Bricker produced his specifically.
And isn't it fair to say that as of the moment that Tyler Robinson voluntarily surrendered to authorities in Washington County, as of that moment, you all did not know who the shooter was. Is that right?
We had identified a person of interest, but we did not specifically know who the shooter was at that time.
Okay. And you became aware that Mr. Robinson was voluntarily surrendering how? How did you become aware of that?
That information came originally, I believe, from the Washington County Sheriff to the administration at the control center at the university on the evening of the investigation,
Okay.
or the second evening of the investigation.
All right, we're going to get back to that in a minute, but I just wanted to get the timeline down. All right, now I want to go back to the videos that we've seen and the question that I just asked before, which is it fair to say that nothing about the video of the individual on the roof revealed to you, you couldn't see facial features, you couldn't see what they were wearing, correct?
Of the individual on the roof?
Correct.
I know that there was a meeting to discuss perhaps a pattern on the front of the shirt that was observed when the individual was jumping off of the roof.
Okay, that's fair. But at that time, as of the 11th, before Mr. Robinson turned himself in, you all had not been able to determine that. Is that right?
Excuse me. Determine who he was or
No.
determine distinguishing features?
Determine distinguishing features of the video
Yeah.
of the person on the roof.
Yes, we had a person of interest and those images were released to the press.
You're talking about the ones in the stairwell from the
Correct,
from the parking garage.
correct.
But the video on the roof was not distinguishable. Fair?
That video as a standalone
Yes.
was not, no.
Okay. And in fact, the video on the roof, well, strike that. Is it true that you had some spectators that you interviewed that had gotten a photograph a few seconds before the shooting of someone on the roof?
So I'm not sure I understand the question.
Did you at some point in your investigation collect from two young men who were present at the event a video that they had taken of someone on the roof about 10 seconds before the shooting?
Yes, a video, yes, not photographs. A video was collected from an individual who had a video
And ultimately, some screenshots were taken out of that video. Is that right?
by,
By you?
not by me, no.
Okay. That's fine. It could have been someone else.
Okay.
But did you see the video that those young men took?
If you're referring to the video that is looking north and shows an individual dressed in dark clothing on the corner of the roof,
Yes.
if that is the video, I have seen that video, yes.
Did you review the interview of those young men?
I did not.
Do you know how they described the person on the roof?
I don't know if I read it or if I heard it, but my understanding was they believed it was Overwatch or some kind of a police Overwatch for the event,
Okay.
if that's my recollection.
And do you remember anything specific about the person's build that they discussed when they described the person on the roof?
I do not know.
Okay. There is a portion of the video after the individual jumped off the roof, which we all saw here, where the individual crosses, I believe it's Campus Drive. Is that right?
Correct?
And there's a moment where the individual waits and there's two cars that pass in front of him, right in front of him.
Correct?
And is this the moment where you are submitting that he was holding a gun in his hand?
As across the road?
Yes.
From my observations, would show that he's carrying an object in his hand that's concealed or in a bag, and it is long and has the appearance, based on my training and experience, it could be a firearm.
But do you see a gun anywhere? The actual gun?
In the video?
Yeah.
No.
He said that.
And did anybody that was driving by on Campus Drive that day report to you or any other investigative entity, hey, we just drove by a guy with a gun who was leaving campus and he was standing right by my car?
We did not receive any reports to that effect, no.
Okay. Also, when you were revealing the timeline, exactly how long was there between when the person was prone on the roof and when the shot was taken? Do you recall?
If you would like to replay the video, I can time it for you, but I don't recall. It was my guess, I would estimate between 15 and 30 seconds.
So between 15 and 30 seconds to lay flat, take a shot, and get up and run off, right?
I think you asked how long he was prone. I
Right.
think it took longer for him to crawl into position
Okay.
and then establish a position
Oh.
and then take the shot. He appeared to be in prone for approximately 15 to 30 seconds, but the video would verify that.
Okay. Thank you. All right. I want to talk to you for just a minute about the video that was taken. And I'm not going to get into I'm not going to show it, just so in case anybody's concerned about leaving the courtroom, I'm not going to show it. But there was a video that was taken by Mr. Ty Phillips from behind the individual that was speaking to Mr. Kirk.
Correct?
And it showed like a dead-on view of Mr. Kirk and his parts of his security team. Is that right? And then you also have video that you described that shows the back of the tent at the moment the shot happened. Is that right? Behind Mr. Kirk.
You're referring to the UVU video in the breezeway?
Yes.
We have that video, yes.
Okay. And can we pull up the last video, the last clip, 49?
What's she trying to do?
I want to show you, just you, this clip. That is a little clip from that video under the breezeway that's behind the tent, right?
Correct?
And just to be clear, this area behind the tent would not have been visible to anybody that was on the Losi building. Is that fair?
I can't answer that question.
Well, thank you, man.
Yeah, sure.
And Ms. Nestor, as you're playing this, are you just being cognizant if the sound is on or not?
I don't want the sound. Please.
Okay, I just wanted
not.
to
Thank you for bringing
clarify.
that. Thank you.
All right.
No sound. I just want only the witness to look at it. So can you just watch this clip for just a minute? This one little clip of behind the breezeway at the time of the shot.
That's fine. And so just as a reminder to all the parties, if it's on your monitor, please be cognizant of that. It will not be displayed on the main monitor. Ms. Nestor, you may proceed.
Thank you. Is it playing? Okay. Do you remember that? Does that refresh your memory of what's in that clip?
Yes.
And having reviewed that, at the time the shot was fired, there was no one standing directly behind the tent. Is that correct?
You'd have to show me it again. I wasn't specifically looking for that,
Okay.
but I can answer that question if I can view the video again.
Okay. And just before you do
Somebody
that,
behind the
I think you
tent.
testified before that Mr. Kirk would have been dead center behind that banner. Is that right?
Approximately.
Okay, so what I'm asking is if anyone behind that banner, dead center behind Mr. Kirk, if there was any people standing there. Go ahead.
So there's a videographer on the right side of the tent. And then I can only see as far as the video allows me to, so I can't speak to whether there's anybody out of frame who could have been behind the tent.
But what you can see, is there anyone directly behind the middle of the tent?
Yes, there's a videographer stood behind the tent.
To the right,
Yes, behind the tent.
correct. But directly in the middle of the tent, is there anyone standing?
There's no one stood in the middle behind the tent, no.
Thank you. All right, I want to talk now about the TP. You can take it down off of the screen. Thank you. I want to talk now about the TP USA video that you got. That was the angle that was taken from behind Mr. Kirk while he was talking, looking out at the audience during when the shot was fired. Do you remember that video?
The visual impulse videos?
Yes.
Yes.
All right. Is it true that Visual Impulse provided 4 videos?
Yeah, I believe there were 4 total videos that encompassed everything that they provided to us, yes.
But the one that you showed, that's only one of the 4 that they provided to you?
That one that was shown had a Bates number. It was an item that was provided by Utah County Attorney's Office.
Okay, but were there more that you haven't seen in this courtroom, in this prelim, that you got from?
There's the original footage.
Okay. But were there other angles that are not shown here in this prelim?
Yes.
Okay, that's what I was trying to get to. Thank you. All right. Were you involved when the gun was located in the
No,
forest
man, we back to
area?
that.
I was not involved in the search for the gun, no.
Did you get notice when it was located?
From the footage that we reviewed, we identified an area that we believed could be potentially of evidentiary value. And then it was secured. And then I was notified that as a result of that search, a gun had been located, yes.
Were you involved in the processing of that gun? In other words,
I was not.
boxing it, shipping it, sending it wherever it was going to go to be
I was
analyzed?
not, no.
Okay, thank you. All right, now I want to shift to the autopsy for just a moment. You were not present at the autopsy, is that right?
I was not.
Okay. So anything you know about the autopsy was not from personal observation?
No, other than from my meeting with the medical examiner and his report. No, I was not present.
Did you meet with the medical examiner after he had conducted the autopsy?
I did, yes.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have any reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you or did he learn it from someone else?
It would be my recollection that he did not learn that from us, but I couldn't speak to how he did learn about it.
Okay. So you didn't share with him your conclusions about what happened or how Mr. Kirk was injured or anything like that?
That's my recollection.
Okay, thank you. And isn't it also true that fingerprints that were taken from Mr. Kirk and autopsy photos were provided to you on a CD?
Yes.
Was there anything else provided to you from the autopsy other than that?
Other than the CD and the report?
Yes.
Not to me, no.
You did mention not to you. Were you aware of anything else from the autopsy going to anyone else?
I believe standard practice is anything of evidentiary value that the medical examiner collects is transferred through a chain of custody.
And are you aware of anything that was transferred after Mr. Kirk's autopsy?
I'm aware that there were items transferred for evidence. Yes.
What items?
I believe some fragments of a bullet casing. I know Mr. Kirk's personal items to be returned to the family. That's all I can recall off the top of my
Do you
head.
know how many fragments from the bullets?
I don't.
Now, I'd like to talk a little bit about the Ring camera that you obtained, and you interviewed a woman named Ms. Noble, is that right? To get that Ring camera that we watched with the car on the outside?
Man, she is all
interviewed
over
her
the
to
place.
verify the authenticity of the video, yes.
And were you involved in that interview?
With Miss Noble,
Mhm.
yes.
And do you recall what they told you about what they remember seeing in and around that car that night?
I don't recall. I just know we were there to verify the video. I didn't conduct an interview with Miss Noble at that time.
Okay. Can we please bring up whole? Sorry, just a moment.
She is everywhere. She done went from autopsies to videos and Ring cameras to side characters, side quests. She all over the place.
Let's see.
Hey, yo, make sure you hit the like button, everybody, please.
Whole 48. This is Miss Noble's interview. Do you have it?
What I'm not getting is,
All right. Do
is
you
any
remember
of this
that?
causing
Looking
me
at that
to
interview, does that
second
refresh your
guess his
recollection?
I remember
authenticity?
reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that Ring camera, did you?
I did not.
And did they also tell you there were 3 other people in the car?
Yes, I believe they thought that was the case.
Did he bring up the Ring cameras? I don't remember that today.
I want to go back, if I can, to the scene itself, the preservation of the actual scene where where
preserving
Mr.
scene.
Kirk passed. Did you all have canine dogs at any point that sniffed that area?
Yeah, she's
I
definitely
don't
giving
know
over to
specifically that
conspiracy.
area, but I do know that canines were present, or a canine was present on the day.
But you don't know what task the canine was given?
My understanding was that it may have been used in an effort to track an individual that had jumped off the roof, but I don't know for certain.
And obviously that didn't produce any results, or we would have heard about that, right?
Yeah, not that I was made aware of.
Okay. Do you know when the tent and the stuff was actually removed from the scene?
I don't. I would imagine it had been at least a couple of days, if not longer than that, before anything was removed from the scene.
You didn't have to give permission to remove the tent,
Me, personally?
Right.
No.
so you're not sure when it was removed?
No.
And were you involved in the decision to pave over the dirt that was under the tent?
At UVU?
Uh-huh.
What?
Did you know that happened?
Only because it was in the news.
All right. But you don't know when or who ordered that?
No.
Nope.
And it's true that during the time before Mr. Robinson turned himself,
Hey, I'm going to stop for a second. I know a lot of people are saying that that they need to prepare their witnesses. Let me tell you right now, this dude has got to be prepared, because I'm feeling the desire to give more information well up in me, but he's poised. He's very calm. He's very cool. He's a cucumber. He is not given over, because I probably would have said something. Again, if Jason was this guy, I would have said something stupid. I would have been like, well, you know, when we get ready, when we're finished with the crime scene, we give it back to the, I would have said something ignorant and messed everything up. He is definitely calm and giving answers, very short answers too. He knows what he's doing. So I think this is good, because I would have probably messed this up. I know what I would have did. I would have needed like a whole year to get ready, because I would have been running my mouth, man. I would have just been talking, yapping. Okay, let's go.
Ben, you all received lots and lots of tips from the public. Is that fair?
Correct?
You received tips of death threats that Mr. Kirk had received the day before the shooting. Is that right?
I'm sorry, did we receive threats that Mr. Kirk had received before the event, or?
Let me clarify. That
Thank
was a
you.
confusing question. As you were going through tips that the public was giving you, did you receive tips about online death threats that had been made against Mr. Kirk prior to his death?
There was a huge variety of tips and information and suggestions that were being provided by the public.
Okay. And a lot of those, some of those filtered through you, right?
Some of them filtered their way down to us, but predominantly that was being handled by our State Information and Analysis Center that had been set up.
And you also got multiple tips about potential suspects, people who thought they recognized people in the picture, right?
Yes, there were different calls and information provided by the public.
And you had quite a few of those.
Correct.
And then Mr. Robinson turned himself in, right?
Yes.
And is it your understanding that the individual they used to facilitate Mr. Robinson turning himself in was someone known to Mr. Robinson personally that had been connected to law enforcement?
I know he was known to the family. I don't know his connection specifically with Mr. Robinson, but I am aware that someone was used to facilitate Mr. Robinson turning himself in.
And were you aware that he was one of his Boy Scout leaders? Did you know that?
I think I had heard that at some point. There was a connection. I didn't recall specifically what it was.
And Mr. Robinson, in fact, no police went to go arrest him. He drove himself, or he was driven with his parents to the Washington County Sheriff's Department, correct?
That's my understanding, yes.
And he voluntarily walked in.
That's also my understanding, yes.
And that was the first moment you ever knew his name connected with this case.
Yeah, aside from the image that we had, that was the first time that we had a name of an individual who had taken responsibility, yes.
And did you personally ever meet with Mr. Robinson?
I did not.
And as far as you know, Mr. Robinson did what he said he was going to do. He told the police he was coming peacefully, he was coming with his parents, and that's exactly what happened.
I don't know any of the specifics of how he was arranged to turn himself in terms.
I don't know where this is going either, because I don't think that she's impugning anything that he said. Now, she might have got him over the barrel with that whole, like she was trying to say, like, well, you said you built the timeline, but he riffed off of somebody else's timeline. Hey, yeah, I guess. I don't see where this is going. I'll be honest with you. And like I just said, like, she's bringing up a lot of conspiracies that are out there, and she's literally running them over. I don't know if that's her goal, is to get rid of the conspiracies, get them out of the way, or what. Like, she's doing us a solid by literally demoing every one of these conspiracies that Candace has put out there. I mean, there's quite a few of them that she just literally just ran over. I don't know how they're gonna fix this. I mean, the Candace people, at least. All right, let's get back to it.
In terms of what you've described, I just know that it was being facilitated with the sheriff's office.
Okay. Court's indulgence for just a moment, Your Honor.
Yes.
Get them court's indulgences. Okay, we're gonna move up a little bit. I think we're a little behind.
Thank you, Agent Hall. I tender the witness, Your Honor.
Thank you.
Okay, they're gonna be a,
Redirect by the state.
that was it?
going to go back to a few things that Ms. Nestor asked you about. First of all, the unfired bullet that you referred to.
Oh,
Is
yeah.
your
there.
understanding that that bullet was accounted for?
That's my recollection, yes.
Okay, and it possibly belonged to an officer that could have maybe been clearing his weapon.
Yes, that's what I recall being told about that particular item, yes.
Are you aware of if on the 10th there were police officers present that were actually securing buildings and securing rooms there at UVU?
I know prior to my arrival, it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus. So there was a large rapid response of law enforcement who were actively trying to clear, secure, and ensure that the campus was safe, if that answers the question.
The entire campus?
Yes, correct.
Okay. And what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded, but subsequently specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how are they equipped? Like what type of equipment were they
I
carrying?
believe most officers carry a sidearm, a handgun, and most officers in this day and age are equipped with a rifle platform as well.
When you said
Thank
that
you, SC
it was
Dog.
possible that round was from an officer clearing his weapon, what exactly do you mean by that?
Our standard practice in our department is to carry a rifle cruiser ready, which
I'm
is
sorry?
we carry our rifles in a situation which is called cruiser ready.
What does that mean?
Means we don't have a round chambered. So if an officer deployed with his rifle, he would chamber a round. Once he had done whatever task it was that he was doing in order to put that weapon back, he would eject the magazine and eject the round. Sometimes in doing so, rounds are dropped or not accounted for.
Have you personally done that yourself?
We do that at training, and I've done that in the field as well, yes.
And you're aware of, is that something that's common among police officers in this situation?
I believe for most agencies, that's how they carry their weapons, but I can't speak specifically to agencies outside my own.
Do you have any idea how many officers were dedicated or sent out to clear the campus?
I can tell you I had to park on University Avenue and walk all the way onto campus between hundreds of police cars. So I would say hundreds, if not 1,000 officers, high hundreds would have responded to the campus that day.
Now I'm going to ask you about, Ms. Nestor asked you about your observation of seeing Mr. Robinson with something in his hand. And I think she was asking you about Mr. Robinson just prior to crossing Campus Drive, following the shooting. Do you remember that question?
Yes, I think I was asked whether he had a gun or I had seen a gun in his hand in the video.
And you said that you did see something in his hand?
Correct.
Okay, I want you to go back as far as you can remember. At what point after Mr. Robinson stood up on top of the Losi building and ran across, I believe to the northeast corner, when did you first notice in that video something in his hand?
The first time you can clearly notice he has something in his hand, without a doubt, is when he's on the white triangular portion on the northeast corner of the Losi building preparing to jump. It is very apparent he has an item in his hand.
Okay, and that's based on your observation of the videos?
Correct.
Okay. And is it easier to see in that enhanced video?
The zoomed version of the video makes it a lot clearer to see, yes.
Okay. And then after he drops down off of the roof of the Losi building, is there any time between that point in time and making his way to Campus Drive that you believe you see, again, something in his hand?
As Mr. Robinson lands on the grass, it's almost like he either drops it or goes into a crouched position. And then when he returns up from that, it is again clear that there is some kind of an item in his hand, yes.
Okay. Can you be more specific or describe in more detail?
It
what
appears
that item might
it
be?
appears to be black and it appears to be longer.
Okay. Anything else about that item?
No.
Okay. I believe it was Exhibit 9, State's Exhibit 9 that Ms. Nestor pulled up on the screen. And she had you look at that. And I believe what you looked at was beginning a still image, but then a few moments or a few seconds of that video. And that's the UVU tunnel video. Is that right?
The breezeway underneath the Hall of Flags, yes.
And the view is from behind where I believe you testified that Mr. Kirk was on the other side of what appears to be a banner
Sure.
in that tunnel view.
Yes.
And on the other side of that banner is the tent and then the rest of the courtyard. Is that fair to
Correct.
say? Do you remember seeing the banner
Yes.
in the video? Okay. And
You're referring to the back of the pop-up tent?
Correct, yes.
Okay. Yes.
okay. And do you remember, what do you remember about that banner?
It has some kind of an emblem on it, and it forms the back portion of the pop-up tent.
Is it opaque? Is it transparent? How would
No, you
describe
can't see through it. It's white,
it? Right.
and you cannot see through it, no.
And how much of the tunnel does that banner, I guess if it's opaque, obstruct?
I couldn't say. I'm assuming it's a 20 by 20 gazebo, so it would block out the area of the back of the tent that you can see. You would not be able to see through it. You would not be able to see through it from the audience side of the amphitheater.
And what about the tunnel side of that banner? Can you see through the tunnel side in the opposite direction?
You cannot, no.
Can you see Mr. Kirk on the other side of that banner?
You can't, no.
Okay. Well, we exhibited, or Ms. Nestor had you watch just, I believe, just a brief few seconds of that video. That exhibit is actually much longer than what we just looked at, or what Ms. Nestor had you look at. Is that right?
Correct.
And leading up, and again, I'm referring to that view, that tunnel view of that surveillance camera, leading up to the shot, what's going on behind that banner?
There are representatives, I believe, of TPUSA, but there are representatives of TPUSA. There are law enforcement representatives. I don't know if there's any student body, but essentially people are moving to and fro behind that area. A couple of individuals are retrieving items from a vehicle, but there's consistent movement behind and in that area.
Directly behind the banner?
Correct.
Ms. Nestor asked you about the wooded area that Mr. Robinson entered. Well, Ms. Nestor brought that up, and I believe your testimony has been, between today and yesterday, that you witnessed Mr. Robinson enter a wooded area on at least 2 occasions. Is that fair to say?
Yes, on his second visit to the campus and on the visit where the incident took place.
At least on those 2 occasions, did the wooded area that he entered, were they different parts of the wooded area, or was it the same parts of
They appeared to be the same.
You're aware that a rifle was eventually discovered?
Yes.
And was it your understanding that that rifle was discovered in a wooded area?
It was in the wooded area where we believe Mr. Robinson entered the wooded area, yes.
And that rifle was discovered on the 10th?
Yes.
Ms. Nestor asked you about a variety of tips including threats to Mr. Kirk, I think before the event.
Yes.
And did you follow up on those tips?
After tips have been put through a process and been analyzed and screened, anything that appeared to have relevance to either the investigation or a credible threat was managed by the various entities involved, yes.
Okay. So managed by law enforcement, so.
Correct.
Did you personally follow up on any of the tips?
I don't think I personally did, but I worked closely with people who did.
The point is, I guess, is that those tips were followed up on. Is that fair to say?
To the best of our ability, yes.
Okay. And then Ms. Nestor also asked you about tips, I believe, of people reporting to police that they felt like they knew who the shooter was.
Yes,
Okay. So identities of possible shooters.
correct.
Did law enforcement follow up on those tips as well?
They did.
Miss Nestor, finally, Miss Nestor asked you, she asked you whether Mr. Robinson voluntarily went to the sheriff's office down in southern Utah. Is that right?
Yes,
Okay. And that was a Washington County Sheriff's Office.
yes,
Okay. You understood that he turned him, well, he showed up there voluntarily. Is that right?
correct.
What was your understanding as to why he was showing up there voluntarily?
He had informed, I believe, his immediate family that he had been involved in the shooting and that he wanted to turn himself in.
Nothing further. In the video that we've already talked about, the video where Mr. Robinson stands up and runs across the top of the LoC building, is there, do you notice whether at that point, after he stood up until you see him last, at least in that part of the video, do you notice whether he's walking or running with a limp?
He is not. From the time he left after going over the railing, when we see him on the video move out to the position
Correct.
and then leave the position, there is no longer a visible limp or gait.
Thank you.
Ms. Nestor.
No follow-up, Your Honor.
All right. May Agent Hull be excused?
Yes, Your Honor.
All right, Agent Hull, thank you.
Thank you.
Yeah, that brother there for a while.
All right, let's take a 5-minute break and allowing parties to confer. Court is in a brief recess.
Look, we're gonna give this up. That's what they need to do. They need to say, look, we ready to admit, look, if you take the death penalty off the table, we about to go ahead and fess up. Let's go. I thought that was good, man. I think it's going to be very problematic for Cantifa because those are some very solid. They did a good job of debunking a lot of the conspiracies that they put out there. Him not being there, him walking with the limp, the grainy photos, all that stuff like that. They quashed a lot of it. A lot of it. Hey, what's going on? Hey, man, don't be getting in trouble on our behalf, brother. We appreciate you though, Dominique. Appreciate you, man. What y'all think of? Comment in, let me see. In the chat, go ahead and give me the emoji. Tell me what you think about Agent Hall's testimony. I thought he was great. I thought he was on the money, personally. Oh my gosh. It's already saying that this is all a setup and they're all okay. The woman is insufferable. The woman she's given over to foolishness. Yeah, we don't want, look, I don't want nothing. I guess now you know one thing you can extract from this is how pervasive cameras are. I mean, there are cameras everywhere. I mean, I could only imagine from my house to, I don't know, the Brave Stadium. I wonder how many cameras I come across that they could be able to track me from my house all the way to the Brave Stadium. I thought he got great answers. I agree. I think he did good in his demeanor, especially when answering questions for both sides. Agree. Like I just know I would have probably been yapping. It would have been hard for me to. He's definitely a professional. Let me say it like that, because I would have just been talking. There was a part where I was like, I know I would have said 45 more sentences. I know it. I just got myself in trouble. My own lawyer would have been jumping up saying, object, object. He seemed to answer the same tone, which makes him seem impartial. Yeah. I have not heard that they said it's AI. I have not heard that yet, but I won't be surprised. We need to have a mute Candace campaign. Hey, we're doing that. We're doing that right now. By just ignoring her right now. We whatever. I want to make sure I got my camera ready. I mean, got this ready for that 5-minute break. Big Brother's always watching and listening. Yeah, I think this has been a little bit more interesting than I thought it would be. I'll have to be honest with you. And I think just because they showed the videos, we could see it. It was very clear. It was very interesting. So today was way more interesting than I thought. Jay went, hitting that Japanese. I'd have been talking, man. I would have been talking. Oh, I just know me. I just know I couldn't do it. I wouldn't have. I would have needed, again, I would have needed a whole year to work with the lawyers because I would have been talking. I've been running my mouth. But you know who else has been running their mouth? SC Dog has been running their mouth. Thank you so much for the 10. He says, Jay Witt, thank you so much for all you do and are doing in this matter. We appreciate you showing the court proceedings for us to see. You are more than welcome, friend. Thank you so much for the 10. Thank you for supporting the channel. I appreciate it. Look, these are fun, to be honest with you. The only thing not fun, okay, let me just be honest with you. The only thing not fun is having to sit in the booth so long. I was ready to go yesterday, but I was like, man, you know, Andrea and all these other great content creators were doing like an after show. I was like, look, I got to go outside and get some sunlight before the sun goes down. So that's the only part I hate is that I'm just like, look, I got to go. Peace out. That's the only thing. So, and Friday I had to leave early because I have to go pick somebody from the airport. But I'll make sure y'all know it. Hopefully we'll be done on Tuesday. I'm praying. I mean on Thursday. Or I'll just leave the chat up and y'all just keep misbehaving to behave properly. That's all. What did you say here, Mrs. North Carolina? Keisha, yes, I had to get off. I just hope they don't taint the jury when. See, that's the part. Oh, by the way, shout out to, was it DJW? He dropped that link for me. Here it is right here. And I thought this was interesting. So now granted, it's in legalese, AKA legal understanding, but this is what the preliminary examinations are about. And so particularly in Utah, I'm going to read through it very quickly. What I thought was, because I was asking, like, isn't this information, isn't this evidence going to be shown to the jury later on? So aren't they getting this evidence early and such like that? The burden of proof is preliminary examination. At the preliminary examination, the state has the burden of proof and proceeds first with this case. At the conclusion of the state's case, the defendant may testify under oath, call witnesses, and present evidence. The defendant may also cross-examine adverse witnesses. Probable cause determination. So we are indefinitely preliminary examination. And I did drop the link to this so you can have this as well. So definitely check it out. Probable cause determination. If from the evidence, the magistrate finds probable cause to believe that the crime charge is being committed or had been committed and that the defendant has committed it, the magistrate must order that the defendant be bound over for trial. The findings of probable cause may be based on, in whole or in part, on a reliable hearsay. Oh, there we go, hearsay. Objections to evidence on the grounds that it is acquired by unlawful means are not properly raised at the preliminary examination. So I guess what somebody was talking about, fruit of the poisonous tree, that might not come into the play until later on. Interesting. If no probable cause, then the magistrate does not find the probable cause to believe that the crime charge has been committed or the defendant committed it, the magistrate must dismiss the information and discharge the defendant. Wow. The magistrate may enter findings of fact, conclusions of law, and or order of dismissal. The dismissal and discharge do not preclude the state from instituting, or rather institute a subsequent prosecution of the same offense in their witnesses. The preliminary examination, the magistrate, upon request of either party, may exclude witnesses from the courtroom and may require witness not to converse with each other until the preliminary examination is concluded. And the prosecutor may present the testimony of any relevant witness at a preliminary examination, including the testimony of investigating peace officers. Okay, we heard those. The prosecutor or the defense may introduce through direct or cross-examination the testimony of an investigating peace officer, including the testimony from investigating peace officer on the totality of the details of the investigation of the crime of which the defendant is being charged. All right, so that is, oh, the camera's back on. We gotta move. Camera's back. Hey, thank you, SC Dog. What'd you say here? Don't get your hopes up. Graham Allen said 198 objections yesterday. Put them behind schedule. Yo, that was a lot of objections yesterday. They were going crazy. Was it really 192 objections? Or was that just being too much? Like, hold on. Was it really that many? Because I could go pull up the transcript. Let me go find it real quick. I really hope it wasn't that many. I really believe it was that many. Okay, I'm gonna do the quick and dirty way. We're gonna do the quick and dirty way to find out how many objections there were yesterday. I don't think this is gonna be a good determinant at all, but we're gonna try it. All right. What is my daughter doing in there? All right, all right, so this is yesterday's trial. Oh, we're on yesterday's trial. Let me pull this one in. All right, this is not scientific at all. All right, so I'm gonna go here to the transcript. Let me see, the transcripts are here. It is right here. All right. I'm just gonna search for the word object. Okay, I got objection 82 times. Now, that might be, I think that's probably, because like one objection, sometimes they say the word object several times in that. And this is like even in the beginning. So I don't know if it's 182. That's a lot. 198. I think Graham might have been slightly embellishing, but I love Graham nonetheless. So he's good people. Yeah, that's a lot of objections. That's crazy word. Yeah, that's still a ridiculous amount. Definitely no question, no doubt. All right, so that was yesterday. So let me jump back over to today. They have not started the camera yet. Sorry about that. I thought they had, but they don't have the camera ready yet. So let's go see what Andrea's got going on in the meantime.
Although I will say, you could put like drive-by shootings and stuff like that. A lot of gang violence would probably fit that. But outside of that context, no, you're mostly talking about domestic situations. By far the most common. So, I mean, it is what it is. Different cases are different. We have what we have here. Jessica Rachel, check out the prelim. They had a defense the case. We are watching the prelim right now, so I am not exactly sure what this is referring to. But thank you for your comment and your support. I'm just a stay-at-home juror. Welcome to the channel. I love that name. What a great username.
Stay-at-home juror is crazy. I love it.
Juror. You get to do the fun job that I wish I would get to do someday and probably will never be able to. Jessica Bell writes, first, Mrazek, now him. I need to move to Utah. Mrazek, I know, is the judge from the Corey Richins case, but as I said, didn't watch any of it, so I don't know. I don't know. I am very impressed with what frankly, reading as a very Mormon courtroom. I'm reading this as a very Mormon courtroom. I'm reasonably confident that most, if not all, probably most, probably not all. I don't think Kathy is going to be LDS. She's from the South. She's a transplant. The Californians, I don't think are probably LDS. But the prosecution, definitely the elected. I mean, to even get elected in Provo, I think he's more than likely LDS. The judge, more than likely LDS. We know there have been lots of like little comments throughout the course of the case about like in the motion to disqualify and things like that about, now I'm spacing on what they call like the local Mormon community of your particular church. There's like a name for it anyway. Yeah, doesn't really matter. But that's really my read on this courtroom, is that culture is influencing a lot of what we see, and is very polite, very respectful, very agreeable and cooperative, like trying to help each other. That is something I very much appreciate about the LDS, is how much they support each other. They really, really do. They will show up to check on people that haven't gone to church in 20 years. You know, see if they need anything. You doing okay? You healthy? You need your lawn mowed? If you do, they'll do it. They'll have like church elders show up on the doorstep when your dryer just went out, and they'll come in and fix it for you. Like LDS are really great when it comes to supporting their community. So I feel like that attitude is reflected here. And it's so different from what we're used to seeing with trials, because trials are adversarial. And so we're so used to seeing this just extremely combative, often like deteriorating into just attacking and insulting and all that type of thing. This is just such a fresh breath of fresh air for me. If that's common with the judges in this area, and I'm like, yeah, maybe I need to move to Utah too. Go be a lawyer there. Kyle Cowden, likely a 5.56 maybe a 7.62 by 39 common LEO use for rifles. Yeah, I wouldn't know. I don't know that much about the rifles. I mean, SWAT is really, as far as my experience, it's usually SWAT that has the rifles, at least in my area, at least, back when I was doing
All of us
a
have
lot
them here.
of active trial work, like case trial work. But don't really know much about how it was chambered and stuff like that. Usually SWAT has the rifle but doesn't need to use it, so it just doesn't often come up in the course of criminal cases. So I got to defer to the LEO experts on that one. Lax Forge, she can object to the officer testifying about other statements.
We are proceeding. Mr. McBride.
All right, we're back.
Yes, Your Honor. We intend to call Jennifer Falmuina, but before I do that, I'd move the admission of State's Exhibit 5.1, if I can approach the bench.
Yes. Thank you.
Your Honor, there will be an objection, and we want to be heard on the objections. And I didn't know this was coming now. It could be a lengthy call.
All right. Let me just, do you wish to identify what State's Exhibit 5.1 is?
Yes, Your Honor. Exhibit 5.1 is a self-authenticating 1102 statement issued by David Engelhardt from Turning Point USA.
All right.
And again,
Who's
I say it's a
this?
self-authenticating document. As you can see there, it's got the admonition on page 1. The body of the 1102 statement is there on pages 1 and 2. I would say number 4 is kind of the foundational statement, paragraph 4, but the self-authentication portion is the notary acknowledgement on page 3.
All right. Turning to Mr. Novak.
Thank you, Your Honor. Thank you, Mr. McBride. So the court, obviously, because the court can decide how much of this we discuss in open court, how much we discuss at the bar, so to speak, sidebar. There's initially a fundamental relevance problem with this 1102. There are also there are other issues, but I think that just to help the court parse the evidentiary
Why you talk so
issues,
slow,
we should
man?
start with the relevance. There are sub-issues. There's also a problem under 1102 because if the court looks at the last paragraph of this, Mr. Engelhardt, who is the purported author, refers to himself in the third person. So it's not clear to me who actually wrote this report. And as Your Honor knows, 1102 says that prosecutors are not to assist witnesses in writing their own 1102 reports. That's not my primary concern, although I think it is an important issue because that's what the rules require. But the real question is relevance. And I guess the question is, does the court want me to do the speaking objection? Because the court said no speaking objections. Should we approach sidebar? How does the court want to handle it? The people can move their exhibits into evidence whenever they wish. I wasn't aware we were going to do it at this moment. I'm ready to proceed, but the question is how the court wants to handle these objections. I'm prepared to keep going in open court, but it's what the court referred to as a speaking objection.
No, I appreciate that. As it relates to, well, so here's my question for you, Mr. Novak, as you're, and again, I appreciate your discretion and highlighting that point. Do you anticipate your argument being of the nature that would defeat the purpose of, if the court does not admit this, that you've already let the cat out of the bag with your argument? Or do you feel that you can make your argument without compromising what is in the 1102, so the purpose of if excluding it is still preserved?
I'll go as far as I think we can go, and then we'll just see. I mean, I do think I am not trying to conceal from anybody in the courtroom or the public our concerns about relevance. So why don't I, taking the court's lead, go forward publicly with my concerns about relevance. And if we reach a moment where it feels like further argument may deprive Mr. Robinson of his fair trial rights, we can approach.
All right, we'll proceed.
Okay, so then what I'm going to do is I'm going to point out that this proposed exhibit, which is the 1102 statement of Mr. Engelhardt, is basically 4 paragraphs. The 4th paragraph identifies Mr. Engelhardt, although I say in the third person, as a pastor and as an attorney who was a friend and a counselor to Mr. Kirk and was involved in leadership of Turning Point USA. So that identifies who the author is. Beyond that, it's not really relevant to any of the issues before this court. Paragraphs 1, 2, and 3. Paragraph 1 talks about Turning Point USA's status with the Internal Revenue Service, the purposes of Turning Point USA within the context of the Internal Revenue Code, and sort of what I'll just refer to generically as the goals and objectives of Turning Point USA. And it also then talks in the second paragraph about Mr. Kirk's relationship with TPUSA. None of this is unknown information, that he was a founder, that he was the chief executive officer, that he was the president of the board until his death. So I'm still not sure what the relevance is. And I guess actually what I should say is I don't believe there is any relevance of any of this information. Paragraphs 2 and 3 are, and actually I'm going to preface this. My discussion of this is within the context of the rules of evidence. And there's nothing that I'm going to say here that is meant to derogate, criticize, question Mr. Englehart's beliefs. What he says were Mr. Kirk's beliefs. What Mr. Engelhart says he believes are tenets of Christianity. That's not what we're talking about. What we're talking about is whether this document is admissible in this proceeding under the rules of evidence. Okay. So paragraphs 2 and 3 include not only Mr. Englehart's opinions, and now I'm going from relevance to opinion evidence. It's not clear to me whether it's lay opinion evidence, whether it's expert opinion evidence, but it's Mr. Englehart's opinions about a branch of Christianity, his opinions about a portion of the Bible.
What?
He quotes the Bible.
Why is this an
and
issue?
He talks about Mr. Kirk's religious beliefs. And I could go into more detail, but the court has the exhibit in front of it itself. So none of this is relevant. If the court looks at the information, that is the document which lays out the allegations against Mr. Robinson, when I use the word information, I'm talking about the court document. There are, with respect to certain counts, what Utah Code refers to as a victim targeting enhancement. That is alleged with respect to count 1. It is alleged with respect to count 2. It is alleged with respect to count 7. And may I step away just to get my laptop?
You may.
What are we talking about? And this is what I'm talking about. Shout out to DJW. This is what I'm talking about. We go too far. What does that got to do with anything?
Court knows, but I want the record to be clear. When I refer to the what the information calls the victim targeting enhancement, that's
I feel targeted.
Utah Code section 76-3-203.14, which the code calls the victim targeting penalty enhancement. The information alleges, and this is, I'm emphasizing this, that Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's belief or perception regarding Mr. Kirk's political expression. And I'm going to focus, if I may, the court's attention on two things. One is, whose state of mind are we talking about or whose state of mind is the statute talking about? And what aspect of the victim targeting enhancement is being invoked here?
What are we talking
The
about?
latter is the state invoking Mr. Kirk's political expression, and now I'm quoting the statute, as the personal attribute that the state alleges is the gateway to this penalty enhancement. And if the court will bear with me, because there's a reason why we have these hearings in public, there are various categories for alleging I should say, there are various categories of personal attributes. That's the phrase the legislature uses, which authorize the pursuit of a penalty enhancement. And those personal attributes are listed in the statute A through R. I'm not going to read all of them because the court knows the law, but political expression is subsection K. That is separate and distinct from the personal attribute that the legislature calls religion, which is subsection M. So what we have is an allegation that the personal attribute, which is one of the elements of this enhancement, the allegation that Mr. Robinson selected Mr. Kirk was based on his political expression. That's actually the exact same phrase, political expression, as is in the statute subsection K. The 1102 statement is predominantly about what Mr. Engelhardt describes as traditional Orthodox Christian values that he believes in, that he believes Mr. Kirk believed in. And I understand in today's world that there is a crossover between religion and politics. I think we can all acknowledge that. But the legislature and the information here are focused on political expression. So I'm concerned that the 1102 statement of Mr. Engelhardt goes far beyond the scope of what would be admissible if the state has it to prove that Mr. Robinson targeted Mr. Kirk because of Mr. Robinson's belief or perception concerning Mr. Kirk's political expression. The second element of this is that the victim targeting enhancement focuses on the allegation of what is in Mr. Robinson's state of mind, not what is in Mr. Kirk's views or
What are we
deeply held
doing?
beliefs, sincere religious beliefs. And so the evidence that the state needs to present is not what Mr. Kirk believed or said or what TPUSA stood for. It's what was in Mr. Robinson's head.
Y'all, just go ahead and type, what are we doing in the chat? I have no idea. I have totally lost the plot. I feel like I might have fell asleep. Like, I have no idea what we're talking about. What are we doing here? What is going on?
If anything, about selecting Mr. Kirk because of Mr. Kirk's political expression, because that's the information. So why TPUSA exists, what its founding beliefs are, what its leaders' beliefs are, what Mr. Engelhardt believes Christianity is or is not.
What?
Is not relevant. And that's why we think it should not be received into evidence. There's a second level here, which is
It's about motive.
Mr. Engelhardt's statements about what is in the Bible, specifically Matthew chapter 9. And so I would just ask this court the hypothetical question. If the state asked the court to take judicial notice of a portion of the Bible in order to prove this enhancement, because I can't see where else it fits into this case, I think, if I may, the answer would be no, it's not relevant. So instead, what we have is the state trying to use the affidavit of Mr. Engelhardt pursuant to 1102 to get the court to essentially receive into evidence the same information. It doesn't really matter here.
I think he's
in this
defense, yes.
proceeding
What are we
what
doing?
the book of Matthew says. It doesn't matter what Mr. Engelhardt thinks, and again, I say this with all due respect to Mr. Engelhardt, who I've never met.
Mr. Engelhardt, like, look, what are you talking about? Did I even say that?
Or how
Engelhardt
one
is
reconciles
trouble.
the book of Matthew as he sees it with other views on the topics that are there. I mean, I want to be careful and
I don't know what
not suggest what other views are, because I shouldn't be testifying about.
I don't think you should either.
perspectives, within the sort of the heading of religion. But it doesn't really matter for this proceeding what Mr. Engelhardt's views are, what Mr. Kirk's religious views were, what religious views TPUSA endorses, seeks to encourage others to adopt. None of that really matters.
Okay. All right.
There
None
are
of it matters.
multiple
What are we
opinions
doing?
in this 1102 from Mr. Engelhardt, and it's not clear whether the state has thought about whether it's expert opinion or lay opinion. I happen to think that it's expert opinion that is not helpful to the trier of fact in this proceeding. That's your honor. There is nothing in this that helps the court resolve with respect to the victim targeting enhancement, whether Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's beliefs or perceptions regarding Mr. Kirk's political expression. If the state comes back up here and says, no, it's lay opinion, we still have the question of whether it's helpful to this court, because the court has to decide whether there is evidence of the target enhancement in the way I think I've structured it. So it's not relevant. It's not admissible lay opinion. It's not admissible expert opinion. There are two aspects of Rule 403, one of which I'm prepared to talk about publicly, and one of which I think is appropriately discussed at sidebar, because it does get into undue prejudice. The 403 here is that receiving this document into evidence is going to create confusion. It's going to create chaos.
You think so? You think it's going to be
not
confusing?
by the trier of fact, but by the future jury pool in this case. For this court to make a ruling that Mr. Engelhardt's opinions about religion, about TPUSA's views on religious matters, that Mr. Kirk's views on religious matters are in any way what this case is about, is going to create significant confusion. And even if this court doesn't show the 1102 in open court, or the reporters who are here don't get to see it, or if the public doesn't get to see it, receiving it into evidence in light of the victim targeting enhancement that the state drafted and charged is just going to create confusion. There may be, outside of this case, litigation where
Somebody is typing like a
TPUSA's
maniac.
purposes and its mission and its adherence to its mission
It's not me. by the way.
are important, and Mr. Engelhardt's opinions about that may be important in some other context, in litigation, in public discussions. It's not important here. And when I say important, I'm saying it's not relevant. So there's a 403 issue with respect to confusion. There's a constitutional concern that this type of evidence being sanctioned by the court is going to suggest to the jury pool that this is a case about religion. This is not a case about religion. The state doesn't even allege this is a case about religion. The state alleges one enhancement based on Mr. Robinson's perceptions of Mr. Kirk's political expression. So I'm very concerned that that this document, even being sanctioned by the court as admissible for any purpose in this proceeding, is going to interfere with Mr. Robinson's constitutional right to a fair trial, which I think is a, sort of an umbrella over parts of Rule 403. If at the time, if there is a trial, if Mr. Robinson is bound over, and if there is a trial, and if the state wants to proffer Mr. Engelhardt for some specific evidentiary purpose that I'm missing, then we can engage in that. But it seems to me that it's, again, a mixture of lay and expert opinion, which at this stage is more prejudicial than probative. The other part of the 403 issue we can discuss at sidebar whenever the court's ready.
Wow.
Thank you, Mr. Novak.
Yeah, thank you, Mr. Novak.
And so just to give an overview, what I'm intending to do is address what Mr. Novak has presented, the state respond. I may have some questions limited to what's been presented now. Of course, that doesn't preclude addressing the second portion of that in whatever means is necessary to protect constitutional rights. But we're just focused on this portion right now.
Understood.
Thank you, Mr. McBride.
Your Honor, the evidence is relevant to 2 points. One is to the defendant's motive, which is not an element of the offense, but nonetheless is powerful evidence, persuasive evidence. And 2, it is relevant to the victim targeting enhancement, which has been described and appears in the information. The statement clarifies what Turning Point USA, what Charlie Kirk's business was. And I think as you read this statement, it's clear that Charlie Kirk presented both religious and political arguments and positions in his presentations. And that is what paragraph 3 says, that he engaged others in debate, discussion of traditional family values, Orthodox Christian views on sexuality, marriage, gender, sex, America's founding principles, political doctrines, and so forth. He often spoke specifically and attempted to persuade attendees to follow a mindset rooted in Orthodox Christian and politically conservative values.
Excuse me, Your Honor, can I lodge an objection to Mr. McBride reading the exhibit which we are discussing the admissibility of? And I'd ask the court to strike his statements and admonish him.
All right. So as it relates to reading.
I thought that's what he was doing.
Because it's not admitted into evidence. I will, well, before I do that, let me turn to you about the objection to make sure that you are heard as well.
Yes, Rule 104 requires the court to consider evidence before determining its admissibility. How can you determine whether an exhibit is admissible without knowing what is contained in that exhibit? That's what I'm putting in front of Your Honor, is explaining this is why the exhibit is admissible, because it contains this language that is relevant and probative. I don't know how I can make an argument that something's relevant and probative without saying this is what the exhibit says.
Well, and
I get him. I get it.
And I want to make sure I do see you have a microphone. Go ahead.
Your Honor is not a jury. Your Honor can look at the exhibit and determine for itself whether it's relevant, whether it meets other criteria for admissibility. It's not necessary for Mr. McBride to read aloud in open court an exhibit which
But he wants to.
the court has available to it. I'm not saying that the court shouldn't read it. I'm saying that it's not admissible. I understand that the court has two roles, one under 104 and one as the magistrate, but that doesn't require Mr. McBride to read in open court the exhibit which we are discussing the admissibility of, especially where I have just expressed our concern that the exhibit has a tendency to
He said, I'm gonna
confuse
get
the
this
issues
in here.
case and create fair trial risks for Mr. Robinson.
All right, thank you, Mr. Novak. Any final thoughts before I rule on this specific issue about reading from the 1102 by Mr. McBride?
Yes, Your Honor. I have to be able to argue here. I have to be able to refer to the exhibits. I can't do my job as an attorney without being able to refer to the exhibits. If the court doesn't want this to be in public, then we've got to close this proceeding, but I have to be able to argue the exhibits. I don't know how I can make an argument without actually pointing to the language of the exhibits, unless I want to say, you know what I mean? Or referring to line 13, it's just so cumbersome to do, Your Honor. And I think my job and my duty to my client, which is the state of Utah, and to their right to fairness, requires me to make a good and powerful argument, and that requires me to refer to the exhibit. And I'll submit it with that.
All right.
Okay, let's see.
Thank you to both of you.
Okay, I understood the second guy.
In court, when evidence is being taken, until it's admitted, it doesn't come in. For example, if there's a witness on the stand and one is trying to get a piece of evidence in, that witness cannot read from the document and prior to it being admitted into evidence. And so the court applies that same principle here. However, the difference is, in noting that Mr. Novak was drawing points from this specifically, he mentioned Matthew, I believe, chapter 19, and talking about certain points in here specifically. There is room for it to be mentioned in argument in order for the court to fully consider what's before it. I'm going to sustain Mr. Novak's objection and simply say, if you want to talk about it conceptually, talk about the points, you certainly may, but simply reading from it exactly saying, and I understand, I don't want to constrain either party from being able to make their full argument, but quoting from it in open court, I fear does risk issues to the constitutional rights of the parties. If the parties prefer to go into a closed evidentiary hearing on this issue in order to be unrestrained, and it appears Mr. Novak has requested that for a second portion of his argument, we certainly can do so, because I do not want to put out evidence that is not admitted in open court until the appropriate time, until the court has gone through its decision-making process on whether it should be admitted or not. So to the parties, if you feel you can move forward on this first portion of it, I'm happy to entertain that argument. If the parties feel at this point, at this juncture, that a closed evidentiary hearing is needed in order to fully explore all the issues, I will leave it to the parties, because I don't know your arguments, and I don't want to say constrain you from saying, well, I don't know what you're going to say, but I can't read your minds, and the court will stay in its lane to ensure that it's in the proper judicial role. So
Staying in your lane is crazy.
the objection has been sustained to Mr. McBride in regards to your response, the rebuttal to the argument by Mr. Novak. What is your request?
Yes, Your Honor. I do not believe it's necessary to close this hearing. I would argue against closing the hearing on the admissibility of this exhibit. However, the court needs to rule on that issue before I launch into the fullness of my argument, because I do not want to be admonished for discussing an item that I'm asking to be admitted into evidence in public. So I would ask the court to make a ruling on the closure of the argument about the admissibility of this hearing so that I can make that argument unconstrained. And after that time, after the court rules on that, I will make my full argument.
All right. Well, what I'm trying to do is, you've heard the reasoning of the court. I don't want to constrain you. If you're saying, as you stated, that you want to best represent your client, and every attorney should be doing that, that is your duty. I don't want, if you feel that closing this hearing to the public is necessary in order for you to fulfill your duty, the court will entertain that. But I can't have it both ways. If you want me to close the hearing in order for you to be fully be able to argue freely as you feel you need to, I will entertain that. But I don't want to say, well, I'm not going to close the hearing And then suddenly the issue is, well, I wasn't able to make a full argument. And so do you need a closed hearing to make a full argument to best represent your client?
I think defense counsel is asking to close the hearing so that the argument can be made without the public seeing it. I do not want to close the hearing. I do not believe it's necessary to close the hearing. That's not my motion. I do, however, want to make a full argument that requires me to rely on the evidence and quote the evidence as I have done. That's my position. If I am not permitted to quote the evidence in my argument, then we need to decide whether or not this hearing should be closed. I would oppose closing it, but I do think it's necessary for me to quote the evidence.
All right. Are you able to make your full argument to the best of your ability to best represent your client by simply referring to the paragraphs and to the lines so it is clear to the court what you're talking about? There's no ambiguity without quoting it verbatim in open court.
No, I don't think so.
All right.
Your Honor, if you're going to make a closure ruling, I'd like to be heard before you.
All right. I'll hear from you as well. If you would like to come forward, again, just Mr. Reimer, just stating your full name for the record, for the clarity of the record.
Sure. Thank you, Your Honor. David Ryman again for the news media. We have briefed this issue a couple different times so far. Sometimes there is a misconception that I think is running, particularly through what Mr. Novak argued, that suppression hearings, because the evidence may be suppressed or excluded, or in limine hearings, need to be closed unless the evidence is deemed admissible. That is the opposite of the law. That has been settled since the United States Supreme Court decided Waller versus Georgia. You can see it in Kearns Tribune, which dealt with a preliminary hearing and access to a preliminary hearing where, as you know, and as we've heard repeatedly today, all kinds of evidence is presented at the preliminary hearing that may not be admissible at trial. And so the universe of the public's right of access to proceedings is not limited just to what eventually gets admitted at trial, which, you know, if there even is a trial. And we've cited the court to, you know, numerous cases on this, and I don't have the brief in front of me, and the docket is huge, and I can find it for you if you'd like. But I just wanted to correct the misimpression that the public is not entitled to hear argument and to see evidence just because it may not be admissible. Otherwise, we would never have admissibility arguments in public.
Right.
And I do want to I'll just make one other point. Kearns Tribune also speaks to this. And that is that if you do decide that there's and so let me just make two quick points. To the 403 point, just because evidence isn't admissible is not a basis to close the hearing. There may be a 403 argument. I haven't seen this document. I don't know what's in it. Maybe there is something incredibly prejudicial. You would have to make that decision. I'm at a loss. I haven't seen it. I'm happy to take a look at it and give you substantive argument, but it's the same high constitutional standard that you have to satisfy in order to close it. And then the last thing is just on the scope of any closure. Kearns Tribune speaks, and I know the court is aware of this. If you are going to close it, it needs to be as minimal as possible. And it's my experience, at least, that most of the argument about things in this context can occur in open court. And if you want to have, you know, a closed session or a sidebar or however, you have also done it in chambers. I just ask that it be as limited as possible. Thank you.
Thank you. All right, Mr. Novak, and it appears like, would you like to respond to that before, and then I'll return to Mr. McBride for any final thoughts, and the court will make its ruling.
Well, I just wanted to mention the Utah Supreme Court decision in State versus Archuleta, 857 P. 2nd 234, where this state's Supreme Court reminds us that the First Amendment right of access is qualified, and that what needs to be carefully judged in light of the qualified right of access with respect to preliminary hearing exhibits. That was the issue in State versus Archuleta. is the defendant's right to a fair trial. So
Oh, gosh, come on.
we're in this slightly twilight zone situation where counsel for the media is saying, even if the court has decided that the exhibits are not going to be made available for copying and inspection, and the court may decide that this exhibit is either not admissible or admissible for the court's eyes only, counsel for the media is counseling that the court permit Mr. McBride to read the exhibit verbatim in open court. And that basically defeats all of those principles. So I don't think that's the correct path. Counsel for the media is correct that the court's sealing or closure should be narrowly tailored. And the 403 issue, which we are prepared only to discuss because of the sequencing of things in this case, in this proceeding, we're only prepared to discuss at sidebar, has to do with potential future evidence that the court may receive in this hearing, or it may not. So I'm not going to address other 403 issues in open court. If the court wants to defer this entire exhibit and discussion of it until later in the proceeding, then it may be that part of the 403 argument doesn't need to be at sidebar. And I think we're all assuming that sidebar proceedings in this preliminary hearing are going to be part of the sealed transcript until some later point in time. In other words, it's not sidebar just for the moment. It's because the transcript's going to be sealed. So it very well may be that taking this issue up at a later point in time in this proceeding eliminates the need from our perspective for that 403 issue to be discussed at sidebar, or at what counsel for the media says in a closed proceeding. However, I agree with the court that Mr. McBride can't have his cake and eat it too. If he wants to make his argument and he thinks that his argument requires that he read an exhibit in court, which we in good faith are saying is not admissible, then we need to have a closed proceeding. I'm not asking for a closed proceeding. I was asking the court to caution Mr. McBride not to read into evidence exhibits that are not received into evidence, because that's the same as Mr. McBride testifying.
All right. Thank you. Anything further, Mr. McBride?
Just to note, I have not made my full argument on admissibility. That's all.
All right. All right. I appreciate the arguments by the parties. This is clearly something that's very important to you all and is important for this case, as is every piece of potential evidence. I note that Mr. Novak indicated that receiving this could create confusion for future potential jurors. And that he mentioned that it could suggest to a potential jury pool that this case is about religion. However, what is happening at a preliminary hearing is far different than what happens at a jury trial. The magistrate, myself, is the fact finder. And whether something becomes admissible at trial is far different than what is admissible at a preliminary hearing. The purposes are different, the standards are different, and different steps need to be followed. Something could become admissible at a jury trial, but given the nature of a jury trial, more steps are necessary. Under Rule 1102, one of the major differences is that reliable hearsay is allowed in a preliminary hearing under the Utah Constitution and under the Rules of Evidence 1102. That is far different than what would happen at a jury trial. Taking this into consideration, I look to the information going to the very beginning, whether this is relevant. And as noted by counsel, looking to count one, which is squarely before the court, to determine probable cause at the end of this proceeding. And the court is not weighing in whether it will reach that or not. It's not predetermining anything, but what is before this court under count 1, aggravated murder, which is a capital offense, victim targeting enhancement in violation of Utah Code Annotated 76-3-203.14 sub 2, Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson belief or perception regarding Charlie Kirk's political expression. And so if that was not here, this enhancement, and it also goes to count 2, felony discharge of a firearm causing serious bodily injury. And I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that
Right.
is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus religious expression, that goes into different grounds. But at this point, the court finds it is relevant for consideration, and if for the very least for argument. What the court is going to rule is that the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. That begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about the going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service and the type of business. And so there is grounds for that to occur in order for the court to consider the argument fully and making the determination whether it is relevant and should be admissible. Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court can make its determination whether State's Exhibit 5.1 is admissible or not.
Woo, goodness. That was long.
Thank you. 5.1 is a general explanation of what Turning Point USA, Charlie Kirk's organization, is and was on September 10th. The exhibit describes the events that Turning Point USA holds, talking about at least 200 plus of these events featuring Charlie Kirk as a headline speaker had taken place by that time. That's in paragraph 3, that these events discussed political issues as well as religious issues. Most political issues in the portion I previously quoted talked about gender issues, in particular, gender, sexuality issues, the difference, or the Christian and political view regarding marriage and families and gender identity. And that information is relevant to the motive that we are alleging in this case. And it's also relevant to the victim targeting enhancement, which is in part a motive type enhancement. And the evidence will be introduced through, or we will offer evidence through other witnesses that talks about some of the defendant's statements that indicate his gender persuasion, and that he falls into some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk.
I'm going to say it again. I think the wonderfulness, the beautifulness of this trial, this preliminary hearing, is that they are lining up every one of Candace's conspiracies and obliterating them. Now they are arguing that Tyler Robinson killed Charlie Kirk because he's a Christian conservative, and Tyler Robinson held different views. Nothing about Jews, nothing about Egyptian planes, Mormon bee cults, or anything of that nature. This is, again, I think this is a great, as convoluted as that last little discussion was, I think it was great. I'm looking at Matthew 19. I'm not 100% certain why it's a problem, but I'll look at it again.
Publicly, in front of large gatherings of people, debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses. It talks about that being the inference and the motive that he had, or the inference from that evidence supports that motive.
Oh, I see exactly what it is.
Targeting enhancement, and frankly, motive in general, which goes to identity.
Okay, I see why Matthew 19 is in play. So let me bring it in real quick. Matter of fact, I had some people come at me about this exact same verse. I didn't realize that's what I had to look at it first. It's actually the issue at hand is Matthew 19 verses 3 through basically 5. And the Pharisees came to him and tested him. This is from the ESV, and asking, is it lawful to divorce one's wife for any cause? He answered, have you not read that he who created them from the beginning made them male and female? And he said, therefore, a man shall leave his father and mother and hold fast to his wife, and the two shall become one flesh. So they shall no longer be two, but one flesh. What therefore God has joined together, let no man separate. Actually, I went all the way to verse 6. That's what the issue is. It's the male and female. He made them male and female. Matter of fact, I had, again, like I said, I had the leftists coming at me for the exact same verse. Oh, it looks like you got it too. Yep, there you go. Yeah, that's what it was. So that's why and I've heard Charlie reference it. I didn't know that's exactly what they were talking about. But so back to that point, that's what it was. Shout out. Let's get back to it. Let's go.
For that reason, Your Honor, this exhibit is relevant. I don't see the prejudicial effect, unfair prejudicial effect this would have on the fact finder, whether or not it has, some capability of prejudicing the potential jury pool. I think that's a completely different question. I don't think it does. I think this case has already highlighted the political issues that we're talking about here. And but my job here is to present this case to the court, to you, Your Honor, for you to make a decision. This evidence is admissible for that purpose. Whether or not it's public or published for the public to see is a different question, which I'll submit. The media is very capably represented, and I'll let them make the argument on that point. But I would ask the court to admit this exhibit.
Mr. Novak.
Thank you, Your Honor. For the state to argue that this exhibit says anything about Mr. Robinson's state of mind should be rejected out of hand. This exhibit does not say anything about Mr. Robinson's state of mind, and that's what motive is, and that's what the victim targeting enhancement adopted by the legislature focuses on, is the defendant's perception. If Mr. McBride wants to propose significant redactions to this exhibit so that Your Honor, acting as a magistrate, can consider things that are narrowly tailored to what the information alleges, which is the allegation is that Mr. Robinson perceived that Mr. Kirk had certain political views, that's one thing. But this document talks, and now Mr. McBride, not to be colloquial, has sort of thrown down the gauntlet. This document talks about foreign affairs, political doctrines, America's founding principles, cultural trends, and what Mr. Engelhardt refers to as Orthodox Christian views on sexuality, marriage, and gender/sex. So this document goes way beyond what the state just flagged for the entire world is their view of Mr. Robinson's motive, which has something to do with gender identity, gender ideology, and sexuality. That's what Mr. McBride has just said this case is all about. This document goes way beyond that. And that's why it's not admissible. There may, as I said, be other evidence which Mr. McBride and the state want to rely upon, which they haven't presented yet, and Mr. McBride hinted at that. So I think that it's not admissible at this point in time. I don't think it's relevant in the sense of has a tendency to make a fact of consequence more or less true. That's the definition of relevance. So how does this court go from what the state has to establish, which is motive, or well, actually the state doesn't have to establish motive. Motive is not an element of the offense, but at least with respect to the victim enhancement, according to the legislature, the question is what is in Mr. Robinson's state of mind? The other thing I want to say is that Mr. McBride did not address the admissibility of these opinions. Now, the court talked about 1102, but 1102 doesn't resolve all of the other rules of evidence. It's just a gateway for an affidavit. So what we have in this document are what I think are purport to be untested expert opinions or at least lay opinions. And the question is, under the rules of evidence, is whether this document is helpful to the court when it makes a determination about whether Mr. Robinson perceived that Mr. Kirk had certain political views. So where is the evidence that Mr. Robinson, in this document, that Mr. Robinson was aware of Mr. Kirk's political views? Where is the evidence in this document that Mr. Robinson had disagreement with Mr. Kirk's political expression? None of that appears in this document. There may be other evidence of that we'll have to see, but there's nothing in this document which connects up with Mr. Robinson's state of mind, which is the question in the enhancement. And Mr. Engelhardt cannot, of course, express any opinion about Mr. Robinson's state of mind because he doesn't know him, and because that would be improper opinion evidence under any rule of law. So for a document to be received into evidence that quotes one very narrow piece of religious doctrine, and that involves Mr. Engelhardt's interpretation of what that means. I mean, Mr. Engelhardt at the top of page 2 is basically telling this court what he thinks Chapter 19 means. How could that possibly be admissible in this proceeding? And how could it possibly be admissible for the purpose of this court concluding what Mr. Kirk thought Chapter 19 of Matthew means? So it's not relevant. It's improper opinion evidence. It's definitely overbroad in terms of the evidence that the state is proffering to prove a very narrow point. And it actually doesn't get to that point, which is what was Mr. Robinson's state of mind. It also doesn't say anything that Mr. Kirk specifically said on September 10th that Mr. Robinson may or may not have heard, or anything that Mr. Kirk said before September 10th, specifically that Mr. Robinson may or may not have heard. Nor has the state presented any evidence. And as an officer of the court, I would say I don't think that the state can present any evidence that Mr. Robinson specifically heard Mr. Kirk say a specific thing at a specific time. There are some statements which I think that the state will say are admissions by Mr. Robinson, which reference Mr. Kirk, which we will get to later. But none of those reference specific statements by Mr. Robinson about specific statements by Mr. Kirk on any specific issue that would even make a piece of this relevant. So I'm pretty sure that I've reached that point where anything more I say, I'm going to be repeating myself. And so I'm just going to stop unless the
Amen to that.
I don't. Thank you. Well, I have a question as it relates to political
Right.
expressions. Does religion or gender intersect with political expressions?
Yes.
I think that's a great question, but probably not a question to be answered by me in this proceeding. That's actually a really, really complicated question that the state wants the court to say is a simple yes.
I'm gonna say, okay. I figured out what the problem is. I'm over here trying to figure it out, and I was gonna draw like a diagram. I know exactly what the problem is. It seemed like they were going from yesterday and into today. They were talking about, evidence, like, on top of the building and driving cars and videos of this and those kind of things like that. It seemed very concrete. And then out of the sudden, out of nowhere, I don't know when he did this, but out of nowhere, he started talking about this statement from this guy. And I think we all were like, what are you talking about? We don't know. This is abstract. And to me, that's what the problem is. It doesn't make, I'm like, I thought we were talking about like hard, concrete evidence, not something abstract necessarily. And at the moment, reports and this, that, and the other, and hearsay. But then you got this reading. We don't know where it's from. We kind of missed it. And whether or not they can read it, they can't read it. I think that's what the problem is for me. But I do think that it's 100% relevant. There's no question or argument there, because I think their point that they're trying to make by reading this, which I got to go back and figure out who the guy is that wrote it. Engelhart is, they're trying to point the finger that Tyler Robinson killed Charlie Kirk because of his political religious beliefs, which is totally different than what the narrative that people have been spinning. So I get what they're saying. I just don't think it's, it just seems like it's a weird place to come through. What'd you say? That is irrelevant to meeting the requirements. Wait. He's trying to wiggle around the 1102. That statements use the Bible verses. Are you pushing back on me? I think if you push it back on me, I'll get it. I understand it. But yeah, okay, yeah. I heard that part. That he was with Charlie Kirk. He was a good friend of his. I didn't get his role. I'm sorry, I just didn't hear his role. I might have found it's not landing at all. He's not sticking to landing at all. You missed the dense getting pissed off. Oh, I'm missing it. Uh-oh. I got to get it together. Yeah, to me, I don't think the Bible verses actually need to be interpreted. To me, I think the passage itself says exactly what Charlie believed. And I don't think there needs to be like, you don't need a theologian. You don't need Deacon Whitaker to be up in there. It's there. Just read it. I don't see what the problem is. Oh, Novak is misquoting the rule. Oh, got you. Man, DJW ain't letting you play. You better stop playing with DJW. You better play with somebody else. Novak, you better stop playing because DJW ain't playing with you. He ain't playing. See, that's what I don't think they want, Katie. I don't want them. They don't want it to become very clear that Tyler Robinson despised Charlie Kirk for what he believed and what he stood for. That's it. They want all this other foolishness, you know, maroon shirts and bees and Ninja Turtles, but they don't want it to become very clear. This is an ideological argument, and the LGBT community and the furry community, they had a problem, and the left had a problem with Charlie Kirk. That's it. And I think that's what Candace doesn't want to happen either, but she's not gonna beat those charges. So let's get this finished. Let's pull this back in. And did I pull it back in? What happened, Jason? There it is. All right, let's get finished because they're probably gonna go to lunch in a minute.
Because I don't want to be the expert.
You're not the expert.
I mean, the court's basically asking me to testify. I'm not trying to be flippant. The court is asking me to testify about where religion and politics intersect. And that's a fascinating question. The question here is whether this document, the way it's presented, the way it was written, is admissible under relevance and expert 701, 702 rules of evidence to prove what Mr. McBride says the state, what he acknowledges the state has to prove, which is that Mr. Robinson had a state of mind which was, let's just say, hostile to Mr. Kirk's political expression. And I don't think that this court should be deciding, based on the record before it, where, if at all, politics and religion intersect. That's. I mean, if the court needs to resolve that issue, then the court also needs to resolve the question of which religious philosophy are we talking about?
Well, Mr. Novak, I bring that up because you mentioned it and you said you cited directly to the enhancement. You said political expression, and then you went to the Bible itself. And so it appeared to the court that you put it into play. So I just wanted to get a little bit of guidance from your position. And so that's the reason for the question.
No, I totally appreciate the question. I'm not suggesting, Your Honor, that there's a problem with the question. Any question that the court asks is a question that counsel should take seriously. Sure. The legislature separates in the statute religion and political expression. The state selected the victim targeting enhancement based on political expression only. Now the state wants to I didn't bring Matthew in. The state is bringing Matthew in through Mr. Engelhardt. Sure. I didn't bring the Bible to this courtroom. The state brought it. And that concerns me greatly because the state is turning this into a question of whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
Thank you. All right, anything further before the court makes its ruling? I appreciate the in-depth argument and the passion behind the argument. You are advocating for your clients, and I respect that.
Yeah, Your Honor, I'd just say it provides context for the defendant's state of mind. That's all.
All right, in making this determination whether it's admissible or not, I'm going to start at the beginning, which is this. This is a preliminary hearing. The purpose is to determine whether the state has established probable cause to believe a crime was committed and that Mr. Robinson committed it As it relates to this case, as I turn to relevance, I turn to the information as previously stated, and is this relevant? What is before me? And without indicating my decision on probable cause, because I am not at that point, I'm withholding all decision-making until all evidence is properly before me. And so in this ruling, it is not indicating either direction that the court is heading. However, the court finds that it is relevant as it relates to the victim targeting enhancement, as it relates to Charlie Kirk's political expression. And the court recognizes the argument made by defense in regards to state of mind. And it is because of both arguments that the court finds that the court is ruling that it is provisionally admitted into evidence. And at such point, when it becomes relevant, based off what Mr. Novak has talked about Mr. Robinson's state of mind about Mr. Kirk's political beliefs, then at that point, whether it is admitted or not into evidence will be decided upon. So as of right now, it is provisionally admitted. Because of that stance, it will not be published to the courtroom or media, but both parties can weigh in on that when this is brought up again and the request for it to be fully admitted is made by either party. Then the court will re-examine whether it should be published at that time to those in the courtroom and to whether that is displayed or filmed by the camera. All right, let us proceed. Well, let us proceed to lunch because it is now 12:40. It seems like a natural place to stop. I believe everyone looks like they need a lunch break. So let's go ahead and break for lunch. Let's come back at 1:15. Well, I need to give you a full lunch here. I need to do my lawyer math and see what that would bring us to. So it's 12:40. Let's come back at 1:45 for lunch. All right. Any party need the benefit of the record before we break for lunch?
Not from the state, Judge.
No, Your Honor.
All right. Court is in recess until 1:45.
All right. Okay. What y'all think about that last little back and forth? What y'all think about that? He's allowing it for now. And by the way, DJ, where are you at? DJ W, what do you think is going to happen? How long will it be between the preliminary and the actual court trial? When do you think it'll be? Music Productions. I asked that question yesterday. When this is over with this week, when will court start? I mean, when will the trial start? December, next spring? Hopefully not that bad, but like when will it happen? I want to, if you know or have an idea, let me know. Okay, let's check out Andrea since you're asking about her.
We're following here. Now backpedals. Because he sees he's faced with these kind of extreme choices, right? He can spank Mr. McBride publicly, which is going to make him mad.
Awkward.
And, he's not going to like that. Or you can just cave and let him read this whole document and, like they said, defeat the purpose of having a discussion about whether it's even admissible. So he backpedals to try to find this middle ground of, well, you can't read the whole thing, but you can read pieces. That would be okay. It's not okay. It's not okay. You don't get to just partially in a way, it's kind of worse to read part of an exhibit that's not admitted into evidence, because now you get to be selective and you get to be misleading to the extent it's not in context. But he's gonna back away because Mr. McBride has put his foot down. Okay, well, I'll let you quote some, so we don't have to have the closed hearing, because I do think the media lawyer makes very good arguments. The judge Judges paid attention to the media lawyer like throughout this entire case. So he finds the middle ground. He gives this concession. Yes, you can quote a little bit, even though like that's probably not right, could be problematic. And so then what does Mr. McBride do? He takes that and makes his argument without quoting from the document again, like we all knew he could in the first place.
Okay.
There's like a psychology going on with this interaction that I would love to study. how this went, and just from the conflict resolution standpoint, how that worked, because it did. Everybody got what they wanted, other than us who want to see the thing who haven't gotten to see it, but that's just a yet at this point. But everybody got what they wanted, right? Mr. Novak got what he wanted. Mr. McBride didn't read from the exhibit. Mr. McBride got what he wanted. He didn't get spanked.
Is this on?
They got there. That was quite a thing to behold.
I thought it was
Personally,
interesting.
I enjoyed that.
So I like Andrea. Andrea is of course, a lawyer, and she does LawTube, of course. And the question was why are we watching her? We were watching her because I wanted to hear her assessment of it. I'm a pre-K law student. I don't know a thing. I have no idea what I'm listening to, watching, and such of that nature. So I wanted to bring her on and hear what she had to say about it, and make sure that what we were understanding was, of course, what was actually happening. And I think I got it. So that's why. So that's why I went to. Did you give me some lunch? Lord have mercy. Lord have mercy. My child. Y'all pray for me. Oh, what did you say here? Why not read the whole thing in pieces? That's what I do, because some of the pieces that they were reading had statements in there that Novak, is that his name, Novak, was saying would prejudice and create this idea that the trial was against, even though I believe it's true, but the trial was a religious trial, not a ideological or just really like a religious trial. That's what he wanted. He didn't want it to become that by reading Matthew chapter 19 and some other things. That's kind of what I understood it. So it's complicated. It was complicated for sure. Oh yeah, for sure. Andrea is a very smart content creator. And actually, when I end my show tonight, I tell everybody to go over to Andrea's, because she does like an after party and a recap, and she does a great job. She's going to explain it quite well, and I think you're going to get a lot from it. The whole goal, 60 fixer is to just keep adding value, and Andrea adds great value. So
Thoroughly, I understand. I understand everybody else's kind of annoyance and trepidation and so forth, but I really enjoyed that little interlude that we had. And I get the points.
I like this
I get
question.
the points, and I don't think that this is a frivolous objection. I think that is very valid. The statute specifically distinguishes between these two things. But I also appreciate it's hard to do that in practice. In reality, there's always going to be overlap. Of course, especially for somebody who is a high-profile political speaker and influencer who has religious beliefs. Of course, there's going to be spillover. So, yeah.
Oh wait, hold on. I put Andrea's link down in the description, but I'm also going to drop it here. But Andrea's link, well, let me double check while I'm sitting there patting myself on the back. It's supposed to be in the description. When I set it up this morning, I remember setting it in there. But anyway, I just put in the link right there for you as well. Shout out to Nikki. There it is right there. All right, let's keep this dance going.
I don't mind. I don't mind having the late lunch as a result of that. Let's get through some of your guys' comments and questions and stuff, and then I will do my step away. Do need to check the trees because we are having a heat
trees.
wave setting in today. So I need to take a little bit extra time in case I have to spend a while watering out there. Oh yeah,
These
this what
bonsai trees
was
is
up,
crazy.
when we went back into section. She can object to the officer testifying about the other statement, like the coroner report, but we'll have the same officer testify to a trooper on cross-examination. Yeah, I mean it's classic. Of course it is. You know, of course
Classic.
it is. That's the fun of lawyering. If you're not real concerned about principle, then you don't have to be consistent. It's just going to be what benefits you in that particular argument. Mara W8658, really hard for defense attorney to explain away the fact that he turned himself in before any suspect was identified. Why would a random not guilty individual do so? They're going to have to explain it if they are going to argue factual innocence or make a case for factual innocence. Even just a reasonable doubt case, you know, nothing affirmative that they're presenting, not, you know,
Mhm.
alibi
That's a
or
good
anything
catch.
like that. They can go through and point to like there's another bullet in a crowd and a lot of people hated Charlie and lots of people had motive and stuff like that. Okay, but you still have to explain the totality of the evidence. And why did you think you were guilty? Why did you think why did you think it would be a good idea to go to, why did you think the police would be interested in you? It's going to be hard to explain and not impossible. I mean,
That's gonna be very interesting.
very few things I think are impossible to come up with some explanation. It's just that it's, you know, it's got to be plausible. Preferably it's got to be strong, and a really strong explanation for this seems hard to imagine. The best thing I can think up that I can think of that they, you know, might go with, just a possibility, would be that once his parents contacted him with, like, you know, the gun, the father had asked to, you know, ask for him to send a picture of the gun and he didn't respond to that. And then his mom wanted to know where he'd been, and he lied about where he'd been, you know, said he was homesick. And then of course the photograph
Hold on
came
one
out,
second,
and they thought it looked like.
Okay, hold on. What did you say? Vanessa said this. Jason, you're missing the point. Find the loophole. The judge said he couldn't read it in total, but he could read pieces of it. He never said what pieces. Got you. I got you. And that's what I think Andrea was pointing out as well, that Vanessa, and thank you for the 5, by the way, that he ended up reading it in pieces and was able to make his point without actually reading Matthew chapter 19. To me, again, that's why I'm not a lawyer at all. I'm a pre-K law student at best, because I would have, to me, that made sense. The argument that just let them read it made sense, but I understand what they're trying to do. So I think I got it. I hope I got it. What'd you say here? I think the judge is mentioning to not read the Bible verses. Right. And so he still did it without, I'm sorry, he read it in pieces, like she's saying, like Vanessa said here, and didn't read the scriptures. So, yeah, we'll have to see how it all plays out. All right, let's see how Andrea finishes this up. I don't know. I don't think it's they probably will, Nikki. And if I had to make a guess, they probably will testify. I don't know why, but it could be, you know, it could be because they're going to talk about what they saw, why they chose him to come in, why did they bring him in before he was determined to be the person of interest, before they knew who it was. You know, I can see why they did that, why they might testify. Okay, let's get done.
Those are the things I remember from the legal documents in the case. So he could think like, well, it was, even if it wasn't me, enough people were going to start to think it was me, that the police were going to be interested in me. And so I just went ahead and turned myself in to try to get ahead of it.
That makes perfect sense. Perfect sense. I always turn myself in
It's an
when I'm
explanation.
guilty, when I'm innocent.
Is it
There he is.
plausible? Hey, it depends on a lot of other stuff, like how good is their evidence, all these other things, the corroboration, location data.
He looking
DNA,
cooked in my end.
on top of the video, top of the statements, all of it.
He looking
I
cooked.
think it's going to be tough to sell, and that's why I think they're anticipating. It's good mitigation, but really, really incriminating as it goes to guilt.
Okay,
Your
thank
gal
you, Andre.
PJ, the insensitive phrasing that she is using was his exact wording during his testimony yesterday. I don't think she's doing it on purpose. His testimony yesterday was dead center. And she did use that a couple of times as well. The dead center.
Dead
which is
center.
really
Yep.
good.
She did
But
say that. I heard
she
that.
had her own. She had her own creative one. Let me find what it was.
What's going on,
Sorry,
K-Dub? Grace and
Kathy.
peace to you, friend.
The dead on view.
Yep, I heard that one
The
too.
Ty Phillips video showed a dead on view of Charlie Kirk and the security team. I can't say I've never used words that maybe on reflection could come across as a little bit tasteless. I'm sure we all have. And as you point out, the witness did too. But it wasn't just a quoting the witness back to him. It was also like some of her own. It's not the worst sin in the world, but I'm just, I am going to notice it like, ooh, that's just a little cringe. Mara W8658, does it hurt the mitigation case at all to be seen laughing in court during a murder trial? That's going to be up to the jury. They get to take into account his demeanor in court and stuff like that. So it's kind of an individual thing. I know this is going to it's going to sit very badly with a lot of people. It doesn't so much to me. I talked about this when I was on the Charlie Kirk show last night.
Where is it?
From the defense lawyer's perspective, their main priority is their client's comfort and well-being, whether he's guilty, whether he's innocent.
Hold on, I'm gonna refresh this real quick. I don't.
To the question that's
There we go.
That's before the court. As far as defense saying their client is innocent, no, that's not common. It's not common, and in fact, that's why it catches my attention when they do. When an attorney goes out on a limb for a client like that, I take that very seriously, because you get burned by clients so many times over the course of a career as a criminal defense attorney. Just like people lie to their doctors. They lie to their lawyers all the time. All the time. Oh, there's no way they're going to be able to prove X, Y, and Z. And they literally like have you on video doing it, and you know it. Like you wave at the video or something. I mean, it happens all the time. So to stake your credibility and your discernment on a client's innocence, you really, my opinion, my view, you got to be really convinced. You got to be really convinced. You could still be wrong, but you need to be really convinced to put yourself out there like that. So it's not common. That's why when Kohberger's attorneys were saying, we firmly believe he's innocent, I'm like, oh, I take that seriously. When Richard Allen's attorneys are saying, I forget the exact words that they used, and so I don't want to misquote them, but basically, yeah.
Shout out to our brother DJW, says his host, your answer on what you just watched lies within Wisconsin and Mitchell, 508 US 476, 1993. Ask AI to give you an Iraq. You know what? I will in a second. I'm in the midst of typing something. I will absolutely do that. Let's finish up how this is going to pan out, though. Thank you so much for that, brother. Thank you for the 5 and supporting the channel.
Guy. I'm going to take that seriously, because it doesn't take many times saying that before you're gonna just look like an idiot. Like there's gonna be obvious evidence that they're guilty, and like you
Facts.
got out in front of your skis making this claim that you should have known better. So no, I'm not holding them to a standard of like they need to say their client is factually innocent, or they need to like assert their own opinion about that. But what I am saying is that you would see in their approach and in their argument and in their representation how they are going to show that he's factually innocent. Right? If he's factually innocent, he didn't do the shooting, then what does that mean? It means he wasn't there. That's a big one.
But he was there though.
And so if he wasn't there, can you prove he wasn't there? There's location data. It's not a Kohberger situation where there's just no data that anybody can use one way or the other. They have data.
Right.
So where is it? The rifle, not his. The rifle's not his. There's going to be people who can testify, yeah, that's not the rifle that Tyler got from his grandfather. They'd be able to present that. And so that's what I mean. They don't have to like, I really don't expect lawyers to come out and say, we think our client's innocent. But you show it. It's clear, even if you don't say it explicitly. And that's what I don't see from this defense team. I don't see steps. I don't see questions. I don't see significant actions taken that would show, no, it wasn't him, because it could not have been him. Everything so far is like, well, it could have been him.
Could have
Maybe it could have been some other things.
been.
That's not a real strong case on factual innocence. Might be a case on reasonable doubt. But that's a tough defense to build when you have this much evidence that you got to poke reasonable doubt holes in. So that is a good question. You got me thinking about all that kind of thing. The Purnell 1799. Andrea, can you, in your awesome wisdom, please comment on they paved over the crime scene? Well, they tore down the King Roadhouse too, remember? And they basically like destroyed the interior doing all of the testing and stuff before they tore it down. This is kind of common, okay? Because this is private property. This belongs to somebody.
Right.
And you don't get to just take somebody's private property away and keep it indefinitely. You have to have a need for it. And so the thing about crime scenes is that time degrades every crime scene. Whether it's, people are kept out of it, the rain and the sunshine is going to degrade this crime scene. In fact, maybe more than a lot of things. Like the environmental factors are huge with things like DNA and gunshot residue and anything like that. So I don't have a problem at all with they paved over the crime scene as long as they documented it.
Right.
They
we go.
met the basic standards, the forensic expectations of what needs to be done to properly document this crime scene. And they did. And so to the extent then, if there's anything that they didn't do that may have been helpful, defense is going to be able to point that out. Oh, they should have brought in LiDAR. They should have, done whatever. I don't know. I don't know what the argument would be. Particularly like it's, if I'm understanding this correctly, it's the dirt under the tent. It's the dirt under the tent.
I don't know where it is.
Seems...
I don't know where it was, but there was an investigator that was asked this question, and he explained that when the authorities swoop in and they take control of the crime scene, there are so many people involved in the searching and categorizing and bagging and tagging evidence that when they give it back to you, they give you back the crime scene, they don't need to come back. So this whole everybody's heart palpitations because they paved where Charlie Kirk was killed. Please understand, if they had left it just green grass, don't you know how many yahoos would have been over there tearing up the grass looking for stuff, as if they were better researchers and better investigators than the researchers and investigators that had been there for 4 days straight and tearing up the grass and so forth. But also remember, think about the people that now you look at this as a place of sadness now, because the grass where Charlie Kirk had been killed. But now it's done. It's no longer there. It's concrete. It's a memorial. They turned it into something else. It's done. It's over with. When they give it back to you, when authorities give it back to you, it's a wrap. It's a wrap. They don't need to come back. They're not going to come back 2 months later like, oh, I forgot to look over here under this blade of grass. It's not going to happen. They've already done everything they need. So if that takes them 4 days, 10 days, however long it takes them to investigate it, when they give it back to you and you know this to be true if you've ever had an event happen at your home. I really wish I remember where the video was. There was a crime scene investigator talking about this, and he talked about when they give you back, they're not going to keep your house indefinitely. If something happened at your house and they have to investigate at your house, they're going to be there for however long, 24 hours straight, right? They're going to be there for 3 days straight. They're investigating. They're tearing it up. But when they give it back to you, they don't need to come back. They might come back and talk to you. They might talk to a neighbor, but they don't need to come back right here with a little magnifying glass like old school Jacques Cousteau or something. Or wait, Mr. Magoo. They're not going to be like that. They've done everything. They got all the physical evidence that they need. So everybody clutching their pearls. Oh, they paved over. What? For what? It was already done. It's a wrap. I just gave the host once you understand the issue. Okay, I'm checking this out in a second. Let me get Andrea back up here, and I will, during the rest break, I will absolutely check that out. Let's go.
Like, relatively speaking, less valuable crime scene, because what's going to be there? Blood.
And what are we going to do with it?
Blood is going to be there.
They're going to already pull that up, though.
It's not in dispute that Charlie died. That Charlie got shot and bled a lot. That's not in dispute. So it's got to be kind of tailored to, well, what do you think you're going to find? What was available? What was of evidentiary value here that they weren't able to get in like the 3 days or whatever that they held the crime scene, which, you know, by the way, is like, yeah, it's a fairly long time to keep the whole thing like secured and people out and everything like that. So no, this does not particularly bother me, particularly in a situation where you're like at a school, at a pub. This is happening on a school facility.
Right.
This involved students were present when this happened. This was a trauma on campus, and it's very common to want to mitigate that. That's why they tore down the King Road house. We don't want these kids to have to be like walking by that house all the time.
King
and it's
Road
just this
house.
constant reminder of that trauma that they experienced when they found out, you know, about that murder, those murders. They don't want people to walk by this and, you know, just constantly be triggered to remember when they were there and watch Charlie get shot. That's not like the most important thing. I mean, you know, if it's that versus getting evidence, of course you're going to get evidence, but it is a consideration. And so that's why, to me, it makes sense. And if there's a problem with something they didn't do, then the defense is going to highlight it and show us how and why it's a problem. But it's just kind of once again, I'm going to wait for them to tell me if that's an issue. In and of itself, it doesn't particularly concern me. Scarecrow 17. I hate how corrupt this all feels. See, we're coming from such a different perspective, because to me, this has like been so clean. I mean, good Lord, go watch the Richard Allen case. Okay. Go get caught
Like,
up
what's
on the
corrupt
Richard
about
Allen
it?
case. if you want to see scary levels of corrupt. Okay. Literally lied about the guy to get a warrant, fabricated some bullshit to justify arresting him, threw him into prison without any prior criminal history, no conviction, threw him into prison pre-trial as a detainee, held him in solitary confinement for 13 months, drove him insane, and then used his insane ramblings against him at trial. Okay, you want to see corrupt.
Wow.
This is like so
Wow.
open
Dang.
and like court process wise, really not sketch compared to that. Everybody's getting an opportunity to make their record, to say what they have to say,
Right.
contribute, to investigate, to get the discovery. Compare 300 plus terabytes of information given to the defense in this case, the open file discovery policy of the prosecuting attorney's office, the absence of any motion to compel, no discovery dispute to date in 10 months of the case. Compare that to what was going on over in Carroll County, Indiana with Richard Allen. It is just night and day. So I have a hard time relating to this sentiment because my perspective is very different. And I don't know if this sentiment is because you are new to cases and haven't seen very many, or if you have seen a lot and for some reason your perspective on this one is you're seeing something that I'm not. I just don't know. I'm not.
Wow.
You know?
I didn't know that about this case she was talking about. That
I
is
don't tell
sad.
people like you're not entitled to feel how you feel or think how you think. You absolutely are. So I'm not saying you're wrong to feel this way. I'm just saying I can't relate to it. It's hard for me to understand.
You by yourself, she said.
Debbie B I see BRZ in there, and then I'm
I'm
lost,
not reading that
and then
though.
I don't know what else to say. Debbie BRZ, sorry, that's who you're going to be for me. But isn't that why Tyler Robinson allegedly did this? I mean,
I didn't
yes
know
and
this
no,
story. That's
right? That's
crazy.
the whole issue with the overlap. It would be much cleaner if the state had just charged him with both prongs of the victim enhancement. I don't know why you wouldn't. I mean, if there's overlap, then make sure you cover both. They
Mhm.
chose to charge the political expression one and not the religion one.
Oh,
but
I didn't
also
get that.
understand
Okay.
the point that the defense is making, and it's this: it's based on Tyler's perception of his beliefs, and Tyler's perception of his beliefs could be totally wrong and off base, but it would still satisfy the victim targeting aggravator because it's based on what Tyler believed his beliefs were. I mean, I assure you, Charlie Kirk and Turning Point USA did not think that they were full of hate. They did not see their positions that way at all. But Tyler Robinson did. Who's right, who's wrong? It doesn't matter. All that really matters is that Tyler Robinson saw it that way, according to him, allegedly, et cetera, et cetera. And so that's why he did it. That's all they need for the victim enhancement. So I get that point by the defense too. It really doesn't matter what Charlie actually believed or thought. But then again, on the other hand, I can see the counter argument that
On the other
it's
hand,
evidence of why Tyler Robinson would think that. You know, it shows what Charlie Kirk was putting out there into the world and into the political arena, the types of arguments and viewpoints and values and so forth that he was expressing. And that would explain, you know, what Tyler Robinson saw, and he interpreted it in a certain way that may or may not be correct, but either way, that interpretation is what motivated the shooting. So I can see both sides of this one. This is not for me like a real crystal clear, cut and dry. I can see both sides of it. Jonathan E. Montgomery, Your Honor, they say my client targeted the victim because my client believed the victim was a Christian. That the victim publicly proclaimed himself as a Christian is irrelevant. What a joke. Well, that's funny. But you can kind of see how in a way it is, right? If somebody believes I'm a Christian and kills me because I'm a Christian, that's justifiable, that justifies the charge, the targeting enhancement, even if I'm not in fact Christian. Just putting that out there. I mean, it's true. Doesn't really matter. At the same time, does it help? I mean, yeah, I can kind of see how it does, because it shows why he would believe that. Why would you think anything about Charlie Kirk's views? Johanna, 81524. I am enjoying the arguments, but I don't get what would be so prejudicial about hearing a pastor's opinion on Charlie Kirk's religious beliefs. Yeah, I think if we see this, we'll get a better idea of what is really upsetting to the defense about it. I'm in the same boat. Like, I'm like, who cares? Like, it doesn't matter. It doesn't matter. The characteristics of the victim don't matter at all. I mean, I get in some limited cases, yeah, it might, but for the most part, no, it doesn't matter.
I knew exactly why she walked that out of
Good
there.
person, if this is a shitty person, it doesn't matter if they believe good things or terrible things, or if they are, psychotic and believe unreal things, delusional things. It doesn't matter. Every human life is sacred and precious and entitled to dignity, period. So, like, who cares what Charlie Kirk thought? It doesn't matter whether you agree with it, disagree with it. He did not deserve to be killed, period. So I suspect, I think Mr. Novak was kind of getting close to saying the quiet part out loud towards the end of the argument, where he's talking about, look at the community that we're in. And that I think is the risk, is the positioning. That's what they don't want. They don't want the state, the prosecution co-opting the side of, we are holy and right and justified and Christian, and this is not. I think that's what they're concerned about. We'll see. We'll see if we get to see the document or not. One more, guys, and then I am going to pause to make sure I have plenty of time to check on my trees. To Truth for Liberty. For probable cause, the base charge without enhancement should be the target decision, because trial would be okay even without enhancement, correct? Well, as the minimum, yes. As the minimum to clear the bar for the prosecution to go forward, yeah, you need to do the crime, and even if you don't get the enhancement, it's not the end of the world. But you have to justify the enhancement for it to be able to go forward and charge it. So, like, they can't not defend it, or not present evidence of it and then still expect to go forward with it at trial, in which case, like, why charge it in the first place? So
Right.
No, it wouldn't end the case, but it would seriously, damage. It would affect their ability to charge and proceed the way that they think the case should. So that's why I think they are so particularly concerned about it. All right, guys, I am going to do my pause and step away. How was the music yesterday? That was, what do they call this one? I'm gonna have to double check. It was like walking the ducks, feeding the ducks, feeding the ducks, feeding the ducks. I love our little sample music we get from StreamYard.
What are you
What should we
talking
try
about?
today? How
All
about
right,
some
I'm gonna.
lo-fi? Some lo-fi. How about some lo-fi for lunch? We'll see, guys. If you hate it,
Okay,
sorry.
I'm gonna let Andrea
I'll be
go
back soon.
tend to her. I think every day she takes a break to walk the dogs and water her bonsai trees. I didn't realize bonsai trees were so temperamental. I did not know that. Okay, so shout out to DJW in the building. All right, so he sent me, asked me to pull up Wisconsin versus Mitchell. And what I did was I put it in my office assistant, which is also known as Chat GPT. All right. And I said, break down Wisconsin v. Mitchell, 508 US 476, 1993. And I said, give me the IRAC. If you're not familiar with IRAC, I'll just jump ahead real quick, give you the spoiler on that real quick. It stands for issue, rule, application, and conclusion. All right, so the issue, here's the IRAC breakdown of Wisconsin Mitchell 508. One of the Supreme Court's leading cases on hate crime sentencing enhancements and the First Amendment. So this will be about where they were kind of, weaving and bobbing and weaving their way to. Wow. So the issue, does a state violate the First Amendment by increasing a criminal sentence when the defendant intentionally selects a victim because of the victim's race? Okay. More simply, can the government punish a criminal more severely because his race was motivated by his crime was motivated by racial bias? All right. Okay. I can understand that. I have a problem with hate crimes, but I mean, it is what it is. So, because I think part of it is the problem is you don't know what this person, we're assuming we know what this person believes or thinks, but that's just me. The rule, the First Amendment protects speech, beliefs, and ideas, even hateful ones. However, states may consider defendants' motives during sentencing. See, that's the part I don't get. Like, I don't know if we have, that's for me. This is just for Jason. I'm not trying to change the law or anything like that. And thank you so much for that, by the way. DJW said you can interchange race with religious beliefs. You're absolutely right. Legislatures may impose enhanced penalties for crimes that cause greater societal harm. A sentencing enhancement based on discriminatory victim selection punishes criminal conduct, not protected expression. Application, facts. Todd Mitchell was watching a movie, Mississippi Burning, with friends. After discussing a scene involving racial violence, Mitchell encouraged the group to attack a white person. When a 14-year-old white boy walked by, Mitchell reportedly said, "There goes a white boy, go get him." The group brutally beat the victim. Mitchell was convicted of aggravated battery. Ordinarily, the maximum sentence was 2 years. Wisconsin had a hate crime statute allowing increased punishment if the defendant intentionally selected the victim because of race or religion, if you want to slide religion in there. The jury found that Mitchell had done exactly that, increasing the sentencing exposure. Mitchell's argument. Mitchell argued the enhancement punished his racist beliefs. First Amendment protects even offensive ideas. Therefore, increasing his punishment because of racial motivation violated free speech. Okay, I can get with that. Okay. However, Wisconsin's argument, the state argued that Mitchell was not punished for speaking. He was punished for committing a violent crime. Okay. His racial motive simply made the crime more harmful. Okay. I can understand that. Shout out. Supreme Court decision. Chief Justice William Rehnquist, writing for the unanimous court, agreed with Wisconsin. The court emphasized several points. The law punished conduct, not speech. Mitchell was punished for committing aggravated battery. His statements were evident of why he committed the assault. The enhancements did not criminalize racist opinions by themselves. Okay. All right. Okay. I appreciate you telling me about this, DJW, because I'm getting it. I'm processing it as I'm reading it. Motive has always mattered in criminal law. One second. Y'all hear my daughter in there talking loud in the kitchen? All right. Judges routinely consider motive when sentencing. For example, killing for money, killing out of revenge, killing because of racial hatred. all may receive different punishments because motive reflects culpability. See, this is the only part, like, I don't know if I understand the motives, though. I feel like I'm assuming the motive. Okay, that's just something I got to work through. Biased crimes create additional harms. The court recognized that hate crimes often inflict greater emotional injury on victims. But see, my only argument is that we are assuming that this is a hate crime. Well, this one is a hate crime. I got you on there. But just because somebody's of a different ethnicity or different people group, it doesn't always mean that they hated the person or it was even based upon that. That's the part I'm a little bit conflicted on, but y'all just pray for me. All right. Provoke retaliation, create fear within entire communities, increase the likelihood of public unrest. Because these crimes produce greater societal harm, legislatures may punish them more severely. What is different from RAV and St. Paul? Oh man, what's RAV? The court distinguishes this case from RAV and St. Paul. In RAV, the government criminalized certain express speech based on its content. In Mitchell, Wisconsin punished a violent assault. The racist comments, or rather racist statements, were merely evidence of motive. Okay. And here comes the conclusion. The Supreme Court unanimously held Wisconsin hate crime sentencing enhancements does not violate the First Amendment. The court reversed the Wisconsin Supreme Court and upheld the statute. Rule of law, one sentence summary. A state may impose enhanced punishments for a crime motivated by racial bias because the enhancements punishes criminal conduct and motive, not protected speech or beliefs. Okay. And why this matters. People cannot be punished. I'm sorry, Wisconsin v. Mitchell establishes this, that people cannot be punished merely for holding hateful beliefs. Okay. So we're saying that Tyler Robinson is not going to be held because he held a hateful belief against Charlie Kirk. He actually did a hateful activity against Charlie Kirk, bringing this about. That's how I understand it. But once they commit a crime, those beliefs may be used as evidence of motive. Like, that's the only thing. Like, how do you know? We got to find something that maybe it'll come up in court. Legislatures may increase penalties for bias motivated crimes because they inflict broader societal harms than comparable crimes without a discriminatory motive. Interesting. All right, here, let me drop this in the chat as well. Hopefully you can use it. I think you can. I'm gonna drop this in there. Y'all can check it out. Shout out to TJW says this. The second case to sum up the Dawson v. Delaware 503 US. Man, brother trying to make me get it. Like, he wants me out here doing this legal search in here. Okay, let's see. He's like, man, you're not gonna sit here and do nothing all day, Jason. You're gonna be looking. You all over here checking this stuff out. Thank you so much for the 5, my brother, by the way. Thank you so much. He said 503. US 159. 1992. That's the year I graduated from high school. Oh, man, you cheating, man. Man, come on, bruh. Come on now. Hold on, man. Come on, man. I gotta play you, man. I gotta play you hard. I gotta play hard for that, man. I'm thinking you over here doing this off the top of the dome, man.
Oh, come on now, dog. Come on, man.
It's an evil world we live in.
Bro, I'm thinking you over here pulling this off the top of the dome. What time are they resuming? They are coming back in 15 minutes. Thank you so much, Jessica. They're coming back it's 3:45 my time, which is 1:45 their time. Well, there we go. Well, good lawyers. Shout out to good lawyers. Okay, where were we reading here? What am I reading here? All right, Dawson. Okay, there's still the IRAC. Okay, so we got the issue, Dawson v. Delaware. Does the First Amendment permit the prosecutor to introduce evidence during sentencing that the defendant belongs to a racist organization when the membership has no relevance to the crime or any sentencing issues. Can the government seek a harsher punishment simply because a defendant belongs to an unpopular, hateful group? Okay, that's the issue. Okay, I can dig it. I can dig it. The First Amendment protects freedom of speech and freedom of association, correct? While evidence of a defendant's beliefs or organizational membership may be admissible at sentencing, if it is irrelevant, the Constitution prohibits using a person's abstract beliefs or associations to increase punishment when those beliefs have no connection to the crime or any legitimate sentencing factors. That's the rule, okay? How's the application go? David Dawson escaped from prison, burglarized a home, and then, deleted a woman during the burglary. He was convicted in the first-degree murder and faced the death penalty. Okay. During the penalty phase, prosecutors introduced a stipulation stating that Dawson was a member of the Aryan Brotherhood, described only as a white racist prison gang. The prosecution did not present evidence that the gang committed the violent acts or the gang encouraged the murder. Dawson's membership motivated the crime or that the murder was racially motivated. In fact, both Dawson and the victim were white. Okay. Dawson's argument. Dawson argued that the evidence served only as a portray him as a bad person because of his beliefs and association. His membership in the Aryan Brotherhood had no connection with the murder, and introducing that evidence violated his First Amendment right to freedom of association. All right, so that's Dawson's argument, Delaware's argument, the state's argument. The state argued that the defendant's character is relevant during the sentencing. Membership in the Aryan Brotherhood reflects negatively on Dawson's character. The jury should be allowed to consider that information when deciding whether to impose the death penalty. Supreme Court's ruling and reasoning, rather. Chief Justice Rehnquist, he's coming back again, wrote in an 8-1 majority, there is no absolute ban on belief or association of evidence. The court emphasized on the First Amendment does not create a blanket rule excluding evidence of a defendant's beliefs or group membership. Such evidence can be admitted if it helps establish motive, intent, future dangerousness, or another legitimate sentencing consideration. I don't know how they got any of those with just because he's a member of that group. But okay. All right. Okay, I got you. Oh, this is what Novak was arguing. Okay, thank you, friend. All right, let's finish this up. The only fact presented was that Dawson belonged to the white racist prison gang. The prosecution failed to show any relationship between the membership and the murder, aggravating factor, or Dawson's future dangerousness because there was no connection. The evidence merely exposed Dawson's abstract beliefs. The Constitution does not allow punishment for beliefs alone. The court concluded that the evidence appeared to have been included, or rather introduced, simply because jurors would find the Aryan Brotherhood morally repugnant. The government cannot seek a harsher sentence merely because a jury dislikes a defendant's ideology or association. Wow. Okay. And then the conclusion. The Supreme Court held that admitting the evidence of Dawson's Aryan Brotherhood membership violated the First and 14th Amendments because it was irrelevant to the sentencing decision. The court vacated Dawson's death penalty sentence and sent the case back to Delaware's court for further proceedings. Interesting. Okay. Shout out to them with that one rule summary. The defendant's belief in organizational memberships may be considered at sentencing only if they are relevant to the crime or a legitimate sentencing factor. So I'm wondering if, like with Tyler Robinson, if his his relationship with Lance Twiggs, will that be like held against him? You know what I mean? I wonder if what that means. Okay, let's keep it going now. The government may not increase punishment based solely on the defendant's abstract beliefs and association. These two cases are complementary rather than contradictory. We got Dawson over here, Wisconsin over here. The government cannot punish abstract beliefs an association, Aryan Brotherhood membership had not proven a connection in the crime, and belief are irrelevant. Over here, we have the government may enhance punishments when the bias motivates criminal conduct. The defendant's racial bias was the motive for selecting the victim, and motive was directly relevant to the criminal act. The key distinction: Dawson protects people from being punished for what they believe, while Mitchell allows enhanced punishment for what they do when those beliefs motivate a crime. Okay. You know what? I think I learned something. Shout out. I can dig that. I can dig that. Thank you, Fred. Okay. Yeah, I think this makes sense. Thank you so much, brother. I appreciate you. DJW, thank you so much. That makes a lot of sense. All right, let me somebody sent me something. Why y'all sending me stuff about bonsai trees? My name is not Andrea. Okay, hold on. All right. We're gonna do a palate cleanse. We're gonna find out about these bonsai trees real quick. Hold on, why is it?
Even branches, especially.
Hold on. All right, here we go.
If you can't keep a bonsai alive or it just seems to stop growing, here's what you do. Every month, you gotta prune it. Trim off some of the leaves, even branches, especially the dead ones. Prune it into a ball shape. As soon as the top layer of soil gets dry, you gotta water your bonsai. And that could be once every 4 days or even every single day. That's why it's important to check up on your bonsai. When you water a bonsai, you gotta water it very slow. Then wait a little bit and then water it again. Bonsais need humidity, so get one of these $10 diffusers and place it next to it. It also helps to mist it every day.
Is that
Follow
intense?
these tips, keep taking care of your bonsai, and it'll go from this, boom, to this. Beautiful and thriving. If you can't keep a bonsai alive or it just seems to stop growing, here's what you do. Every month, you gotta prune it, trim off.
I will not be doing that. I will not. You know, in retrospect, I thought about it. I had a bonsai tree when I was in college, but I was nothing like that, man. That's intense, man. That's probably why I don't have a bonsai tree now. Like that's just too intense, man. All right. Hold on a second. Okay, so here's the other palette cleanse real quick. Just to get something different. It's a little bit different. Shout out to Amethyst Angel for sending me this. I appreciate you, friend. Always keeping me in the loop. We're about to get a bonsai. We're about to get some bonsai treatment up in here, y'all. No problem. What does he say here? Wait, what'd you say, DW? No problem. The craziest case in Utah right now, though, is the bricks. Oh my gosh, yes. I've read about it. I don't fully understand all the ins and outs, but yeah, that bricks minifig case is absolutely crazy. Oh, he said Mormon Mafia. It's crazy. That story is absolutely insane. I can't wait for it to kind of die down so it all makes sense. Because I talked about this on the show. I like Legos. I think Legos are super cool. If it was fun, if it was acceptable for a 52-year-old black man to play with Legos, I probably would. But I'm not going to do that. But that story has been crazy. The little bit I've read and understood has been crazy. All right, let's take a station break. Here we go.
Bonsai is an art form that requires years of training and centuries of dedication. At the 2012 International Bonsai Convention, a tree was on sale for 100 million yen, just under $1 million. And many more of these trees are considered completely priceless. So what is it that makes bonsai so expensive? Bonsai is the art of dwarfing a regular tree to create a perfect miniature representation of nature in a small pot. It has a long history. Originating in China, the practice of creating tiny trees and landscapes appeared as far back as the 6th century. The tree's growth is restricted by years of pruning, wiring, repotting, and grafting, and the plants need to be checked on and often watered every day. The skills required to grow these trees plays a huge part in their value, They're often bent and twisted into shape, positioned around rocks, or even placed with other trees to simulate a tiny forest. Many of these techniques require years to master, and any errors made can result in permanently ruining the shape, or even killing a plant that has been growing for centuries. Chiako Yamamoto is a fourth-generation bonsai master based in central Japan. She's been creating and selling bonsai for the last 51 years, and one of the hardest skills to master when growing these plants is patience.
で、これがこうなってきます。で、これが、そうですね。15年ぐらい経って、これが15年ぐらい経ってできたものですね。ここら辺が、古い木ですね。こういうのが25年ぐらい、それからこういうふうになって作る。やっぱり絵だとかそういうのはもう完成したらそこからは何も変わっていかない。でも盆栽は変わっていくんですよね。それは自分の愛情とか管理で変わっていく。そうやっていつも安定してない、不安定感があるから、安定してないものに自分の愛情をかけて、自分の、で、植え替えしても新しい根を作ったら3年かかる。で、変わるのは5年。だから植え替えしても、植え替えした今年の仕事は3年、5年後に結果が出る。
The time and devotion this process requires is unlike almost any other form of artwork. While the work is almost a form of sculpture, the plants are living things and will always react in their own way.
3年はまあまあ。で、5年になって自分の考えが、答えが出てくる。そうやっていつも変わる。その5年後になんでこんな作り方しちゃったのかなっつって、それは植物生きてるから太陽に向いて好き勝手にこう動いちゃうわけよ。そうすると自分の発想と違う動きしちゃう。そうするともう一回自分の見方をこうやって、あ、これよろしくない。で、いつもそうやって変化していく。その結果がすぐ出ないから、長生きしないと結果が見えてこない。
The extraordinary time this process takes means that there just aren't that many trees around. Some of the most valuable bonsai are over 800 years old, and so the supply isn't going to increase anytime soon.
ただ盆栽は私で4代のように、やっぱり今種まいて次の人に渡す。2代、3代かけて作っていかなければできないので、まあ特に国内どんどん今業者減ってきてるので難しい問題だと思いますね。で、今ある盆栽はかつて明治の頃山取りされたとか30年、40年かけて作った名品が今あるわけ。でも今作られてる名品はあんまりないわけだから、今後それが数が増えていくかってことは。
Other factors can contribute to the cost. The bonsai pots and the tools used are often handmade and can cost thousands of dollars themselves. Certain types of tree are also harder to grow or require certain techniques and may fetch a higher price. But more than anything, these trees are works of art, valued for their beauty and the vision of the artist.
作ってる方から言うと、年月を考えると、皆さんの年収考えたら、すごく安い。盆栽はね。やはり、世界に1個しかない。同じものが2つとない。で、年月が何十年かかる。そういうことで評価をいただけば、高い値段設定もいく。でも、何十年かけたって、その、いいものでなければ評価が低い。そういうふうに、盆栽の値段の評価は、すごくシビアっていうか、その値段の評価を認めてくれないと買ってくれないので、いくらね、年月かけてもダメだし。
I mean, it looked pretty. I don't know if I would be doing that though. Should I buy a bonsai tree, y'all? Is that what I need? Back here, a little bonsai situation going on back here. That would be kind of fun, right? Anyway, shout out to y'all. Andrea is back. I want to hear what she's going to be saying about the rest of the day. So let's bring her in and hear what she's got to say. Andrea, what do you got going on, friend?
Darlene Dunlap, 6693. Does it matter? Ultimately, is he the person responsible for shooting CK? Everything else is noise, in my opinion. Love the coverage, Andrea. Thank you. I mean, it literally just matters for that limited issue of the targeting enhancement, and for that purpose, is it the most important thing? No, it's not. Like, it's I buy that the relevance is pretty minimal, but it's not zero. It's just low. And that's why Mr. Novak, he's bringing up Rule 403. He keeps talking about 403. 403 is a balancing test. That's the test that exists in the rules of evidence. And I mean, pretty much every jurisdiction I've ever seen, certainly the federal rules and everything, that the presumption is if evidence is relevant, it's admissible. But the exception to that is 403. Even relevant evidence can be excluded if its value is outweighed by its potential for prejudice. If it's more harmful than helpful, even if it's relevant, you can keep it out. So that's really what they were trying to show here. And I don't think they really got there, because I'm kind of in the boat of, I'm not really seeing the harm here. Like, I'll buy that it's minimally relevant. It's not relevant, but it is minimally relevant. But I'm just not seeing what the harm is about. All right, we get to see what Charlie Kirk and TPUSA's views are. How is that harmful? I can feel like the gist of it. They don't like the lines being drawn. This side is Christian, that side is not Christian. But that also seems to be a little bit hypothetical, a little bit skeptical. And I think it's also a little cynical. You know, I mean, I'm not a Christian, guys. Wasn't raised in the church. Nothing against it whatsoever. A lot of respect for a lot of the beliefs and practices and so forth. Just not my personal community. But you know, that said, my understanding of Christianity, and like certainly the Christians that I've worked with that I have the most respect for, embrace the sinners. It's literally like not about, you know, I'm the good guy, you're the bad guy, you're damned to hell. It's about embracing the sinner and offering a helping hand. I will always praise. I need to look up the name now so I don't get it wrong, but one of the Presbyterian churches in Walla Walla, they ran the warming shelters in the winter. They ran a prison reentry project. They walked the walk when it came to, you know, ministering the suffering, the sinning, you know, offering the help. And I have so much respect for that.
So my only pushback is that's not what's going to happen. It's not like, look at how embracing Charlie Kirk was. Look how embracing TPUSA is. Look how embracing Christians are. It's Tyler Robinson killed this man because of his Christian beliefs. So it's not going to be, it's going to be in one direction. So is court back on? No, Andrea, no. We still got a little bit of time. I'm waiting though. I got it ready though. So I don't know if it's going to go exactly like that, Andrea. That seems I understand what she's trying to say, but it doesn't work like that.
So I feel like it's a cynical view of Christianity anyway, to think that like, okay, even if somebody is kind of characterized as here as disagreeing, that means they're going to hate him. They're going to want to convict him. I think they would see him as misguided and they would pray for him. That's what a good Christian would do, just based on my experience with Christians. But feel free to correct me because, like I said,
Oh, we're still on lunch. We're still on lunch.
My particular culture, but it's not one that I take issue with. Definitely when it's like I said, walking the walk, very impressive. Base player 2011 IFY. I disagree. The defense opened the door. They could have just said this document doesn't show my client's state of mind, but he didn't. That's fair. That's fair. That is a risk for Mr. Novak, right? He fills the space with his voice. And the problem is the more you talk, the more you might talk too much. And then you say something
Yeah.
that opens the door to something you weren't intending to. I feel like Mr. Novak would benefit in his trial presentation from becoming comfortable with the silence. You really don't have to fill every second.
I can dig that.
Part of the issue is he thinks out loud. He's a very, very smart man. It's very clear. His thoughts go everywhere, but they haven't gotten to their destination and mapped the route by the time, when he's opening his mouth. So it ends up being that like he's talking while
Just
at
say
the
he
same
talks too
time
much,
he's like
Andrea.
trying to Google the location and then like check the directions and then make sure he's not gonna, back into somebody and then so I think that when he is operating off the cuff like this, he's a very organized thinker. It's crystal clear in his writing. Okay, I've looked at a lot of his briefs and things like that. He's a very, very organized thinker. And so when you're off the cuff, if it hasn't crystallized like that, exactly what your logical structure is, I think he struggles with that. So yeah, I think it might help him to simplify, become comfortable with the silence. Because yeah, I can't disagree with this. I mean, I think at least to a minimal extent, yeah, he did. He's the one who brought it up. Now, does that again require Mr. McBride to read from it? I don't think so. Mr. Novak characterized it. You can characterize it your own way too. That's not hard to do. But to the extent this was like, I don't know, this wasn't as bad as like you headbutted me so I bit your ear, but it's the same kind of vibe.
What?
Like,
How did we get
one
there?
of these was more of an escalation than the other, in my view. All right, looks like court is
Mr.
back now.
McBride.
Yeah.
Turning to the state.
I am currently overseeing, or I am the lead over our evidence response team within our division. That includes not only conducting training, but also attending training and whatnot.
Okay. So if we hear ERT, it means evidence response team.
Yes,
Were you called to the crime scene at Utah Valley University on September 10th of 2025?
yes, I was.
And were there multiple scenes that you oversaw or helped to process?
Yes,
We've had some testimony about the rooftop of the Low C Center. Did you oversee or are you aware of evidence that was collected in that area?
yes, I am.
Was there a screwdriver that was collected from that rooftop?
Yes,
And do you know how that was collected and what happened to that screwdriver?
yes, that was collected by the Utah Bureau of Forensic Services Crime Scene Response Team, or also
man.
known as our state crime lab.
And do you know what happened to that?
Yes, it was packaged, and then that evening there was discussion on who would take custody of the evidence, and I was there along with FBI. Then it was decided that FBI would take custody.
And did that evidence actually go to the FBI?
Yes, it did.
And was it sent for testing?
Yes, it was.
Where was it sent? Do you know?
It was sent back to their, I guess, their equivalent of our crime lab.
Are there other areas there at Utah Valley University that were also processed for the presence of evidence?
Yes, there was.
Is there a wooded area that's northeast of campus?
Yes.
What was found in that wooded area?
What was found there was a long gun that was wrapped in a dark colored towel.
And you say a long gun. What does that mean, a long gun?
Sorry, that would be a rifle. So for to be more specific, it was a Mauser 98 rifle.
Do you know what caliber that was?
It was retrofitted to a 30-06 barrel.
And do you know what kind of action that had? Was that a semi-automatic, automatic, bolt
It was
action?
a bolt action.
What is a bolt action rifle?
I'm not too familiar with guns, but I just know there's a bolt and you have to pull it back.
Okay. And what was done with that weapon and that towel?
That was documented in place, and then eventually pictures were taken. It was documented in place, and then afterwards we rendered that gun safe and then packaged the gun as well as the towel.
What was done with the towel after it was packaged?
The towel was also provided to the FBI.
And those two items, well, let me tie up that thread. The gun, what was done with the gun?
The gun was packaged. It was taken to FBI custody. Then eventually it was provided to the ATF lab.
Okay. So the gun went to the ATF lab. Is that correct?
Yes.
The towel went to the FBI lab.
Yes.
And the screwdriver went to the FBI lab.
Yes.
Did you receive reports back from testing that had been done on those items?
Yes, I did.
I'd like to show you State's Exhibit 31. That's connected to the defense computer right now. Is there any way to switch it? Thank you. Okay, I'm showing you here on the screen, State's Exhibit 31. Do you recognize that?
Yes, I do.
What is that?
This is the FBI report that was provided to me by the FBI that documents DNA testing.
And does that include testing that was done on the screwdriver that we've spoken about and the towel that we have spoken about?
Yes, it does.
Okay, what I'd like you to do, Kimberly, if you'd please just scroll down so that Sergeant Falmuina can observe this exhibit. If I can have just a moment.
They haven't said exactly where it was found. They did say it was in a wooded area to the north of the school or something like that, but he hasn't like gotten into the weeds. The weeds.
And can you see who that report is signed by?
Yes.
Who's that?
Amanda Baker, I'm assuming is how you pronounce your last name.
Is that in fact the report that you received documenting the testing results on these items and some other items from
Yes.
the FBI?
Sorry. Yes.
And does it appear to be in an accurate condition as to how you received it?
Yes.
I'd move the admission of State's Exhibit 31.
Defense?
No additional objection.
What? No
It's on
objection?
The standing objection and as it relates to admission, what is your request as to publication?
I'd move this admission and its publication both to the court and to the public.
All right. Anything further, Mr. Britt? All right. The court will admit State's Exhibit 31 into evidence and allow publication of this exhibit to the gallery and to the monitor on screen in the courtroom and for the camera to broadcast.
Okay, if you'll go to, Kimberly, if you'll scroll down to still on page 1 where the screen will show items 7 and 8. Sergeant Falmuina, do you see the lines that say item 7, that line?
Yes.
And will you read that portion of the report that describes what item 7 is?
Item 7, towel from around Mauser rifle, serial number 8863.
And there's also some other identification numbers. Is that the towel that you found with the rifle that day
Yes, it
on
is.
September 10th?
Yes.
Item 8, will you read what that says is a description of item 8?
Item 8, screwdriver from perch.
And is that the screwdriver that you described that was collected from the rooftop?
Yes.
Okay. If we can go to page 3 of 6, please. Will you, item 7, sub 1, will you please read the result there from the title, item 7, until the word contributors?
And would you mind repeating that, but with the microphone? I want to make sure that the record picks up your objection. All right. Either way, if you want to come up, that's fine, Mr. Burke.
Judge, the objection is that her reading to the court, what's in the report is cumulative, since we have the analysts here who will be testifying to what the report says and what it means. So you've got the report in evidence. We don't need this witness's reading the report to the court. So it's a 403 cumulative objection.
Mr. McBride, do you wish to respond?
My point is only to draw your attention, Your Honor, to the relevant results that will be discussed by the other expert, as well as the results of the items we've discussed, the towel and the screwdriver. That's all.
All right. The court will overrule the objection and allow a brief
you knew it was coming.
Overview of it, not going line by line, page by page. So if it is brief, I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes. Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 7 sub 1 and what are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Okay, thank you. A couple of foundational questions before we finish for now. First off, do you know who Twiggs is?
Yes.
Who is Twiggs?
Twiggs is Lance Twiggs. He was a roommate of Mr. Tyler Robinson.
And do you know if Lance Twiggs's DNA was obtained for comparison in this test?
Yes, it was.
And how was that DNA obtained?
It was obtained by law enforcement officers.
And was that by a buccal swab?
Yes.
What is a buccal swab?
A buccal swab is basically like a Q-tip or a swab that we'll just place in someone's mouth and just scrub the inside of their mouth to obtain the cells.
And then that Q-tip is then packaged and sent to the lab for testing and comparison?
Yes.
And was the defendant, Tyler Robinson's DNA, also collected in the same manner?
Yes, it was.
Okay. Thank you. Nothing else.
Right. Mr. Burke, cross-examination.
I'd like to reserve the right to cross-examine after the witness completes their testimony after the following.
Oh, would you mind grabbing the microphone? I just want to make sure what you say is on the record.
With the court's permission, I'd like to
Why you
reserve
carry
the
on
right
them
to
books?
cross-examine on the area she testified about until she's completed her testimony.
Okay, okay, I see what you're saying. Any input, Mr. McBride?
Your Honor, that's what we expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so should I have the sergeant step down or?
Yes.
Okay. Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the party?
Yes, to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right? Thank you.
Yeah, don't be on. She
All right,
can be in the
Mr.
live chat
Bernstein.
though. She can be in the best
Your Honor,
live
out
chat
of
on the
order,
internet.
The defense would be calling Amanda Baker.
All right, Ms. Baker.
I welcome Jen to the best live chat. Tell her come on up over here.
All right, Ms. Baker, if you wouldn't mind coming forward right up here by the bailiff and being sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Whose phone is that?
All right, Ms. Baker, if you wouldn't mind being.
Somebody
seated at the
be in
witness
contempt.
Stand. Once you're situated, there should be a water bottle for you if you'd like behind the monitor. And after you're seated, if you wouldn't mind just pulling that microphone close to you so it picks up your voice, okay?
Okay.
Mr. Burt, your witness.
Your Honor, we're going to need the monitor switched over to our side if we
Okay.
could.
That's a lot of books, right?
While we're doing that, good afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled Bakker.
Ms. Baker, what do you do for a living?
I am a forensic examiner in the DNA casework unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that location?
A little more than 10 years.
And just in general, what are your duties?
My duties are to manage a case. When a case comes into the DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Ms. Baker, in this
Well, that's
case,
what you're doing
were
today,
you
baby.
requested by the state of Utah to do certain testing?
Yes, I was.
And when were you called upon to do that testing?
That was September of 2025.
And do you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit receives evidence for analysis, is it true that the turnaround time is about 200 days?
It depends. We've wavered between 90 days and over 200 days. I would say on average, it's somewhere between 180 and 200 days.
However, did this case come in on what's called a priority one level?
Yes, it did. And what that means is we worked 24 hours a day, 7 days a week until examinations were complete.
And is it true that you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high profile nature of this case, an item of evidence would be submitted to the lab. It would be inventoried by our evidence management group and then sent to the various units for testing. For example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files
Yes, I do.
and document your examination in other ways?
Yes.
Do you have your case file with you?
Yes, I do.
Okay. And in your case file, are there notes of conversations that you have with people that are relevant to your testing?
Yes, that's called our communication log.
Now, do you have your case file there in front of you?
Yes, I do.
I think the pages are numbered. So I'll ask you to go to page 22 of your case file notes.
Okay.
And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication communication entry on September 13th, 2025. All spoke with FBI Special Agent Folger and Utah SBI SA Dave Hull. Gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
And you told them that, quote, Robinson was included as a possible contributor to the DNA from the towel and the screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right. I'd now like to direct your attention, if I could, to exhibit number, State's Exhibit 31, which is in evidence, and I think it's our tab 2. And that's in evidence, so if you could display that on the screen.
Mr. Byrd, are you requesting it to be displayed to just your screens or to all screens?
No, since it's in evidence, Your Honor, I'd like it displayed to the public.
Okay, let's go ahead and put it on the main monitor as well.
Okay, could you go to page 6, please? And highlight the third paragraph. This is your report dated September 15th, 2025, correct?
Yes, that is correct.
So this is 2 days after you had the conversation with the agents as to what your results were.
That is correct, yes.
And in your report that you wrote 2 days later, you included this language that's highlighted there, correct?
That is correct.
This report conforms to the Department of Justice uniform language for testimony and reports for forensic DNA examinations. Correct?
Yes.
Okay. Now, I'd like you, if you could, to take a look at that standard that you referenced. And then I believe is that, and this will be just to the witness, not to the public.
Okay.
Calling up tab 7. Do you see that on your screen?
Yes, I do.
Do you recognize this document?
Yes, I do.
And tell the court what this is.
This document is the approved standards for scientific testimony and reports for autosomal DNA testing.
And is this the document that you were referencing in your report?
One of them, yes.
And is it a true and accurate statement of what the policy of the FBI is in regard to reporting DNA in a case of this type?
Yes.
I move that document into evidence, Your Honor.
So is it just this page or all the pages? Because it says 1 of 6.
Yes, so this would be the entire document.
Mr. McBride?
I don't see the relevance of this document. I object on relevance grounds.
Mr. Burt?
Your Honor, the document is referenced in her report and it defines the parameters of what her opinion means. So I think it's very important for the court to understand the limitations of the opinions being expressed.
And just for my understanding, when you say in her report, are you referring to State's Exhibit 31?
That's correct.
All right, Mr. McBride, any further thoughts?
No, I'll submit it.
All right, so State's Exhibit, well, I'm sorry, how am I labeling this exhibit for the defense?
Your Honor, we have our exhibits organized by witness, and we would be submitting to the court electronic copies of these under named witnesses. So this would be Baker 7.
All right, Defense Exhibit Baker 7 is admitted into evidence. And as it relates to publication, what is your request, Mr. Burt?
Your Honor, I would ask that this be published since the report is published, and this is important to understanding the limitations of the report.
And so published in the courtroom and on the monitor for the media?
Yes,
Okay.
correct.
Any thoughts, Mr. McBride?
No objection.
All right, it will be admitted and published both in the courtroom and on the monitor for the video camera.
Okay, so this document has various subjects, correct?
That is correct, yes.
And it, in the beginning, tells you how to frame your testimony in terms of inclusions or exclusions, mixtures, sex determination, et cetera.
Correct, yes.
And then there's a section called Statements Not Approved for FBI Autosomal DNA Testimony in Our Laboratory Reports.
That is correct, yes.
Okay, so if we could go to page 5 for that statement.
You don't like the judge? Why not? Hold on. The judge been holding it down. I wouldn't want that at all.
Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct. No, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty.
That is correct. It was not.
Okay. And then the next one, not that one more down. Not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a 0 error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a 0 error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
Can you
sorry.
take that down?
Can you clarify your question?
Yeah, when it refers to don't state that there is a 0 error rate, what in general are the sources of error in DNA, in the kind of DNA testing that you do?
A human error could be an error.
Anything else?
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's on. No, not on the big screen.
Okay, so not to go on to this main. big
Correct.
screen.
This is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4, fourth down, one more. No, next one. An examiner, does a policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted in our stated in your report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down. Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
Formal activity level is determining an activity that causes DNA to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some situations, if a piece of evidence has been buried for a long time or is in a river for a long time, it would be my expectation, based on my experience, that I probably won't get DNA off of an item that's been buried for 10 years, for example. However, I cannot give exact timing as to when DNA was deposited on an item.
And I was talking more about a situation where you actually find DNA on an object, be it a gun or anything else. You can't say when that DNA was deposited, correct?
Sure, that's correct.
And how long, in general, does DNA persist on an item? Once you've made contact, how does DNA get deposited on an item in general?
In general, DNA can be deposited a few different ways, via body fluids such as saliva or blood, or skin cells. So touching an item or wearing an item, DNA could be deposited. Once DNA is on an item, if it's subjected to ideal conditions, it's out of heat and high UV, it's not subjected to any kind of cleaning or chemicals, it can persist on an item rather indefinitely. It can degrade slowly over time, but we've certainly worked items of evidence that are 40 and 50 years old, and we've been able to recover DNA.
Now, could you explain to the court the concept of degradation of DNA samples, what that means and what it suggests with your testing?
Sure. So degradation of DNA is breaking up the DNA. So if you think of DNA like a long rope, it's essentially taking that rope and cutting it up into pieces. Seeing degradation in a sample could lend me to believe that there may be, that sample may have been subjected to cleaning or high heat. an extended period of time. So I can't tell why an item is degraded, but looking at my data, I can tell if that sample is potentially degraded or broken down.
And two of the items that you examined were referred to as items 7 and 8, correct?
That is correct, yes.
One was a towel and one was a screwdriver.
That is correct, yes.
Were both those samples degraded to a certain extent?
May I refer to my
Certainly.
data?
Okay, so this is the forensics for the defense. For the defense. She seems like she knows what she's talking about. She seems definitely up to snuff. So shout
So
out.
item 8 was the screwdriver from the perch. I would say that there was some degradation as I look at the DNA peaks or the DNA data. In an ideal world, if there's no degradation, I would expect all the peaks to be at the same height. Here I see a ski slope type effect, meaning that the data on the left is a little bit taller than the data on the right. As far as item 7, item 7 was the towel. There was a slight amount of degradation, but not as much as item 8.
Okay. And what is the effect of degradation on production of the allele? First of all, what's an allele?
An allele is an individual's DNA type. So we inherit half of our DNA from our mom and half of our DNA from our dad. We're looking at something called short tandem repeats, or STRs. These are small segments of DNA that repeat themselves over and over again. We all have those same sections of DNA, but what might differ amongst us is how many times it repeats, and that's actually what we inherit from our parents. So for example, at one particular location, my mom may give me 14 repeats and my dad may give me 15. So when I'm looking at the DNA types, I would say that I have 2 alleles at that location, a 14 and a 15. As far as degradation goes, it could cause some of those alleles to do something called drop out, meaning when I'm looking at the DNA chart or the DNA data, I do not see information. I do not obtain numbers at that particular section of DNA.
And is it true that in the testing that you were doing in this case, STR testing, what you were looking at is the length of the, what I'll call, have you ever heard the boxcar analogy?
I have, yes.
Tell the court what that is.
So the boxcar analogy is how many times that section of DNA repeats. So that section is essentially letters. So for example, A, C, T, G. So you may have A, C, T, G repeated 10 times or 12 times. Each of those sections of A, C, T, G would be considered one boxcar.
And so when you're looking for alleles, you're essentially counting the boxcars. Could be 7 boxcars, and that person would be a 7.
That is correct, yes.
And from the mom and from the dad, he may have inherited 10 boxcars.
That is correct, yes.
And so that person at that particular location would be a 710.
Yes.
And what you're doing in your testing is comparing those numbers to what you get from a known sample to see if they match.
That is correct, yes.
Is that true?
Yes.
Now, is it true that what you mentioned the A, C, T, and G, correct?
Correct, yes.
Is it true that you are not measuring the sequence within the boxcars? You're just measuring the length of the boxcars?
That is correct. So the sequence would be equivalent to letters in a word. What I'm looking at is the number of words versus the letters that make up that word.
And we'll talk about this a little later, but people can vary not only in the length of the boxcars, but in the sequence within the boxcars, right?
And that is correct, yes.
And what your testing looks at is just the length.
Correct, yes.
Okay. Now, for the, and is it also true that you're looking across many different locations?
Yes. So at the FBI laboratory, we use a kit called Global Filer, and this is looking at 21 different locations on a human's DNA, in addition to 3 sex-determining locations. That lets me know if an individual is biologically a male or a female.
as between two individuals, 99% of their DNA is exactly the same, right?
That is correct. And that makes sense. We're all humans. We all have arms, legs, and a head. Less than 1% of our DNA is it differs amongst us, with the exception of identical twins.
But with the within that 1%, you're looking at these length differences, correct?
Correct, yes.
And you're looking at what you called short tandem repeats.
Yes.
How many, you said you looked at 25 locations?
We're looking at 21 and 3 sex type determining, so 24 total.
What are the sex determining? They're called the locus, correct?
Correct. So locus is that individual section of DNA.
Right. And they typically have names or numbers associated with them, correct?
Yes, they do.
So what are the sex determining loci?
So there is amylogenin, and that lets me know if an individual is male or female. And then there's 2 specific male sex determining locations. One is Y-indel and one is DYS 385. Those just let me know that those are specific to male individuals.
Okay. And then for the other locations you're looking at, those you're just looking for 2 types at each location, correct?
Correct, yes.
Okay. Now, for the samples that you looked at, the 7A and the 8A, did you get a full, what's called a full profile would be a profile where you have all 23 locations present?
That is correct. So a full profile means I have DNA at every single location. It is above our threshold, and I'm seeing 1 or 2 pieces of information at each location. For item 7, I did develop a full profile.
For item 8, you developed the full profile?
Item 8 was a partial profile, so I did not develop DNA at every single location.
Okay, so what that means in your comparisons is you have certain information in the question sample that for whatever reason doesn't appear, correct?
Correct, yes.
So you can't make a comparison at those locations.
That is correct.
All right. What makes it not appear at certain locations?
So it could be that there's degradation. So those larger locations could be broken up so that it wasn't detected during the DNA process. It could be a low level amount of cellular material to begin with. So if I only have a few cells, I may not have enough to detect at every single location.
Okay. And for the 8-1 sample, did you measure Mr. Robinson and Mr. Twiggs's DNA at the 23 locations?
For item 8, I did not have a full profile, so I did not have data at all 23 locations to compare it to either Mr. Robinson or Mr. Twiggs.
Right, but you had full profiles for Mr. Twiggs and for Mr. Robinson, right?
For their known sample?
Yes.
Yes. So for their known sample, that was a sample that was taken directly from those individuals, and I did develop a full DNA profile.
Okay. And just to illustrate how this works, is one of the loci that you looked at called the DYS 391 loci?
Yes, it is.
And what type was Mr. Robinson at that loci?
At that location, Mr. Robinson was an 11.
And it's, I think you said you inherit one from your mother, one from your father. But when you say he's an 11, technically he's what's called an 11-11, correct?
So for this, so DYS 391 is actually that male location. So he would not have, or anybody would not have inherited anything from their mother. So at this location, I would only expect to see one piece of information, and I did see an 11 here.
Okay. And for the D3S loci, what was his type?
His type was a 17.
Now for that loci, you'd expect two types, correct?
That is correct.
And when you say he's a 17, do you mean he's actually a 17-17?
That is correct. He inherited 17 repeats of that location from mom and 17 from dad.
Other locations, for instance, the VWA, he's type 18-19, correct?
That is correct, yes.
So you're looking at those, and what the machine produces are peaks, correct?
Correct, yes. They're just spikes on a graph, similar to like spikes on a heart monitor.
And you said for 8A, you had certain locations where the test sample didn't have any results.
That is correct.
So at the TPOX location, Mr. Robinson is a type 8-9, correct?
That is correct.
Mr. Twiggs is a type 8-11.
That is correct.
But when you looked at the sample, 8A, it didn't have any of those types.
That is correct. So I could not compare at that location.
Now, are there certain rules for when you exclude someone? In other words, when you're comparing two samples, are there rules which say, here's where I would conclude that he could not possibly have contributed this sample?
Yes.
Your field has a lot of literature written about it, correct?
That is correct, yes.
And do you generally like to keep up with that literature?
I do, yes.
And across time, there have been several books, publications that attempt to educate you and courts and lawyers on the technical aspects of DNA testing, right?
Correct, yes.
One of the books, the early one, DNA Technology and Forensic Science by the National Research Council.
I'm familiar with that, yes.
That's an authoritative book that was really one of the first books on DNA testing,
Yes.
all right? And then by the same organization, National Research Council, the Evaluation of Forensic DNA Evidence,
Correct, yes.
published in 1996. So you're familiar with that as well.
Yes, I am.
And then there's an author, I believe, who did his research work at the FBI named Dr. John Butler.
Yes, I'm familiar with him.
And you have studied his work both in your training and your continuing education.
That is correct, yes.
And he's got 3 current textbooks on the topic that we're talking about, right?
I'm not familiar with how many textbooks he has. I know at least the one.
Fundamentals of Forensic DNA Typing,
Yes,
familiar with that. Forensic DNA Typing Methodology,
yes, I'm familiar with that one as well.
and Forensic DNA Typing Interpretation.
Yes,
Everybody in your field relies on these publications and use them as teaching tools.
yes, I would agree with that.
And then in addition to those books, there have been studies that have been done on particular topics, correct?
Yes,
This case, we're dealing with mixtures, correct?
yes,
And mixtures present certain challenges that are not present when the samples are not mixed, correct?
not necessarily. So first, to define a mixture, that simply means DNA from more than one individual in a sample. So if I were to take a sip from a coffee cup and my husband were to also take a sip, if I were to swab that coffee cup, I would get a mixture, his DNA and my DNA together. As far as it being difficult, you can have some mixtures where there's one contributor that donates a lot of DNA and the second contributor donates a little bit. For DNA interpretation, that is not challenging for me. Where it can become challenging is if you have 4 or 5 individuals within that sample all donating roughly around the same amount, it may be challenging for me to determine if a person is included or not.
And would you also agree that that challenge exists in situations where you have what are called low quantities of DNA?
Again, that could be possible. So I could have low quantities of multiple individuals, which is simply just saying that I can't determine which piece of DNA goes with which individual. So that's possible.
What is
It's possible.
Drop-in is where you have environmental DNA that's not inherent to that sample that's detected during our DNA process. DNA testing is very sensitive, so it could be that we have a peak that's detected, like I said, from the environment.
And what is drop out?
Dropout is when you have an allele that is not detected or a piece of DNA information that is not detected. So in the DNA chart, there is no number associated with that particular location.
And degradation can cause dropout?
Yes.
So if you have a person at a particular location that is a type 1415,
Right.
and because of degradation, that 15 drops out, what you're seeing on your chart is just the 14, right?
That is possible, yes.
And that presents a certain challenge, does it not? Because if the 15 is not there, you could misinterpret that as a type 1414, correct?
Not necessarily. So we have thresholds. We have something called the stochastic threshold. If that 14 is above that stochastic threshold, I'm confident based on our validation, our testing, and my training that the DNA type there is only a 14. If that 14 falls below that stochastic threshold, that could be indication that there is another peak. So when I'm interpreting, when I'm comparing, if that 14 is below threshold and someone is a 14-15, I will not automatically exclude them.
What is stochastic effects?
Stochastic
I'm
effect.
going to object at this point. I think we've gone beyond the scope of preliminary hearing. I think this is getting into 702 material that's not necessary for the probable cause determination.
All right. Mr. Burt?
I think it goes directly to the reliability of the testing results that the state introduced. I think the court has to understand the limitations and the potential sources of error in order to assess whether these results are reliable.
And in regards to this line of questioning, how far are you going to go on this line of questioning?
I have this one question and then I'm moving on.
All right, Mr. McBride.
I'll hold them to that.
All right, well, Mr. Burt, so the objection is overruled. You may proceed with that question.
You can answer.
Could you repeat your question, please?
Tell the court about stochastic effects.
Stochastic effects, when you have low-level samples during the DNA copying process, based on how the DNA is copied, you could have alleles that are copied better than other alleles.
Okay. Now, on another topic, I mentioned studies before. One of the studies that you're familiar with is called the PCAST report. Are you familiar with that report?
Yes, I am.
And tell the court what that is.
PCAST stands for the President's Council of Advisors on Science and Technology. And this was a committee that was found, I believe, under the Obama administration that gave guidance on different areas of forensics.
Including how to deal with mixed samples and how to deal with samples that have low quantity of DNA.
I don't know that I would agree that it's how to deal with them. They gave some of their concerns on low-level samples and mixtures.
Right. And they also did a follow-up report to assess whether using the kind of software that you used in this case had been established as reliable, correct?
That is correct.
And what was the software that you used in this case to reach your statistical results?
The software is called StarMix, STRMIX.
And the PCAST report specifically addresses whether reliability has been established with respect to StarMix, correct?
I don't believe reliability came into question. I think PCAST thought that there needed to be additional testing as far as mixtures and low-level samples go.
Mixtures and low-level samples that had certain characteristics, right?
That is correct, yes.
Including mixtures where what's called the minor contributor was in the sample below 20%.
That is correct. So the minor contributor would be an individual that donated less DNA to that sample. So PCAST called into question mixtures of 3 or more individuals with that minor or that low-level contributor making up 20% or less.
7 and 8 samples in this case were both mixtures, correct?
Yes, that is correct.
And did you determine what the proportion of mixture was between what I'll call the major contributor and the minor contributor?
So I did not calculate that personally. Part of the StarMix software, it does a couple different things. One, it takes a mixture and it uses math and biological modeling to try to break that mixture into its individual contributors. And then it also calculates the likelihood ratio, which is the statistic that I report. During that process, it does give an estimate of the breakdown of those potential contributors.
And what was, first of all, for the 7 sample, was the minor in there at less than 20%, according to StarMix?
Yes, it was. For one of the runs, when I compared to Mr. Robinson conditioning on Mr. Twiggs, it was a 5% to 95%.
And how about for the other sample?
Ooh, come on, come on.
For item 8, one of the contributors was 11% and the other was approximately 89%.
So below 20%, right?
Correct, yes.
And the concern expressed in this report, which was written by experts in your field, correct?
No, that is not correct. The PCAST report was written by individuals that were not practitioners or any type of laboratory personnel.
Right, but they list the experts who provided input into that report, do they not?
Yes, they did.
One of them was Bruce Bedoli, correct?
Correct, yes.
Who's Bruce Bedoli?
He is a DNA expert within the field.
Well, he was the head of your unit for a number of years before you came on board, wasn't he?
He was, yes.
And he's written extensively on forensic DNA testing, has he not?
He has, yes.
The report also lists Eric Gilkerson, correct?
That name does not, I do not recall that name.
Forensic examiner for the Federal Bureau of Investigation Laboratory.
I don't recognize that name.
How about Bruce McVicker, forensic examiner, Federal Bureau of
Objection,
Investigation?
Your Honor. I'm going to renew my objection. I think this is beyond the scope of determining probable cause. The standards that apply here are that the court weighs the evidence in the light most favorable to the state and avoids credibility and balancing the evidence at this stage. I think we're far into 702 territory at this point.
Mr. Burton.
I'm not sure I understand the objection into 702 territory. 702 deals with reliability of evidence. That's what the court is here to determine. So again, it's directly relevant to reliability. This report criticizes, for the specific samples she's using here, the reliability of this testing. And her response was, oh, but they weren't experts. But the report indicates that there were experts who were consulted on this report. So I think it is relevant, and I think it goes to the issue of reliability, and it's the only question I have on this area as well.
Anything further, Mr. McBride, or do you wish to respond to that?
Just that 702 deals with admissibility. It does discuss reliability, but it's directly related to admissibility of the testimony at trial under the Utah Constitution and under the robust case law in this area. The court does not weigh the evidence, draws the inferences in the favor most in the light most favorable to the state. And I think we're beyond that point now. We're getting into the admissibility questions.
All right. Anything further, Mr. Burt?
No, Your Honor.
All right. Well, as this is the last question, I'm going to overrule the objection, but as a reminder to all parties that this is a probable cause standard, and as it relates to, well, I will just leave it at that.
Are you familiar with that analyst?
No, I'm not.
Okay. Just to close the loop on the PCAST report, what they said in the report was that published evidence supports the foundational validity of probabilistic genotyping with some programs of DNA mixtures of 3 individuals in which the minor contributor constitutes at least 20% of the intact DNA in the mixture, and in which the DNA amount exceeds the minimum required level for the method. Isn't that what they concluded?
That sounds
Yeah.
accurate, yes.
And do you know why the level 20% raises reliability issues?
I do not know.
Okay. But you do know that in this case, both your samples had minor contributors below 20%.
That is true, but in this case, it was also only a mixture of two individuals.
All right. Now that's the next thing I was going to ask you about, which is what is NOC?
NOC stands for number of contributors.
And when you use this program, this genotyping program, StarMix, who decides what the number of contributors is?
That's my determination based on my experience and training, looking at the data. That's something I input into StarMix.
Right. And that's a complex determination, is it not?
Not necessarily.
But it can be in some cases, correct?
It could be if there's mixtures of a lot of individuals and a lot of the peak heights, the size of the spikes are relatively the same. It could cause some trouble for me as an examiner.
All right. One of the groups that studies your field is the National Institute of Standards and Technology, correct?
That is correct, yes.
They're in the Department of Commerce,
I believe so, yes.
federal agency.
Yes.
And they published a report in 2024 called Forensic DNA Interpretation and Human Factors, Improving Practice Through a Systems Approach. You're familiar with that publication, right?
I am, yes.
And was that publication written by scientists?
I don't recall exactly who the authors of that
Wow, the
publication
audio
were.
went up. What in the world?
Okay,
Man, he is scrambling.
sure. But it's a long report, right?
Yes, it is.
And you've read it.
I've read highlights of it.
Is it true that one of the things that they say in that section on the complexity of number of contributor estimations?
Objection.
Are you,
Same objection, Your Honor. This is beyond this. Scope of a preliminary hearing. Again, we're talking about expert reports. We're talking about scientific studies. These materials are all fine to consider at a 702 admissibility hearing. At this stage, where again the evidence is viewed in the light most favorable to the state, this is unhelpful to the court's determination, therefore irrelevant to this proceeding.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, I think the report that the state put into evidence as clarified by this witness indicates that she reached the conclusion that Mr. Robinson and Mr. Twiggs were, quote, possible contributors to these two samples. And so the one thing the court has to weigh is what is the weight of that opinion given the science or lack thereof? And one of the important issues here is how she derived these statistical numbers. And as an offer of proof, I'll indicate to the court that the numbers derived from this software program, and that software program is dependent in large part on how many contributors the analyst puts into the input of the software. And the numbers can change if the number of contributors is changed. And in this case, as I'll show through the examination, this examiner originally thought there were 3 contributors. And I will show to the court why she changed her analysis, and will indicate through this publication that there has been criticism of the way in which she determined the number of contributors. So I think it's important for the court to assess whether you've got accurate numbers in front of you. The state put in these astronomical numbers and are asking the court to give weight to them. And I'm asking the court to consider how those numbers were arrived at and whether there are reliability issues with regard to those numbers.
So the concern that I have is, I turn to State v. Ramirez, 2012 UT 59 in paragraph 10. It states, furthermore, the magistrate's role does not encompass an assessment of whether such inference is more plausible than an alternative that cuts in favor of the defense. That is a matter of fact finding, which is left for the jury at trial. And so when I'm staying in my role as a magistrate, I hear what you're saying, but my concern is based off case law that dictates what I as a magistrate should be doing. If I want to stay in that lane, my fear is as we go down further down this path, which again, it's not precluding if this were to proceed, if there were a bind over, if there was a trial, that certainly that could be determined. But at this point, at this stage, how do you weigh this issue as I'm weighing State v. Ramirez in deciding whether we're going past the probable cause stage?
Sure. And I think the answer to that is we have to take into account the ruling that you made in this case, which is the law of this case, which is when we objected to the hearsay aspect of these DNA reports and other reports, you ruled that you are the ultimate determiner of the reliability of the hearsay evidence being admitted. And you will recall that our argument was the statute was unconstitutional because it was dictating that you find certain evidence to be reliable without considering whether it was reliable. And your ruling, as I understood it, was no, you retain the ultimate determination of whether the evidence is reliable. And that's not a credibility issue. Is this reliable hearsay that the state is offering? And so issues that go to whether these numbers that the state is putting in front of you are reliable, I think go directly to the substance of your ruling, which is that your role here is to determine reliability of evidence. And I'm familiar with a case that the court cites, but I think that has more to do with weighing evidence and making credibility assessments, whereas I'm focused on what the court ruled, which is we have to look at reliability here. And that's my job as a magistrate.
Mr. McBride, any final thoughts?
Yes, under Rule 1102B4, this the Exhibit 31 is considered reliable hearsay. In addition, credibility determinations are not proper for the court to make here for the whole reason that, studies supporting this science, studies opposing this science, testimony from this expert or that expert about what is reliable, what is not, what's more reliable, what's less reliable, factors that affect all those determinations. Those are all very, very complex decisions. There will be probably multiple day hearings dealing with that. And a probable cause determination is just not the place to conduct that kind of thorough, in-depth, and searching analysis. Rather, the case law the Constitution of Utah that says the only purpose of a preliminary hearing is determining probable cause, the case law, the rules that all say the court does not weigh the evidence at this stage, but leaves that for a finder of fact, the jury in the end. That all supports cutting this line of questioning off at this point rather than going on for into greater depth, Your Honor.
All right. So based off what's been presented before me, I'm going to sustain in part and deny in part the objection made. I'm going to allow this question to be asked, and so that is denying, but sustain in the sense that this would be the last question, and if Mr. Burt would chooses to, may go on to a different subject or a different line of questioning.
Sure. Did that NIST report conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
Can you repeat that?
Yeah. Did the report, the NIST report that you referenced, conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
I think that goes to the DNA evidence. Again, we never truly know the number of contributors in a forensic sample. So like I mentioned before, you could have DNA mixtures that are made up of 2, 3, 4 individuals. I have training, I have experience, I followed standard operating procedures. So I'm making the best determination based on the evidence, the DNA evidence that I have as far as number of contributors goes.
Now, if I could, I'd like to return to your case notes, and could you display for the witness page 365 of tab number 4? And while he's doing that, by the way, it's true that if you change the number of contributors, you're going to get different numbers from the software program.
It depends. So actually, each time you run the software, you will get a different number based on the math that the software system does. But there are studies and validations that show we don't expect that math to be greatly different, usually by a factor of 10. Changing the number of contributors, it depends. If you have a major contributor, someone who's made up most of that DNA profile. If I originally interpret something as 3, calculate a statistic, if that major contributor is the individual that I'm comparing to, if I change the number of contributors to 2, based on the studies and based on my own experience, it doesn't change the likelihood ratio of that major contributor by much.
But it does change it, correct?
Yes.
And you just said, I think, that even when you put in the same parameters, you don't get the same answer if you run it through STR mix more than once, right?
That is correct. Based on how StarMix utilizes math and distributions, you will never get the same answer twice, but it will be no more than a magnitude of 10.
So that test is not reproducible in the sense that you can run it a sample or your assumptions in there 10 times, you could get 10 different answers.
That is true. Again, all within the first time I run StarMix, I'm not going to get a likelihood ratio of 10, and the second time get 10 quadrillion. I might get 10 quadrillion the first time, 2 quadrillion the second time. But even if I run it 10 times, I'm still going to get around the same likelihood ratio value.
Now, could you look at tab number 4, your case notes at page 365, if you could bring that up for the witness? Let me know when you have that in front of you. I think you need to scroll up one page. There we go. Can you identify this page from your notes?
Yes, I can. These were notes that my technical reviewer made, and my technical reviewer, they will review all of my DNA evidence. They will draw their own conclusions as far as number of contributors and comparisons, then compare it back to my conclusions.
All right, so this is regarding the 7 sample, correct?
That is correct. That is one of the samples.
And your original assessment was that there were 3 contributors to the sample, right?
That is correct, yes.
And that conclusion was reviewed by a reviewer, correct?
Correct, yes.
She read the same electropherograms or the name for the output of this technology you use, correct?
She utilized the same electropherogram, which is the chart that the DNA is on.
And does this page in front of you, is that an accurate representation of your case file?
Yes, it is.
I move into evidence page 365. And that would be Baker 4.
Mr. McBride?
I'll object on relevance grounds.
All right. Did you want to respond, Mr. Burt?
Your Honor, it's relevant because the witness originally determined that there were 3 contributors. And I'd like her to explain to the court how she reached that conclusion, because I think it does go to the reliability of her testing here.
All right. So as it relates to Baker 4, and this is her personal notes from Ms. Baker as it relates to what I'm assuming is State's Exhibit 31, these notes were prepared as part of the report in State's Exhibit 31. I will find that it is
Your Honor,
relevant
Your Honor.
and that it is admitted into evidence as regards to publication. What is the request?
Your
Mr.
Honor,
Byrd?
if I may clarify, I think the testimony was that this was not her notes. That these were the notes of her technical reviewer, is what I heard.
Please correct me if I misheard that from both sides. I want to
Yeah, I
make
did.
sure. I want to make sure, are these Ms. Baker's notes?
Could I clarify that?
Absolutely.
Ms. Baker, these are notes in your case file, correct?
These are notes in my case file, but they're not my notes.
And the way your lab works, you're not the one that does all the different steps in the testing process, correct?
That is correct.
Other analysts have input that then all goes into the case file, which you have access to and rely upon in rendering your opinions.
That is correct, yes.
All right.
And this particular page is a note written by your peer reviewer that you relied upon.
Correct. After I made my interpretations and drew conclusions, my technical reviewer then reviews the data and draws their own conclusions. So this was created after I had already drew my own conclusions.
All right, I'm just trying to put it together here. And so the question I'm trying to get to, counsel, is, was this particular, I recognize it as it being prepared by someone else, but as it relates to State's Exhibit 31, was this relied upon in order for State's Exhibit 31 to be put together as the report? Because I'm trying to determine relevancy as it relates to that, and that's a crucial point I don't have the answer to just yet.
Okay. Let me lay a more adequate foundation. The case file notes are assessed by you at every step of the analysis, correct?
Not necessarily at every step. Before I issue a report, before I write a report, I review all of the case notes. So that will be any communication log entries, any documentation from the laboratory, the biologists that perform the DNA testing. I will review all of that, write a report, and then give that to a technical reviewer. They will draw their own conclusions to determine if they agree with me. If they do, they will sign off, and then my report and my case file will go for an administrative review to make sure that the laboratory number is correct on all the pages, that if there's any crossouts, there's dates and initials and so forth. Those 2 reviews have to be done before I can actually make it a final report and case file that gets submitted and sent to the field.
And in this case, correct me if I'm wrong, but the sequence was you originally determined in sample 7, that there were 3 contributors. That conclusion got reviewed. Then you ran some further testing, and then you change your conclusion, correct?
That is correct, yes.
Right. And before you change your conclusion, you of course go back and look at what the reviewer said about her review.
We would have a discussion. If I say a number of contributors was 3, he or she notated that it was 2. We had that discussion. She agreed with 3. So for that step of that process, because again, we're piecemealing this. Typically in a normal case, we will work all of the evidence. I will write a report. For this situation, I had DNA evidence coming to me throughout the day, throughout the night. So I had reviewers at different steps, which is not usual for a case. Usually I have 1 reviewer. So in this case, at that particular time, I had a reviewer. Then when I was submitted additional known samples and used those for comparisons, then I did have additional conclusions and additional reviewers.
But you certainly took into account this notation on this page before you change your conclusion, correct?
I don't know that I would agree that I took into account. We had already had that conversation. And again, once I received additional known samples and additional information from the field, I then did amend my conclusion.
And these notes are kept in the ordinary course of your business?
Yes.
And they're part of the case file that you rely upon in reaching your conclusions?
They are kept with the case file after I draw my conclusions.
So Your Honor, I think there's a foundation for this. The state has offered all kinds of hearsay here, and certainly this is, there's no question about the reliability of the entries.
Anything further from the parties before I weigh in on, make my ruling on Baker 4?
No.
The court finds that it is relevant, and as it relates to State's Exhibit 31 and Baker 4 is admitted into evidence in regards to publication. Mr. Burt, what is your request?
That it be published.
All right, in the courtroom.
In both the courtroom and to the cameras.
All right. Any objection, Mr. McBride? All right, go ahead and publish that to all screens and may be captured by the media.
So these notations at the top there, 7-1 mail, discuss 3 NOC and okay with 3. Could you translate that for us, what that means?
Sure. So when my technical reviewer took a look at the DNA evidence, she determined that male DNA was present, and she concluded that she would have called it a number of contributor of 2. She compared it to my conclusions. I said number of contributor 3. So we had a discussion as to why she thought it was 2, why I thought it was 3. And she said she agreed with me calling it 3 based on her discussion.
Okay. So was that an extended discussion you had with her, or just?
No, this was a quick discussion, and this is not unusual. We have discussions like this during the technical process quite often.
And the stamp on the bottom, approved by Tara Benson, is that the reviewer?
Yes, it
we're
is.
Talking about? All right, thank you. Now, I want to ask you to look at page 128 of that same exhibit. No. Is this an electropherogram that is a part of your case file?
Yes, it is.
And is this an accurate representation of what's depicted on this page?
I'm sorry, there's nothing on the screen. Am I?
128.
Yes, it is.
I move that into evidence, Your Honor. This would be Baker 4, page 128.
Oh, I thought I already admitted Baker 4. Is this a different? The previous one was Baker 4, as I understood it.
Yeah, Baker 4, page 365.
Oh, okay. So
And
Baker,
so this is Baker 4, page 128.
right, so the previous admitted exhibit is Baker 4, 365. The current proposed one is Baker 4, 128.
That's correct.
All right, Mr. McBride.
If I can have just a minute to update my notes on those page numbers.
All right. 365 was the previous one, unless I heard it wrong.
Yes, that's right.
All right, and the current one is 128.
First, I'll note, this is the first I'm seeing these as exhibits. Of course, I have this file, but I was unaware that we were going to be, these are going to be offered as exhibits, so I'm looking to find them in my file as we go.
Why is it?
Second, again, I'm going to object on relevance grounds to the probable cause determination. We're going through the finite details of the analysis here. And once again, I think these are appropriate questions to raise in a 702 hearing, but with the standards that apply at the preliminary hearing that I've already discussed, I think we're beyond the scope of probable cause determination as we dive into this evidence.
All right, Mr. Burt.
Your Honor, I think this exhibit is particularly important because the court does not yet have in front of it what an electropherogram is and how it's interpreted. And this particular page will illustrate to the court how the analysts interpreted the peaks on this electropherogram to reach the conclusions that she reached, that there were 3 and not 2 contributors. And I think it will assist the court in determining exactly how this comparison process works and what the output looks like, so the court can see exactly how the interpretations are being made.
And is this the dose that were relied upon I'm viewing State's Exhibit 31 as a summary, and this more of showing the work of how the summary was reached. Am I misunderstanding how this fits in?
This fits into how the analyst originally was of the opinion that there are 3 people here and not 2. And she will go on to explain how she changed the interpretation from 3 to 2. And the point of this is to illustrate to the court that this is a subjective process to a certain extent, and that people can read these things in different ways. And so I think it will help the court understand exactly what's being compared here. You've got peaks online.
I don't know about
she will
that.
Say, and just to let the court know, in responsive to Mr. McBride's statement that he was unaware that this is going to be an issue, he and I met with this analyst before the preliminary hearing. The analyst pointed this page out to us as being illustrative of why she originally concluded that there were 3 contributors. So this is not something that's being sprung on the state. He was a part of that conversation, and this particular page was identified by the analyst, not by me. So it is important to understand why we went from 3 to 2 and what impact that has on the numbers that the state is offering.
All right. Anything further?
This is reaching, man.
Utah Rule
Gracious.
of Evidence 1102. B4, it says scientific, laboratory, or forensic reports and records. I find that this is admissible and is admitted into evidence as Baker 4, page 128, and is a request to publish this document.
Okay, you can,
Was that a yes? Oh, okay.
yes,
All right. So published, I'm
Oh,
assuming.
I just said it.
All to that
Yes.
screen as well. All right.
Correct.
It may be published. Council.
All right.
just
So
as a
real quick.
reminder,
I know I
as
just
this
got
is a
everybody thinking I was
probable
going to say
cause,
something
I
profound.
understand, and I
I'm going to let you
appreciate
down.
giving
I'm not
me
saying
a-
anything really
a
super
pointer of where
profound.
it's
I'm
going.
just saying Candace Owens is an IQ test. When you see what Realtor put up here, that I saw this earlier, actually, that Candace is arguing that the picture of the guy going up the stairs looks like he's a certain height. I'm like, how in the world can you tell a certain height from a video that's looking down? Like, the fact that people are honestly taking her seriously in the year of our Lord 2026 and not mocking her and laughing at her and throwing rotten tomatoes at her. That's got to be studied by science. Candace Owens is an IQ test. It is literally God's way of showing whether or not you are a pure fool or you're just a silly person. Whether you are completely given up on trying to think for yourself or you're just kind of being silly. Because I'm sorry, there's no way in the world that grown woman in the year of our Lord 2026 is saying that it doesn't look like he's 6 foot tall. She's just retarded, man. She's just retarded, man. I don't believe in making fun of the ignorant. I don't believe in making fun of the mentally deficient, but y'all, we got to make fun of Candace. She is retarded. So that's her argument. Remember, she's the one that said the boy wasn't even there on the campus at all. Now she's making room that there was a clone. Why was there a clone there? Because he was there. That's so dumb. She's so bad. Y'all, you almost got to feel bad for her. Okay, I'm going to stop. I'm going to bring this back up here because I know y'all want to hear about alleles and 4% and 20% and degradation and all that kind of stuff like that. Y'all, pray for Candace because she's retarded. She is. I think she just needs to be mocked at this point. You have to have something to compare height to. That's why banks, right, have measurements at the doorways. Right. She was comparing it to another woman, a woman that was walking down the stairs while Tyler Robinson was walking up. And she's like, the woman looks like she's 6 feet tall, so he can't be 6 feet tall. She has to be mocked, man. She must be mocked mercilessly. Mockery will continue until morale improves. That's just all I'm going to say. All right, let's go find out more because this lady is kind of, I mean, the witness is really smart. I'm going to give her that. I like her. She's holding her own. She's holding her own.
But just as a reminder, as
helping us understand this. I have no idea what that is.
The software that
What is that?
utilizes the information from the machine, yes.
However, it's true.
She's have all of us tricked. Don't
that
worry. We
in
all were
determining
tricked at
the
one
number
time.
of contributors, you look below that 150.
Yeah, I'm not lanky. I'm 5'6".
All right. Now on this,
And I probably
this is
look
only
every bit of
showing
5'6".
1, 2, 3, 4 different locations, right?
Correct, yes.
And you see a number of peaks at each one of these locations. Some of them are labeled, some of them are not.
Correct, yes.
So tell us how you originally looked at this and said there's not 2 contributors.
Hey man, we're not using all these big words over here.
So first what I do is I
Dominique, you
count
use all these
how
big
many
words.
labels that I see. So how many of those little squares under each of those locations. So for example, at D2S441, there are 3 squares. Knowing that one piece of information comes from mom and one comes from dad, if it's a single source profile from one individual, I expect to see no more than 2 squares. Because I see 3, that gives me an indication that there's at least 2 individuals. Same thing for the next D19S433 and as well as FGA. There were 3 peaks that were called. So I knew this had to be at least 2 individuals. Then what I do is I take a look at the peaks that are not called and determine could there potentially be a third person included. So for example, at D2, the location farthest to the left, I'm asking myself that 12 in that bottom box, is it the same contributor as, for example, the 22 under FGA all the way to the right? Because I see peaks that are not labeled, it could be that the 12 belongs to one individual and those 2 peaks that are not called belong to a second or third individual. And that at FGA, I could be seeing the 22 from that third person, but that second person has dropped out. Because I'm able to use information below the threshold and I see peaks, that gives me an indication that I can increase my number of contributors to 3, which I did in this case.
Okay, and when did you reach that conclusion, time-wise?
If I recall, it was somewhere around September 12th.
And when did you change your conclusion?
That I would have to refer.
Sure.
I changed my conclusion on September 13th of 2025.
And explain to the court why you changed your conclusion?
I was submitted an elimination sample from Mr. Twiggs, and an elimination sample is a sample in which it's from a known individual, and then there's an expectation that the individual's DNA might be present. In receiving that sample and talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination. When I compared him to this sample, all of the DNA, unlike that major contributor, matched to Mr. Twiggs. So because of that, I determined that there's actually only 2 individuals because those small peaks, there was nothing left for a third individual to be compared to.
You use a phrase elimination sample. That's typically used, is it not, in a situation where you're testing a sample that has more than one contributor?
Not necessarily. An elimination is just simply an individual that we're expecting their DNA to be there. So for example, if we have a stolen vehicle, I will request an elimination sample from the known driver of the vehicle so I can subtract out their DNA to see what I have left over. It doesn't necessarily have to be more than one individual. There certainly has been times where I only detect that known expected individual.
And you said you had a conversation with the investigators as to whether Twiggs should be included as, or you talked to them about whether you should get elimination samples?
I talked to them with regards to if I should utilize Mr. Twiggs as an elimination versus comparing him and offering a statistic.
Okay, but in your report, you concluded, did you not, that one of the contributors to both samples was Twiggs?
That is correct, yes.
Right. You didn't just assume that, you reached the determination that he was the source of both those samples, one of the sources, right?
I don't want to use the word source, but knowing that there was an expectation that his DNA could be present, when I compared him to that DNA sample, I did see his DNA types present. So using the word assumed, that's verbiage that we use when we calculate our statistical calculation. I'm letting the software know, I know this individual is there. I'm assuming that they're there. Based on my comparisons, I did see evidence that that person was there.
But I guess what I'm confused about is we talked before about how your language should never imply an absolute identification. But in the body of your report, you say that one of the contributors is Twiggs. You don't say he's a possible contributor like you do for Mr. Robinson. You say he is a contributor. Do you not?
I do, and with elimination samples, that's slightly different. So for example, let's say I have a sexual assault case and I have a vaginal swab from a female. She has a consensual partner. I can request an elimination sample from that consensual partner. If I see that they're present, I can say they're present and say the DNA foreign to that victim and that consensual partner is one person, for example. So it's different than comparing a known individual. If they're an elimination sample, I can say that I expect their DNA to be there, and based on my interpretation and reviewing that data, they are present.
And based either on your conversations with the agents or other people, why did you think that Twiggs was someone whose DNA you would expect in those two samples?
So from what I recall, in speaking with the investigators, Mr. Twiggs was a roommate of Mr. Robinson, and it was thought that those items came from potentially Mr. Robinson's home. And I don't recall exactly if it was a situation where a particular towel was known to have been in that house. I don't remember that exactly, but in talking to the investigators, based on their investigation, it was important to assume potentially Mr. Twiggs was present.
Right. Did any investigator ever tell you that the towel did not come from Mr. Robinson's home, but was found in a bush out at the university?
I was aware of that, yes.
So you knew that that towel was not found in a place where you would inspect Mr. Twiggs's DNA to be present.
That is correct. It was found outside of a home, but again, based on speaking with the investigators, they had information to suspect that that towel came from Mr. Robinson's home, and I should utilize Mr. Twiggs as an elimination.
Right. And again, you didn't assume that, you actually concluded it based on the match, right?
Based on reviewing Mr. Twiggs' DNA profile to what I developed from these items, I used him as an elimination sample.
Now, you did various STR mix, what I'll call runs, correct?
That is correct, yes.
And the way this works is you input the number of contributors. You determine that. And then they also have something called HD and HP, right?
Correct, yes.
Tell the court what that is.
So those are different propositions. So in calculating the likelihood ratio compares the probabilities of seeing a DNA profile given one of two different scenarios or explanations or hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. So depending on the question being asked is how I set up StarMix, number of contributors. For example, if I'm utilizing someone as a known elimination sample, I will apply their DNA profile both to the HP and HD.
And the theory of this HP is the prosecution hypothesis, right?
Correct, yes.
And HD is the defense hypothesis.
Correct, yes.
So, and these are things you plug in based on your understanding of what the prosecution and the defense are contending.
Correct, yes.
So how do you plug in the HD in a case where you don't yet have a defense postulating what their theory is?
So HD, or the defense hypothesis, is simply the DNA profile, the probability of the DNA profile, given that it's another unknown, unrelated person to the prosecution's potential person of interest.
Mr. Burt, I don't want to interrupt your line of questions, but we've been going for just shy of 2 hours. Would right now be a good time
It'd
to
be a
take
great
15
time, Your Honor.
All right,
Thank
let's
you.
take a 15-minute break. Let's see. We'll come back at 3:50. Court is in a brief recess.
Judge Graff said, look, man, you've been going long and hard on this. Let it go. Let it go. The only thing I hate is this is truly a very technical job. This woman's job is not something that she just, rolled out of bed one day and decided to start doing. It's truly something technical. And I hate it because they're drilling her and grilling her about something that really, at the end of the day, she's probably the only one that understands. So I think that's harsh. But anyway, let's go see what Andrea's got going
I
on.
hope that helps you with your ability to tolerate what is understandably not everybody's cup of tea. I totally get it. I had to call this one out too. User XR numbers.
Oh, there you go. Yeah.
He's been calling scientific evidence into question using sophistry for decades. LOL. It's hilarious because it's actually the exact opposite of this. All of the things that he is talking about, like from the PCAST report, the policies that they have for the Department of Justice, why you have to use certain language and what it means. These are all directly related to the kinds of challenge that Mr. Burt has been litigating for decades. It's because he's been on the side of pointing out that so much of what has been claimed and asserted, and the confidence associated with these claims in forensic evidence, a whole bunch of different disciplines, has been overstated for so long. It's been very misleading, and it's not scientifically valid. It's because of those changes that we have these limitations that the DOJ has finally recognized. Okay, we won't have our analysts call it or imply that it's definitive, because it's not. It's probabilistic. It is probabilistic. It's a comparison. Yeah, so I saw this. I had to be like, no, it's the opposite. He has been so successful at this type of thing. Him and people just like him, but he has been at the forefront of these types of challenges. He has been so successful that DOJ has had to change their policy to acknowledge they were doing pseudoscience bullshit before, and now they are going to restrain themselves to what can have some kind of foundational validity. Now, that said, is he coloring this to his advantage? Of course. Of course he is. Oh man. Let me give you the big picture takeaway from my perspective, at least as far as what we're dealing with right here. Two-person mixtures. Okay, two-person mixtures, not particularly regarded as complicated. Even in the PCAST report, the PCAST says where we start to get concerned is mixture of 3 with a minor contributor of less than 20%. And the reason for that, it goes back to these types of errors that he's been talking about: stochastic effects, drop in, drop out. These are just, I mean, it's almost helpful to think of them as like measurement types of errors that can happen. And they happen more when you have low quantity. There's just like not enough there to capture. And so it may just fall out, or it might appear to be something more significant than it is. So that's the error that the PCAST report identified. The PCAST report came out in 2016. Okay, it's 10 years old. There has been a lot of study and validation and litigation of this in courts all over the country. I'd say probably primarily the federal courts, because they do lots of Daubert hearings there. Daubert is the hearing on the foundational validity of scientific evidence that if a party wants to present scientific evidence in court. Under the Daubert standard, you have to show it's minimally reliable. It meets basic fundamental standards of scientific reliability. So they go through these Daubert hearings with new technologies or novel technologies, or sometimes even old technologies that they found new ways to validate. So there have since been lots more validation studies of star mix and mixture analysis and things like that. Don't have my notes with me, so I can't tell you what's the highest mixture I've seen validated in federal court for star mix. I think it's 4. I just don't want to say for sure. No question that 5 is really on the limit. A 5-person mixture is really, really complicated. It also gets complicated, by the way, when you have relatives, because now you have, like what she talked about, you get 1 copy from your mom, 1 copy for your dad. When you have relatives, you have multiple people sharing the same alleles. And so you're gonna, it's not like a picture where you have 5 different people and everybody is contributing different things, and it's really easy to just go through and count, oh, I have 20 different alleles because now I got to do my math. 2 from each people. So I guess it would be 10. Oh man, it's too late in the day for me to do very simple math in my head. Anyway, if they're all different,
It's all good. It's all
and
good.
you can just count them. Okay, 2 copies from each person, 10. We're good. We're set. We're at 5. But when multiple people have the same ones, it makes it really difficult to tell, is this one person with like a really strong quantity of DNA, or is this multiple people contributing different DNA alleles? So I'm finding all of this fascinating, and
I think it's both of them.
very
I think
intrigued
he's talking about the towel,
direction
but
the state is going.
it's
or
going to
the
also apply to
defense
the
is
weapon,
going
I
with
think.
this. So bottom line here, nothing that the defense has brought up has been like, oh, this means the conclusion is invalid. Absolutely nothing at all. He is arguing around the limits, around the interpretations, and around the statistics. For example, this argument that if you have 3 contributors versus 2 contributors, it can change the statistics associated with that likelihood ratio that this is reported in. That was the, it's 30 quadrillion times more likely that the sample, I think from the screwdriver, gotta go back and find which one was which. 30 quadrillion times more likely that the sample came from Lance plus Tyler. If you assume Lance is on it, Lance plus Tyler, then Lance plus an unrelated, unknown, random person. It's not a random person in the population. I don't want to like suggest this is a population type of statistic, because it's not. It's much more like if you took all of the possible genetic combinations and you account for like the likelihood that certain combinations are far more common than other combinations in real life, and you take all of those possibilities and you shake them up in like a Yahtzee can and you dump them out on the table, what's the likelihood that you're going to get this sample that shows up? It's not that this many people in the population. It's like literally if we just kind of randomly did it, what's the likelihood we'd get that? 30 quadrillion is a pretty high one. It's a pretty high one. But like by this testimony, even if the likelihood changes, okay, it would be somewhat less likely. It's still going to conclude Tyler Robinson is the major contributor to this DNA sample. It just might be more like 10 quadrillion. You know, maybe it's less. Maybe it's
10 quadrillion is crazy.
You know, 100 trillion. I don't know. She indicated it would be nominal, but because he was the major, and because that's what they're concerned with. The minor could, you know, potentially change a lot, but the major, not so much. We're going to have so much to talk about on the recap show tonight. Oh, good Lord. Jeff is going to be upset with me because I'm going to be going off about everything. I think we might make it just DNA. Maybe we'll just do it just DNA, like all this other stuff, these nice cases that they gave us before, and Matthew 19.
There you go.
I think we might just pass on all that and just talk about DNA tonight. That's probably going to half of you in the chat are like, all right, see, had enough of the DNA for one day.
Enough of the
But I do,
DNA
I
for
really
one
love this
day.
stuff, and I've been waiting for this. Mr. Burt has been on the front lines of this issue for decades. He is so incredibly informed about this technology and, as he's pointing out, the limitations of it. It does have limitations. Of course it does.
Uh-huh.
Any good science has limitations, and any good scientist will acknowledge the limitations. So it sounds like, you know, that's like a bad thing, but it's not. This is going back to our epistemic humility. I mean, there's nobody who should be more humble about what we know and how we know it and how certain we are about what we know than a scientist. I mean, that's like the whole job. Oh, man. All right. I got to calm down. Let's go back to you guys.
Oh, we got
Kyle Cowden. Charlie could have been on the table and surrounded by surgeons, scrubbed in and prepped, and he wouldn't have survived. Yeah, I tend to think that's likely too. And that was certainly my impression when I saw it. I'm like, this looks, if not instantaneous, at least, you know, very, very, very rapid, that he would have been lost. So it's just with a catastrophic injury like that. I mean, we're expecting arterial injury, you know, major veins, jugular, you know, stuff like that.
Yeah.
It's just very difficult to mitigate an injury like that. The Jay Witt podcast. Is there a timeline for the trial if this prelim is granted? How long until the trial starts? We don't know.
All right, whoever wanted that
There's
question.
no, like, deadline other than the constitutional speedy trial limit. And the constitutional speedy trial limit is not black and white. It's not like here's the calculation that you do. It's a factor test. It's very much a it depends test. And ultimately, the way that it works is that anything short of a year is not
Oh
a
my
problem.
gosh.
If it's up to a year, almost certainly it's going to be fine. Anything
What?
over a year starts to raise concerns about, is this delay unreasonable? And so then at that point,
Wow.
they will start to look at other factors like who's responsible for it, how aggressively has the defendant asserted rights to a speedy trial? Because, I mean, most of the time, that's what we're talking about. We're talking about the defendant wants it speedy and the prosecution is slowing things down. That's not going to happen here. So to the extent, taking more than a year implicates Tyler Robbins' speedy trial rights, he can waive that to get more time if he wants to. Utah is somewhat unique in that their victims' rights includes a victim's right to a speedy trial that is considered according to the same kind of test as the defendant's right to a speedy trial. So it doesn't mean that anything over a year means Eric can object and they will have to go to trial right away. It just means they have to look at why is the delay being requested and is it necessary? In the fairness of the process and the adjudication and everything like that, is it something that reasonably necessarily needs to be done? This case, there's going to be so much. I mean, I keep coming back to, there is going to be so much litigation over scientific validity. We already know this. We're getting the preview right now on stuff that in many other courts and in many other cases, this would just be taken as we're going with it. It's DNA. High probability. We'll see if our expert can poke holes in any of their steps in the process. But they're going to go deeper than that. They're going to go into things like star mix on the complex mixture. 5 individuals, at least 5 individuals is how Kathy put it.
You got 5
They're
individuals?
likely to be litigating around the edges of like, how do you get to express the opinions? How do you get to tell the jury about what the statistics mean, right? That's a very misleading one. If you have a likelihood ratio of, 30 quadrillion times more likely this than that,
wow,
you need to be real sure that the jury doesn't think you're saying 1 in 30 quadrillion likelihood chance that it came from somebody else. Those are not the same thing. They're not the same proposition. And then what people end up doing is they think, oh, well, there's only, 5 billion people on the planet, 6 billion people on the planet. There's only been, I don't know how, like 10 billion or something ever. And so, you'd have to have like however many thousands of times more people than have ever existed on the planet to meet that likelihood. That's not what it means. It's not that kind of statistic. So
interesting. Okay.
they're going to be litigating all of this kind of stuff. They're going to litigate the tool marks. No question about it. I mean, if he's litigating this DNA and star mix, he is going to litigate tool marks. Okay. Tool marks is absolute trash compared to DNA. So many fundamental problems with it. Also criticized in the 2016 PCAST report, but unlike the DNA and the mixture analysis and so forth, not really a whole lot of additional validation or improvement of kind of the fundamental problems with the methodology in the tool mark analysis. It's still subjective. It's literally an eye test, literally an eyeball test. And it's based on what the analyst thinks is good enough. The literal standard, the actual, it sounds like I'm exaggerating, but the actual standard is based on what does the analyst think is close enough match to be a match. So they're absolutely going to litigate that. I mean,
is there a difference between probability, statistical probability,
this is
and likelihood?
just like kind of the obvious and what we know, like what's jumping out from what we already know about the case. So Yeah, these could be like multi-week hearings and stuff. This is
Oh
going
my
to take a
gosh.
massive amount of time. And this is just like one small part. They're going to litigate the search warrants, guys. No question about it. No question about it. They have to. I mean, you pretty much there's always something in a search warrant that you can point to. They're going to argue they're overbroad, particularly the search warrants for devices, for electronic digital data. They're going to argue these are overbroad. They're going to argue
No.
they were, in the execution exceeded the bounds of what the warrant authorized.
knew
All
it.
of these types of things that are fairly common arguments, they're going to litigate that too. I mean,
She looks
there's going to
frustrated.
be a lot. There's going to be a lot. So
Oh
the
man.
idea of getting this all done in a year seems pretty improbable to me. In the meantime, of course, they're doing their mitigation investigation. They're doing their other independent investigation. They're having to get their experts up to speed anyway. It's not going to be soon, guys. It's not going to be soon at all.
I believe
So
that though.
all of
I
that's
do
going to
believe it.
factor into, is it reasonable to take more time, and how much more time is reasonable? And so the judge is going to look at, well, what do we need to get done? And what's the realistic time frame to get it done? It's not going to be quick.
Wow.
We have Amy LC gifting a membership.
All
Thank you
right,
so much. We
so-
love the generosity, seeing the chat just blow up all green. It really is awesome. To Truth for Liberty. There is probative.
All right. So real quick, I want to bring up this real quick. Is there a difference between statistical probability and no, not really, but statistical probability is more accurate. Is that more accurate in a term or more accurate like in practice? Is what I meant to say there. So there we go. Is it more accurate as the term? Is it more accurate to say statistical probability than likelihood? Likelihood is kind of like what the pre-K law students say, but statistical is what the real serious people say. Yeah, it's going to be in practice. Okay, cool. All right. Thank you, brother. Appreciate you, man. Thank you very much for that. And by the way, I want to say thank you to everybody who's tapped in with us. It's been a long day, man. We still got time though. It's been a long day. And I really appreciate y'all tapping in and keeping the live chat live and keeping it interesting and engaging, because that's why we're the best live chat on the internet. So I want to say thank you. I appreciate y'all tapping in, whether you stayed all day or just came in, went and took a nap, you went and did some yard work, whatever. I appreciate you for sure. What does this say? Legit. Tyler Robinson is like, I don't want to die, but I had to kill Charlie Kirk because he was hateful. Yeah, I mean, that's technically what he's saying. Yeah, in a roundabout way. Yeah, I don't, this is going to, and I hate it because there's going to be like some hard facts that the general populace can understand. Like we have a body, we have a weapon, we got video evidence, right? We can all understand that part. But when they get into the weeds of, arguing about a search warrant, get into the weeds, arguing about DNA and star map and cell hawk data and stuff like that, our eyes are going to roll back in the back of our head. So I hate that part because those are experts, man. They know exactly what they're doing. They know this stuff, and we are trying to understand it. So imagine what the jury, man, the poor jurors are going to have to understand this. And she's sitting there saying it's going to take a year. That's crazy. We don't want that. We do not want that here in Georgia. We had a year-long case here in Georgia, and it was crazy. So yeah, we do not want that. We do not. But I do want y'all to hit that like button if you don't mind. If you could hit that like button, that would be super fantastic. We're gonna jump back over to Andrea real quick and get done. I don't know. It doesn't look like they're starting back up. So let's bring her back in. Let's go.
Investigative analysis, Candace, if you say so. And there is legal analysis of evidence and process, Andrea, apples and oranges. I think of the contrast between what I try to do and a lot of the other approaches that are common in the true crime arena, for lack of a better way to put it, is legal analysis versus sleuthing. I'm not a sleuth. I don't do the sleuthing thing. I'm not against the sleuthing thing. I don't have really problems a lot of the time. There are some really shitty people doing sleuthing, and the problem is sometimes sleuthing can go sideways even when you have the best intentions. And the "we did it" Reddit is like the kind of paradigm of that. If you guys aren't familiar with that, because it's now an old meme, I guess, from back at the Boston Marathon bombing. Reddit got a hold of the like initial I think it was just photograph, like still photograph of the suspect, and went on a huge tear, like trying to find the Boston Marathon bomber. Accused one guy wrongfully. He was ultimately found dead later on, not because of Reddit. He had died before and gone missing. There is an argument to be made that because Reddit was like so persistent about accusing people, that the FBI released more information about the bombers, and that alerted the bombers to the fact that they were under suspicion now, and then they reacted in a way that caused a law enforcement officer to be killed. These are the reasons I'm very cautious about sleuthing, just because there is a reason why we have formal investigators who do things
I didn't know about that.
privately until it gets to court. Now I recognize fully, depends on institutional trust, and we don't have an awful lot of that in this day and age. So I do get it, and I understand completely why people want to kind of look and know for themselves. But just there are
comparing that individual to the sample. If I may refer, I think that was the only additional.
Oh, no problem, friend. No problem at all. It did sound like she wasn't feeling Candace, so if you heard her, she sounded like she wasn't feeling Candace and her behavior at all.
Yes, after discussion with my reviewer, it was determined that I was also going to calculate a statistic or compare Twiggs by himself, comparing him to the evidence, and having that run in my case file.
Okay. And could you go to tab 38, page 39?
Oh,
Yeah, it should not be on the screen.
let's pull it down from the screen. Thank you.
Thank
So
you.
just to the monitors of the attorneys and the witness, Mr. Burt?
Just for the witness, Your Honor.
Okay, just for the witness.
39. And this is page 39. Is this the DNA report? I'm sorry, the Star Mix report that was produced as a result of your inquiry that involved a comparison of the sample to Mr. Twiggs alone?
Yes, it is.
And is that a 6-page report?
Yes, it is.
And is it a true and accurate copy of the STR mix report for that particular sample?
Yes, it is.
I've moved that into evidence, Your Honor. This would be Baker 38, page 39 through 44.
Baker 38, page 39 through,
I'm seeking admission as well as publication to the audience and the camera.
I just want to make sure I have the label correct. Baker 38, pages 39 through 44. Did I hear that correctly?
That's correct, Your Honor.
All right. To the state?
Yes, Your Honor, I object on grounds of relevance to the probable cause determination.
All right. And Mr. Burt, would you like to respond?
Submitted, Your Honor.
So I'm not exactly sure what this is in order to
Sure.
determine
Let
how
me-
it fits into the probable cause analysis.
Sure.
So a little bit more information, because as of right now, I don't have enough to admit it.
Understood, and I apologize to the court. So the report that was admitted into evidence has the conclusion in it that both samples were contributed, that Mr. Twiggs was a contributor to both samples. And this is the report that the analyst ran in order to make that determination, I believe.
All right, did these reports, were these made prior to State's Exhibit 31 being prepared?
Yes, that's correct.
All right. I will admit, so Baker 38, pages 39 through 44 is admitted and may be published. Again, as a reminder, for all attorneys, this is a probable cause standard. So if all parties can just keep that in mind as we're moving forward on this.
Sure.
Thank you.
Thank you.
And so it may be published to all screens.
Number on this?
Yeah, it's page 39.
No, the actual dates number, I'm happy.
So is this the report that you referenced in your notes that you needed to run the sample through StarMix?
Yes.
Now, at the top, this is the StarMix unit dated September 15th, and it relates to item 7-1, correct?
That is correct, yes.
All right. And then down below that, the kit used, if you could go to the summary of the input. You tell the software program, assume there are 2 contributors, right?
Correct, yes.
You input sample 7A.
Correct, yes.
And when you input it, it's just the raw data, right?
Correct, just the numbers from the graph.
The numbers, and then known contributors under HP, the prosecution hypothesis,
Correct, yes.
right? And you put in sample 61,
Yes,
right? That's Twiggs's known sample.
correct, yes.
And then the known contributors under the defense hypothesis, you left that blank.
Correct.
Is that because you didn't know what the defense hypothesis was?
No, again, the defense hypothesis for this situation, if I'm comparing someone, is an unknown, unrelated individual, and that is taken into account during the calculation.
Okay. And then you input that data, and what you get out from that is a likelihood ratio, right?
Correct, yes.
So let's go to page 2 of that report. And is this a summary of the results from that test on the 15th in terms of a likelihood ratio?
Yes, it is.
What is a likelihood ratio? What does that mean?
A likelihood ratio is a statistic that calculates the probability of seeing a DNA profile given one of 2 different hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. The probability with the higher number gets the support, and the magnitude of the support is determined by the ratio of those 2 numbers.
That's pretty technical stuff, but the bottom line is that the software computes the numbers, and then you look at those numbers and determine whether it has any significance, right?
I don't know that I would say if it has significance. I report the value that's calculated.
Right. And why is one column, these columns relate to different, what are called population databases, right?
That is correct, yes.
The one on the far left, BAH, is an FBI population database on Bahamians,
And African Americans, yes.
African Americans. Another one for Caucasians.
Correct, yes.
SEH is Southeast Hispanics,
Correct.
and then Southwest Hispanics.
Objection.
That's all I have on that. I'm just trying to explain the chart.
All right, well, there's an objection. Let's pause and turning to Mr. McBride.
Sure.
Your Honor, at this point, I'm going to object on, again, grounds of relevance to probable cause hearing, State v. Drosbeck, State v. Merrill, State v. Ramirez that the court has cited, all hold that The court should bind the defendant over for trial unless the evidence is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecution's claim. I don't know that any of this analysis goes to whether or not the expert's testimony and her report is wholly lacking and incapable of reasonable inference to prove
I agree.
her result in this case. We're far beyond this. We're hours into this examination. This feels like a 702 hearing to me. I think we're far beyond a probable cause hearing, Your Honor. I would ask the court to sustain the objection, not allow questioning on this or any other matter that does not deal with the issue of probable cause.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, the state offered this report on a very technical, complex, scientific area of inquiry. And they offered to the court a conclusion in that report that Mr. Robinson and Mr. Twiggs were contributors to 2 samples that were found at the crime scene. They obviously think that's relevant to the probable cause inquiry, or they wouldn't have offered the report in the first place. So having done that, I think the defense is entitled to inquire whether those conclusions are reliable, because that, again, is the court's ultimate determination here, reliability of this evidence. And the court can decide it's not relevant, it's not reliable, therefore I'm not going to rely on that in determining probable cause. And that, or the court could say it is reliable and it bolsters up other evidence that the court is going to hear from. So the particular report in front of us goes directly to the issue of whether the expert correctly concluded that Twiggs not was a possible contributor, but was a contributor. And the state's theory here apparently is that both Mr. Robinson and Mr. Twiggs are somehow connected to this crime scene. So I think when the court sees what the numbers were generated and how that compares to her own standards for assessment, the court will see that the conclusion is not justified that she reached.
Well, I understand what both parties are saying, and at a probable cause hearing, the issue is whether we walk 1 mile or 100 miles down the path. And so I want to keep it limited to 1 mile and as opposed to 100 miles, because that would exceed the probable cause standard for a preliminary hearing for what is before me. And so, Mr. Burt, as it relates to the objection, I'm going to sustain it in part. If you want to briefly address this and move on, you certainly may choose to do so. But as it relates to where we're at, my hope is we can keep this very brief as opposed to going through all this, so we can move on to whatever else you would like to present.
Yes, we agree with that.
We'll do that, Your Honor. And in the interest of doing that, could you bring up on the same screen part of her report, People's Exhibit 31?
And let's take that off.
I'm going to need that up there because I need to do it.
So is it part of the same? Because it was on that screen. I want to make sure that what you're calling up on the screen right now, is it part of this that was already admitted or something else?
It's part of this, which has already been admitted, compared to Plaintiff's Exhibit 31, which has also been admitted.
Okay,
So
thank
they're
you. I
both-
just wanted to clarify.
Sure.
All right. So do you want that published on this? all
Yes.
Screens? All right, let's go ahead and do so.
And the chart I would like you to bring up from that report is on page 5. Yeah, and just highlight that. Thank you. So what we've blown up there is from your report, Plaintiff's 31, and you provided this chart in the report, correct?
That is correct, yes.
Explain to the court how this works, what this chart is supposed to represent.
Sure. So this is our verbal scale. In addition to the numerical likelihood ratio value that I provide, I also give a qualitative or a verbal equivalent to that numerical value. That gives some kind of context to what that likelihood ratio means.
Okay. And on the left, explain what the greater than 1 million, less than 1 in 100 means. What does that scale relate to?
Sure. So that scale is the numerical value of the likelihood ratio. So if I have a likelihood ratio that's greater than or equal to 1 million, I designate that as very strong support for inclusion. The next example, 10,000 to less than 1 million, I would say that's very strong support for inclusion, and so forth.
So you need to reach a likelihood ratio of 2 in order to get even limited support for an inclusion, correct?
Correct, yes.
Okay. If you could not reduce that. And go to page 2 of the report on the left. So from this chart, when you ran Mr. Twiggs against the sample, what was the likelihood ratio that you determined?
I believe this chart is not the comparison to Mr. Twiggs.
That's not in the report?
The chart at the bottom of the screen is not my comparison to Mr. Twiggs.
Let's verify that if we could. Take that down, the highlight. And repost 38, page 45. I'm sorry. Page 39, that isn't in evidence. There we go. Second page. Is this the likelihood ratio from your Twiggs comparison?
Yes, it is.
Okay. Now, what was the likelihood ratio that you calculated based on this chart?
The likelihood ratio was 1.
1.
Yes.
So that doesn't rise to the level of even limited inclusion, correct?
Correct. It would fall under an uninformative.
Uninformative, and yet you concluded that despite this STR mix reading with a likelihood ratio of 1, that Mr. Twiggs was a contributor to both item 7 and item 8, correct?
I did. So actually, I didn't utilize this calculation to determine that Mr. Twiggs was a possible contributor, or that I could use him as an assumed contributor. I visually looked at the DNA sample, and the DNA, unlike that major contributor, he also had those peaks. So that was one proposition or one hypothesis that I determined that he was an assumed contributor. There are multiple different ways. We don't have a threshold. I don't have to see 2, 4, 8 peaks to determine I think an individual is present. Given that the field submitted him as an elimination, I assumed he was a contributor. When I compared him to that data, I did see his DNA present. So when I calculated the statistic for Mr. Robinson, I used Mr. Twiggs as an elimination.
Let me see if I understand that. The STR mix that you relied upon to include Mr. you relied on the STR mix to include Mr. Robinson as a possible contributor, correct?
Correct, yes.
But when you ran Mr. Twiggs's sample through STR mix, the result you got was that he was not a contributor, correct? Or that it was of not even of limited value in including him.
Based on the STAR mix run, it was uninformative, but I did use my own knowledge and training to determine that I was going to utilize him as an assumed contributor.
Okay. Your own knowledge and training. Is there some standard that you use for deciding when not to rely on the star mix results and when to sort of disregard it and rely on your training and experience?
I can't say that I disregarded it. When I'm comparing someone, that's my first determination. Do I think this person is potentially included or excluded? If I determine that I think they're included, I will run star mix to give weight to that inclusion. Elimination samples are different. If I'm told that an individual is submitted as an elimination sample, I can assume they're there. Visually, I'm able to look at the DNA evidence and determine, yes, I think there's enough evidence there to assume that individual, which is what I did here.
Okay. At D16, Mr. Twiggs was a 912, right? According to your electropherograms.
That is correct, yes. Mr. Twiggs was a 912 at D16.
912. And did you find 912 at that location in the 8-1 sample?
I'm sorry, the sample 8 or sample 7?
Sample 8.
The only piece of information I had for sample 8 at item D16 was a 12.
And you said Twiggs at that was a 912, right?
Correct, yes.
But at that location, the evidence sample was not a 912, but a 12.
That was the only piece of information that was recovered at that location.
Let me ask you about your interpretation rules for excluding someone. Is this an accurate statement? This is from Butler's textbook. In forensic DNA analysis, if any STR locus fails to match when comparing the genotypes between 2 or more samples, then the comparison of profiles between the question and the reference sample is usually declared a non-match, regardless of how many other loci match.
I would agree with that if it's a single source sample. So single source, again, meaning from one individual. If I have a DNA profile from evidence and I compare it to a known individual, if there's a difference at even one location, I can say it's an exclusion. If I have a mixture, it's not that cut and dry. I have to take into account how many people are in that mixture, how many pieces of information I have, is there potential dropout? So it's just because someone may not be present in a mixture doesn't necessarily mean that I'm going to automatically exclude them.
I see. At D19S, what was Mr. Twiggs's type?
It was a 1416.
Did you find a 16 allele in the 8A sample?
No, I did not.
Okay. At Tho, what was Mr. Twiggs's type?
He was a 7.9.3.
Did you find a 7 allele in the 8-1 sample?
No, I did not. But again, this is a mixture and there is some dropout. So just because I didn't see a 7, for example, does not mean I would automatically exclude someone.
It's a mixture, so there was some dropout. So did you assume that at that location that the allele that dropped out matched his allele?
At that location, no, there's only one individual represented there. So when comparing an elimination, I would essentially ignore that location. I'm looking at the other locations where there was 2 individuals present.
Okay. Now, a couple more topics and then we're done. When you received this, the evidence, you got more than 7 and 8, correct? You got a number of other samples.
Correct, I did.
You got a backpack, which you labeled as Exhibit 9, and a bunch of items from that backpack. correct?
Correct, yes.
You were initially told that those items related to things that may have been discarded by the suspect.
So initially, we didn't have any information. So we processed that. Those are items that are good for DNA. Not having any information from the investigators, we process them for DNA. As the investigation continues, it was determined that that backpack was potentially left behind by a bystander, and there was no comparisons needed at that time.
Well, left behind by a bystander, or according to your notes at page 20, the backpack belongs to Kirk's detailees.
Yes, based on the individual that was not my communication log. That was someone else within the laboratory. That was the information that they received.
Before you received any samples, did you request to perform what's called destructive testing on the samples?
Yes, I did. And destructive testing is essentially consuming the sample, cutting the cotton off of the Q-tip or the swab, subjecting it to testing. There's nothing remaining. I have to request permission to consume prior to doing so, and I did in this case.
And why did you do that?
That is part of our protocols, that we have to request permission to consume, and we consume. So DNA, we can't see it. So when an item is swabbed, we don't know how much DNA is on that swab, if anything, or how that swab was used. Did someone just swab using one side of it? Did they roll it and use all sides? Because I don't know that, it's our practice to consume that swab. It's our best chance of getting any DNA evidence.
And that's a determination that you made in this case before you even saw any of the evidence, correct?
Determination to consume?
Yeah.
Yes.
Okay. Now, remember I referred to that NRC report?
Yes.
1996. Did they say there a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated? Such an opportunity should be provided whenever possible.
Yes, that does say that.
And does your laboratory have a policy, standard 7.4, which says, where possible, the laboratory shall retain or return a portion of the evidence sample or extract?
That is correct. And we do actually return the remaining extract, the liquid from our DNA testing. So we did consume the swab. However, there was a small amount of liquid that was left and returned.
On some of the items, right?
I believe on all of the items.
We'll get to that in a minute. And that policy that I read is from your lab policy, right? The
Yes.
FBI's lab policy.
Yes, it is.
And then is there also a similar policy from the quality assurance standards, the FBI quality assurance standards, which says the laboratory must have a policy on sample consumption. The policy is expected to provide instruction for if and when the laboratory may or may not consume a sample, and any documentation that the laboratory requires.
That is correct, yes.
Okay. Now, your report indicates that certain samples were destroyed, consumed, correct?
That is correct, yes.
And which samples were consumed?
Items 1 through 6, which were swabs from possible smudge, swabs of hand swipe, swabs from possible sweat drop, swabs from possible smudge, swabs of possible smudge, and swabs from possible sweat drop. In addition to items 54 and 55, which were swabs of swiped finger areas and swabs of stairwell railing.
Okay, so when you wrote in your report that those items were consumed, which of those items, and by that you mean the actual swab was consumed?
Correct. So a swab is just like a Q-tip. So the cotton portion of that swab was cut off the wooden stick, placed into a tube, subjected to DNA testing. So we consider that consuming. But again, there is liquid at the end of the process that is returned to the field.
And the normal procedure in terms of sample preservation would be something called sample splitting, right? You split the swab and you use half, you save half so that your testing results can be replicated and retested.
So yes, however, again, I don't know how an item is swabbed. So even if I were to cut that swab in half, it could be that I'm testing the half that doesn't have any DNA and the other half may have some DNA, or the swab may have a little bit of DNA on one side and a lot on the other side. So for the best possible chance of getting a DNA profile, it is our practice to consume the entire swab.
So for the first 6 items, those were swabs that were taken from the Northeast.
Yo, Vanessa, you are in my mind. I was literally just thinking, like, why is he dragging this out so far? Like, good gracious, man, stop. You are in my mind. I think you're right on the money, though. All right. This is so
For me
boring.
to compare to.
Okay, and what did you have left after you did that in terms of the volume of extract? What was left?
So it was approximately 3 microliters. So a very small portion.
Very small portion, and you actually used 10 microliters to do your testing of those samples, right?
That is correct, yes.
So if you didn't get any results with 10, what you left over would not be sufficient to get any sort of independent testing done, correct?
It could be tested. However, my expectation, if I took 10 microliters and did not get any DNA, the remaining 3 would also still not give me any DNA.
Okay. And for item 55, that was 2 swabs of a stairwell, from a stairwell railing where the suspect touched the railing, right?
As far as I know, they were swabs from a stairwell.
And correct me if I'm wrong, but I understand from your lab notes that you took those 2 swabs and combined them into one sample and then used the whole sample, right?
That is correct, yes.
Okay. Before you did that, did you inquire whether the 2 swabs came from 2 different areas? For instance, maybe the suspect touched it here, but the other sample was taken somewhere else?
I did not. They were both labeled as coming from the same stairwell and they were packaged together. So our policies and procedures is that we can combine those 2 together.
And when you do that, you create a mixture, right?
I don't know that I would agree that combining the 2 would create a mixture. Given the item of evidence, a stairwell railing, I don't necessarily expect that one swab would have one person, the second swab would have a different second person, and combining the 2 of them creates a mixture. However, I don't know that for certain, but again, I don't know is DNA present, so our procedure is to combine and consume those swabs.
And in this case, when you did that, what you got was a complex mixture, right?
I did. I got DNA from more than 5 individuals, so I could not provide a conclusion.
All right. Now,
Mr. Burt, and we are at the 4:30 point. I just want to inquire, not applying
have
pressure.
He
One
said,
strand.
sir, we got to get this going.
be done with it. We talked earlier about your
Woo, come on.
testing of the length of the DNA sequence, the length of the DNA boxcars, not the sequence of A, C, T, and G within those sequences, within those boxcars, right?
Correct, yes.
And is it true that there are different alleles that have the same length when you measure by STRs, but have different sequences?
Yes, that is possible.
And I'd like to show you a chart that you have reviewed, I believe. This is, could you bring up 34? This is not in front of the on the public screen, just for the witness. And is this a chart that you reviewed that I prepared and you looked at to see if I had correctly stated what alleles were found?
Yes, it is.
And does it, as it's presently existing, accurately state what the alleles are at each
Yeah.
location?
Yes.
Okay. I would move that into evidence. It's 5 pages and it's Baker 34.
Mr. McBride.
Yes, I object. Unless this exhibit is reasonably likely to defeat the prima facie showing of probable cause, this is irrelevant to the preliminary hearing.
Mr. Burt.
Your Honor, this exhibit and the next one go directly to whether the comparisons being made between Mr. Robinson's sample and the evidence samples are usable and reliable to make a determination that he is a probable contributor.
I'm not sure I'm following with what you're saying on there, right? And maybe it's just because it's late in the day. Could you
Yeah, it could
repeat
be.
that?
So this chart illustrates what allele she found at each location for Mr. Twiggs and Mr. Robinson, and for the evidence samples, the 7.1a and 8.1a. The other alleles are on here as well, but we're going to focus on 7.1 and 8.1. And for instance, Your Honor, at the, you'll see that under the first reading there is for Tyler Robinson at the D3 location. He is a 17. Okay. And take that down. And then if you go down to the 7.1 towel sample, which is what the topic is of this report introduced by the state, you'll see that she found a 17 there as well, measured only by the length of the DNA strand. And what she's going to testify to is at this location and 5 or 6 others, there are alleles, all of which measure here 17, but actually contain different sequences. And that her testing that she used does not measure for those differences.
And so as it relates to probable cause, that's what I want to keep coming back
Sure.
to. Again, if this was a trial, this may be a little bit different analysis that the trial judge applies. But as a magistrate, taking a look at this and looking at the probable cause standard, how does this comport?
So it comports because it goes to the
Oh, no.
ultimate opinion expressed in the report that the state is offering, that the report offers reliable support that Mr. Robinson is a possible contributor. And we're asking the court to consider that the comparisons are only based on a limited number of length-based comparisons, and that there are sequence differences so that she cannot distinguish.
Wow.
And I believe she'll testify, she cannot distinguish based on the testing that she did in at least 5 separate locations, whether the evidence sample and Mr. Robinson's sample, or for that matter, Mr. Twiggs' sample, matches the sequence differences here. And this is my final area, and I think I can do it very efficiently. And I think
No,
it
you
is
can't.
important
We
for
don't
the
believe
court
you.
to consider, especially as it relates to the comparison to Mr. Robinson.
Mr. McBride.
We don't believe you anymore.
And she is also going to testify that the analysis she does is based on looking at the totality and all of the different markers that match and are consistent. And that's how she comes to the opinion that she does. The point is, there are explanations that are susceptible to different interpretations and arguments. Ultimately, we're going to have an expert hearing where all of the literature is going to be before the court, and the court's going to determine if it meets a threshold of reliability for admission at trial. But at this stage, even granting that there may be some argument that may come from defense counsel's position, the court can't weigh it. This does not go to the probable cause determination. And I don't think it's relevant. And this exhibit in particular is not relevant without the testimony of the witness. And so the exhibit should not be admitted on its face either.
That's why I was trying to lay a foundation that she would, and offered a proof to the court that she would testify that in fact there are these sequence differences at the 5 or 6 locations, 6 different locations relevant to the comparison to Mr. Robinson. And when
This is
the
going to
state
be
says
a
the court
long
cannot weigh
trial.
it, the court can weigh reliability. The court has ruled that. So we're simply asking the court to take into account the limited nature of these comparisons and the fact that she cannot, based on the testing that she performed, tell the court whether there are differences between at these 5 locations. She can't match Mr. Robinson to the question samples because she didn't do sequence testing. And she'll also testify that the FBI is in the process of implementing this kind of testing.
All right. Thank you
Whew,
to both
gosh.
sides. I'm going to allow the admission of this evidence, but I'm also going to set a limit of a limited number of questions. We are now at 4:40.
I like it.
This is on the cusp of whether it is applicable to the probable cause standard. I want to afford defense its full opportunity, but I still have to rein it in to keeping it to probable cause and not going into a full exploration, because that's not the purpose of a preliminary hearing. So I will admit Baker 34, but Mr. Burt, I'm going to limit you to how much time do you need to address
I just
this?
need about 4 or 5 minutes. I'm going to, the
Boy,
next
no, you don't.
chart will be
No, you
the
don't.
chart with the what are
lies
called
you
iso
tell.
alleles displayed for the court so the court can see what we're talking about, and that's it.
All right.
I'm just going
We'll-
to have her document that in fact I've accurately stated what the alleles are that have sequence differences.
All right. So it is Mr. McBride.
Just on a second matter, which is I need to cross-examine this witness. She's got to leave town today. I would like 20 minutes to cross-examine the witness.
Oh,
Well, and we'll go with the I accept Mr. Burt's representations, the amount of time, and I'm going to talk less because that's consuming more time, and also allow the state the appropriate time for cross-examination given the nature of this witness having to travel. So, Mr. Burt, I'll turn to you. This has been moved into evidence. Do you want it on the screens?
No.
Actually, I don't need it on the screen, just in the interest of efficiency. Pull up the next one, please.
Okay.
Dude, like a Baptist preacher talking about, I got one more point.
35.
I'm almost done, y'all.
Take that one down.
I'm almost done.
And is this exhibit
I
the
got one more
same
point.
chart with what are called the isoalleles indicated?
Yes, it is.
And isoalleles is a term used to refer to these alleles that have different sequence but the same length.
Correct, yes.
So across the top there for allele 17 and D3, there is a allele 17A, allele 17B, allele 17C, all with the same length, but different sequences for each of those 3.
Correct, yes.
And similarly at VWA, where you say that the Mr. Robinson is an 1819 and 1819 in the evidence sample, there's an 18A, a 18B, a 19A, and a 19B.
Correct, yes.
And similarly for the other areas I've indicated there, I've accurately stated what the different sequence alleles are, correct?
Yes.
So I moved this exhibit into evidence, Your Honor, and for publication.
Is this Baker 34?
Yes. 35. Baker 35.
Same objection, Your Honor.
All right, I'll admit it into evidence under the previous statement as it relates to Baker 34. It may be published.
And as you look at these 5 areas, you can't distinguish the evidence samples from Mr. Robinson based on the sequence differences, can you?
Correct. I only utilize length differences, STRs in this case. The FBI laboratory does not use sequencing for nuclear DNA testing, nor am I qualified in it.
Right. What is NGS?
NGS stands for Next Generation Sequencing.
And your laboratory is involved in validating next generation sequencing, correct?
We utilize next generation sequencing for mitochondrial DNA, which is a different subset of DNA testing, but not for nuclear DNA testing, which is what we're talking about today.
Right. But the people who market STR Mix also market a sequence platform, do they not?
I'm not aware if they do or do not.
Last question, take a look at. There we go. Well, I'll save that for redirect. Thank you.
Thank you.
All right, turning to the state, Mr. McBride.
Oops. Good afternoon.
Good afternoon.
All right, let's see how he does. Let's see how he goes. Let's time him.
I want to start by asking you what your training and experience is. First of all, do you have any education?
Yes, I do. I have a Bachelor's of Science in Biology from Salisbury University.
And do you, after your bachelor's in biology degree, what did you do for your career and in further education?
Upon graduating from college, I began working at the FBI laboratory as a contractor. I was assigned to the Federal Convicted Offender Program, which was a program under the DNA unit. During that time, I did that for approximately 1.5 years. It was my responsibility to open and inventory and barcode DNA collection kits sent in from federal agencies across the United States. I then became a biologist in the DNA casework unit. I did that for approximately 6 years. During that time, I did the actual testing of items of evidence, so swabbing, cutting those swabs, producing the DNA profile. And then in 2015, I accepted a position as a forensic examiner, which I am still today.
I'm sorry, what year was that?
2015.
So 11 years, you've been doing more or less the same duties you have now, is that right?
Correct, yes.
I want to ask you about your lab's accreditation. What is accreditation for a laboratory?
Accreditation is a formal recognition that our laboratory is following a very strict set of standards. We're accredited by ANAB, the American National Standards Institute National Accreditation Board. And our accreditation shows that we have to follow standards such as I have to have a certain education background, how we process evidence, how we store evidence. Every 4 years, we're audited to those standards, meaning an outside body will come into our laboratory, look at my training records, look at our standard operating procedures to ensure that we're following those standards.
And you mentioned your training. So what do you have to do as an examiner there, as a scientist there, for your lab to maintain its accreditation?
So for my training program, I had to complete a 2-year training program. During that time, I learned the science behind DNA testing, and I showed that I understood that science by completing oral board examinations and written examinations. I also then had to show that I could relay results, that those scientific results, to a jury by completing moot court exercises. And before becoming qualified, I then took something called a competency exam, or it's like a final examination to show that I'm qualified to perform my duties. During that accreditation or that audit process, my training records were reviewed to make sure that I had the proper coursework, the proper college degree, as well as completing successfully that training program.
And do you have to keep up with ongoing education to maintain your, do you have a certification?
I'm not certified. I'm qualified as an examiner.
To maintain your qualification, do you have to have ongoing education?
Yes, on a yearly basis, I have to complete at least 8 hours of continuing education, and this can be done by attending conferences or lectures or reading scientific literature.
Do you also have to undergo proficiency testing?
Yes, and a proficiency test is a test that we receive from an outside vendor. I process that test like I would any other case and submit that those answers to determine if I'm satisfactory or unsatisfactory. This tests not only me to see if I'm still proficient in my qualifications, but it also tests the laboratory process to ensure that we're getting accurate and reliable results.
Now, as you discussed your work in this case, you talked about your work needing to be reviewed by another analyst.
Correct, yes.
And is that true in every single case?
Yes, in every one of our cases, they have to undergo a technical review in addition to an administrative review.
And it sounds like during those technical reviews and administrative reviews, there's discussions between you and other analysts. Is that accurate?
Yes.
And is that an opportunity for training and learning as well?
Yes, absolutely.
And I assume that training and learning goes both directions, that you're learning and you're also helping others understand your thought process, which may train them as well. Is that accurate?
That's true, yes.
The tools you use, are the tools you use validated?
Yes, they are.
And what does that mean to have a tool that you use validated?
So a validation is a thorough testing of a process or procedure. So before we subject any evidence to testing, we ensure that those process and procedures will work within our laboratory. Based on the validation, we create something called standard operating procedures, or SOPs. And these are kind of like cookbooks. It gives us step-by-step instructions on how to do our process and procedures. And then both myself as an examiner, as well as the biologists, were all trained to those standard operating procedures and tested to those standard operating procedures during proficiency tests.
Now, you've talked about, I think, a couple of the tools you use. One you call StarMix, is that right?
Correct, yes.
And is that tool validated?
Yes, it's validated both developmentally and internally. Developmentally it's validated by the creators of the software. And then we, the FBI laboratory, also tested StarMix to ensure that we could use it within our laboratory and produce accurate and reliable results.
Now, when you say it was developmentally validated, is that in a peer-reviewed study?
Yes, it is.
And is StarMix used, how widely is StarMix used throughout the world?
StarMix is used in approximately 120 laboratories, both domestically and internationally.
I want to go back to some of the questions that you were asked on direct examination. You were asked about an Exhibit 8.4, Baker 8.4, which is the DOJ Ultra, which is the Uniform Language, what does that stand for?
Uniform language for reporting and testimony, I believe.
Okay. It talks about language that you should use and language that you shouldn't use as an examiner and a scientist, correct?
That is correct, yes.
Now, I want to ask you a little bit about what you do when you have a conclusion, like you did in Exhibit 31. Do you know? Let's see.
the directive from the Department of Justice limits the adjectives you can use to describe the evidence and the conclusions that you reach. Is that accurate?
Yes, it is.
And the thinking behind that is to submit the statistical number and let others decide, meaning the reader decide how they want to describe that number. Is that accurate?
Yes, it is.
So for example, if we can look at Exhibit 31, if you don't mind publishing that. Yes, and that's been admitted. So if we can put it on the screen. And Kimberly, if you could scroll to page 3 when that comes up. Thank you. So item 7 sub 1 is the swabbing from the towel from the rifle. We have the number in written form in the second paragraph beneath the heading. And then beneath that, you have a table, correct?
That is correct, yes.
And the likelihood ratio gives the number, right? That's the likelihood ratio. And that's stated in sentence form in the paragraph preceding the table, correct?
Correct, yes.
The only language you can use to describe what that number means from the DOJ directive is very strong support for inclusion, correct?
Correct, yes.
And the sentence there that says the DNA results from item 7.1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The reader can assign whatever value they want to that, correct?
What do you mean?
Meaning adjective to describe what that means.
Sure, yes.
The adjective you can use is very strong support.
For inclusion, yes.
Okay, for inclusion. All right, if we go to 8.1, if you'll, Kimberly, if you can scroll down just to make that a little bit easier to view. Same question there. The results are from 8.1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The adjective you're allowed to use is very strong support for inclusion again, correct?
Yes.
Okay, we can take that exhibit down. Thank you. You were asked about formal activity level, and you described this as the lab cannot testify about, or you cannot testify about what action left the DNA on the object. Is that right?
That is correct, yes.
Does that mean that an individual did or did not touch? Well, let me ask you this. How can DNA get onto an object?
DNA can get on an object via direct contact, so an individual touching an object. It can also end up on an item via body fluids, such as blood, or through transfer. So if I were to touch an object and then that object is given to someone else, my DNA could potentially be on that other individual through the transfer of DNA.
And your lab can't, or you cannot testify as to what precise action left the DNA on the object, correct?
Correct, I cannot.
Okay. Same question about time. You can't testify about the exact time that DNA was left on an object, right?
Correct.
But there are some indicators that may give some information about how long and the conditions under which DNA was placed on an item, like degradation.
Yes, degradation or the condition of the item. So again, if a firearm, for example, is in a river, I would expect with the water rushing over that item, I may or may not be able to detect DNA. Also, if there's an item of evidence that is exposed to the elements, something that's been left behind 10 years ago, I don't necessarily expect to recover DNA, but something that may have been left yesterday, I might be able to detect DNA.
An item that has been left in the dirt or has been rubbed in the dirt, could that affect your ability to recover DNA?
It could, yes.
Could it also affect degradation?
Yes.
Can UV rays affect degradation?
Yes, it can.
Does degradation keep you from doing your work?
No, it does not.
Is degradation normal?
Yes, it is.
Does all DNA degrade?
It does, yes.
I imagine if it's kept in a pristine environment, it would degrade less than if it's kept in, or if it's found in a less or out in the open. Is that accurate?
Yes.
Okay. You said with regard to the screwdriver, there was some degradation. Did that affect your ability to reach conclusions in this case?
No, it did not.
You said on item 7, the towel or the swab from the towel, there was slight degradation, not as much as exhibit 8. Is that accurate?
Yes.
Did that degradation affect your ability to reach a conclusion here?
No, it did not.
You're asked about the PCAST report. You testified that that gave guidance on different areas of forensic science. Do you know what year that report was published?
I don't recall the year.
Do you know if it's been within the last 5 years?
No, it is not.
Meaning it's older than that?
Yes.
Do you know if it's been the last 10 years?
I think it was 2016, but I'm not entirely sure. I would say within the last 10 years.
Let me ask you this. Has the science in your area, can I refer to it as probabilistic genotyping?
Probabilistic genotyping is the math in my area. Yes.
The science in your area and in your field, has it developed over the last 10 years?
Yes, it has.
And have there been studies that have made suggestions which have been implemented in the field?
Yes.
You testified about exhibits 7 and 8, that they both had mixtures. Excuse me. Yes, items 7 and 8. In your testing of these items, that they both had mixtures. And you stated, I want to make sure I understood this. You stated, I believe, that the minor contributor was less than 20%, and that it was actually 5%. And the ratio was 5% to 95%.
For one of the samples, yes.
Do you remember that?
Yes.
Does that mean the 5% was from twigs and the 95%, that 95% is assumed from the defendant, the Robinson?
When I calculated the statistic, Twiggs's DNA profile aligned with the 5% contributor, and Mr. Robinson's DNA profile aligned better with the 95% contributor.
Okay. Same question with regard to 8. I think you said the ratio was 11% from the minor and 89% from the major. Is that Twiggs being the 11% and Robinson being the 89%?
Yes, Twiggs better aligned with that 11% contributor, and Mr. Robinson better aligned with that 79% contributor.
You're asked about Baker 4, an exhibit that was titled Baker 4 365. Do you remember this exhibit by chance? I don't have a copy of it, so, well, do you have Baker 4 365? Put that up. And item 7 is the towel, right?
Yes,
Item 8 is the screwdriver.
correct, yes.
Thank you. You know, it's 5 o'clock. I'm going to wrap up. We can go ahead and take that down. I'm sorry.
Praise the Lord. Praise him. Whoa, goodness
In
gracious.
reaching your conclusions, did you follow the protocols of your accredited lab?
Yes, I did.
And based on your training and experience and following those protocols, did you in fact come to the conclusions described in Exhibit 31?
Yes, I did.
Thank you.
Right, Mr. Burt? And how much time are you anticipating?
He said, how much time you need, man?
You referred on cross-examination to your training and experience, right?
Yes.
Do you agree with this statement in the PCAST report? Experience or judgment cannot be used to establish the scientific validity and reliability of a metrological method, such as a forensic feature comparison method. Moreover, a forensic examiner's experience from extensive
still doing this.
casework is not informative because the right answers are not typically known in casework, and thus examiners cannot accurately know how often they erroneously declare matches and cannot readily hone their accuracy by learning from their mistakes in the course of casework. Do you agree with that statement?
I don't.
Okay.
I think experience, they're right in the fact that we never know the true answer. However, my experience means that I've seen a lot of different DNA. I've seen a lot of validation data. So that does help me come to a conclusion.
Do you agree with this statement by that same report? Good professional practices, such as the existence of professional societies, certification programs, accreditation programs, peer-reviewed articles, standardized protocols, proficiency testing, and the code of ethics cannot substitute for actual evidence of scientific validity and reliability.
I don't think I agree with that either. The science has been heavily validated and tested to show that's reliable. Following protocols that are based on validation, again, shows that my results are accurate and reliable, as well as being proficiency tested.
By the way, you said that that report was not authored by experts, but the head of that group was Eric Lander, who is one of the foremost experts in the area of forensic biology, is he not?
That name does not ring a bell. I don't know who that individual is.
You don't know who Eric Lander is?
No, I do not.
Okay. When did you go to school? What years?
2003 to 2007.
You said that STR mix was widely used and then it's been validated. The PCAST report said the problem is it's been validated by the people selling the product, right?
Developmental validation, yes. Internal validation, no. A laboratory that's going to utilize StarMix has to validate within their own laboratory.
And the PCAST report said that we need validation data, not by the people selling the product, but by independent scientists in order to make this reliable, right?
They do, and that's exactly what happened. There was 31 laboratories that came together in response to the PCAST report and gave their validation data on how they internally validated StarMix.
And then after that information came forward, the PCAST committee reviewed it and they said PCAST was unpersuaded by those studies. While likelihood ratios are a mathematically sound concept, their application requires making a set of assumptions about DNA profiles that require empirical testing. Errors in the assumptions can lead to errors in the results. To establish validity with a range of parameters, it is thus important to undertake empirical testing with a variety of samples in the relevant range. And they specifically address the studies you're referring to, did they not?
I believe they did, yes.
Yeah. And then lastly, you said that STR mix is widely used, but as I understand your testimony, you didn't use it and rely upon it for your conclusion about twigs, right? The software told you there was no support there for including them, and you ignored it and decided otherwise, correct?
I did not ignore it. Again, given the type of sample, it was an elimination sample. I compared that individual to the DNA profile that I developed and determined that I could conclude that I could utilize him as an elimination sample.
You said your laboratory was accredited, correct?
Yes.
But you're aware that in 2004, the Inspector General did a comprehensive audit of your laboratory and published a report called the FBI DNA Laboratory Report, a review of protocol and practice vulnerabilities, which found a number of errors in the way that your lab does testing, correct?
Objection. The 2004 study is hardly relevant to this proceeding 22 years later.
It's relevant because he's relying on accreditation to somehow say that these results are valid.
No,
This
because she
lab
was still in
accredited when
college.
this study was done.
I'll allow this single question. She may respond. So I'm overruling the objection, and then we'll continue to move forward.
You're aware of that study, right?
No, I'm not.
Okay, thank you. That's all I have.
All right. Anything further for this?
She was still in college, though.
Yes, I think there's one follow-up needs to be asked. You were asked that, or you testified that you never know the true answer with field work, correct?
Correct, yes.
And that's compared to ground truth studies where you do know the true answer and you can compare the conclusions that analysts draw with the true answer, the ground truth answer that is the basis of the study. Is that right?
Yes, and that is what our validation is.
Your validation actually studies is a ground truth test in essence.
Yes.
Okay, thank you.
Anything further for this witness?
I thought he was going to ask some more questions about that.
Thank you.
May this witness be excused.
Yes.
Thank you. Ms. Cooper. You may step down.
Thank you.
All right. Well, does either party need the benefit of the record before we go into
I need the benefit of the record.
No, Judge.
All right. Having both parties said no, we'll go ahead and be adjourned until tomorrow at 1 p.m. We do not have morning court for this proceeding, and we'll start up at 1 p.m. in the afternoon.
Really?
Court is in recess.
Why do they not have morning court tomorrow? Break that down to me. Break it down. Ooh. This trial is going to be painful, y'all. Y'all, this trial is going to be painful because I'm sure he is going to dig and dig and dig on this evidence, this data, how they did the testing, so on and so forth. It's going to be a mess. Yeah, that's 3 p.m. EST. All right, tomorrow I have Johnny Walker Dredd coming on. We're going to talk about the Carmelo Anthony trial and the people that still follow after Carmelo Anthony. But my goodness, the judge needs a break. The judge said, look, man, I'm going to stay up late tonight. Look, y'all get up early if you want to. Tomorrow at 8:00 p.m., we got Johnny Walker Dredd coming on. Great content creator. We're going to be looking at the Carmelo Anthony trial. We're going to look at 12 lies or myths, fan fictions told by the Carmelo Anthony crowd. I think she held it together quite well. I thought she was an excellent. They've had some really good. The judge needs a drink. Judge drank. I thought she did a great job, man. Especially in the challenging, really challenging her professionalism, really challenging her ability to do her job. We all need one. He said he has a medical appointment. He probably does. Hey, look, man, I can imagine how stressful that job is. Just being there all day for that. I can imagine. Let me close this out. Y'all, thank you so much, everybody who tapped in with us today. Okay, so I want y'all to go check out Andrea. Andrea's going to be doing, I think she's doing a show at 5. Don't quote me. At 8:00. Don't quote me on that. But I know she's going to be doing a show about this. So go over there and check her out tonight. I need to go outside and get some air my own self. Today, it went better than I thought. Let's be honest. It still was painful, but to God be the glory. Great things he has done. Tomorrow we'll be back, I guess, at 3:00 Eastern Standard Time. I got a whole bunch of stuff I can get done tomorrow. Ooh, I'm gonna be out in these streets. I'm gonna get a whole bunch of stuff done. I'm gonna do kettlebells at the park tomorrow. Shout out to y'all. Thank you so much. And Judge Chris knows better. I can imagine it probably not the best thing for him, I'm sure. Look, I'm gonna take some strong water tonight. That's it for sure, y'all. That's crazy. But I want to say thank you again. Thank you so much for liking the videos. Thank you to everybody who supported with the supers, as well as for blessing folk with memberships. Again, shout out to Mike earlier today. Mike was a stream sponsor. I appreciate him for that. Blessing 10 people with memberships. Where is it? Right here. I don't know, man. Where is it? I don't see it. I don't see it. Oh, here it is right here. Haha. So yeah, shout out to Mike Klikovich for being a stream sponsor. Thank you to everybody who hit the like button today. I really appreciate y'all. Thank you so much. It's been a lot of fun. We'll do this again tomorrow, 3 o'clock Eastern Standard Time. So I actually need to go change the setting for that because I set it up for it. I thought it was regular time. So I'll change that, but it is 3 o'clock Eastern Standard Time, which is 1 o'clock their time. I wonder why they're doing that. So anyway, thank y'all again. I really appreciate it. Do me a favor, please tip your waiter on the way out the door. Get that fire water. Tip your waiter on the way out the door. Please make sure you hit the like button, all that kind of great stuff. Enjoy your family. Enjoy the rest of your night. Have a fantastic night, good people. I'm going to see you all, Lord willing, tomorrow. Grace and peace. Take care. Thank you so much for tuning in to another episode of the Jay Witt Podcast. If you enjoyed today's show, please do me a favor and hit me up with that 3-piece special. Like the video, subscribe, and of course, share it with somebody who would also enjoy this type of content. And make sure you leave a comment because I do pin the best comments to the top. So thank you so much for tuning in today. And until next time, everybody, grace and peace.